Yes. I'm still listening. Not told you. Give all the best.
Malad, next week, Malad, I have filed several memos. It is not listed.
Okay.
Change is not some night of Malad. I am unable to enjoy the property. Next week, any date now, they will apply.
What do you think?
And the award of final disposal of the one time. We have finally giving pay to more than that. In Monday.
Told.
Monday.
Maybe she is asking for the reservation.
Yes, reservation.
So clarify Madi the position. Nodi. We'll dispose it.
Immediately.
Ultimately, you have to make some effort. Constructive submission Madi. Nodi again Marti. Same waterly 3 reservation one day of candidate agide. Ad nodi ಸ್ವಲ್ಪ. First. ಕೊಡಿ ಕೊಡಿ
Land review not
complied. What interim order BBM has got?
They have given some amount for land review. They have not complied.
Totally, let's see what. No difference.
And before this one, the direction for them to remove not into illegal. They remove only one portion of the 6th block. The other one,
Who are you? Correct. Where are you staying? Where are you residing? Are you next to the building?
Yes, sir.
You want the other floor also fall like this?
So what they done is the 14 block, they considered 6 blocks.
Totally. Totally. Good. Please. Totally. Take that memo.
Yeah. May I make a mention, Lords?
46 to 48.
46 to 48.
49 to 55. Page 10.
Serial number 56, my lords.
Really?
I pray for the respondent. I have today personal inconvenience, my lords. Kindly have it. Any date may be fixed, my lords. I'll answer.
No, sir. Make some alternate arrangement.
No, kindly, my lords.
Yes.
Any date, my lords. Any date.
No.
I have.
Make arrangement. 2007 matter.
No, my lords, it has been recalled in 2018, my lords. That's the reason.
Right,
I will address it, my lords. I'll address it.
For adjournment, please come here, sir. Yes, next.
Your lordship. Serial number 42, your lordship.
Wait till the matter is called. Yes.
This one, first matter, number 1. Parallel BK.
They seem to dispute with regard to the measurement of the sites. Correct. Correct. Your property has been included in that.
No opportunity has been granted to us. After unilaterally the authorities collect the record at the federal back, what happens is
Take notice, issue notice.
interim stay.
What interim stay? Only Khata ಆಗಿರೋದಷ್ಟೇ ತಾನೇ
ಈ ಆರ್ಡರ್ ಸ್ಟೇ ಕೇಳಿದ್ದಾರೆ.
ಏನು ಆರ್ಡರ್?
There is no the procedure of requirement of hearing is not granted.
All right, no. We'll see that. They seem to be problem.
In next year in date, I discussed your order to grant a lot of stay.
When was that order made?
That order was made on
1 year ago.
yes, madam.
What's urgency? You want us to say all this?
Now the matter is being precipitated.
Correct, sir. What were you doing? Almost 1 year, 2 months.
Yes, madam.
All right, let the notice. We don't know what has happened thereafter.
That is next year.
Council. I hope you'll appreciate this.
Yes.
we are not inclined to give interim order looking at the order before you could say that. That's why we ask you the date of the order. Let the notice going to come, emergent notice, yes. We don't know what has happened for the past 14 months, sir. Yes.
Earlier matter, Assam district. Accept.
Yeah, respond number?
2.
2, every badala. 2 and 3 but nodi. Taluk Panchayat are Hassan. Panchayat Development Officer. Other 2 and 3. Or Hilly, what of you? So there undertakes to file vocal to respond to 2 and 3, issue notice respond to 1, petition to serve the copy and respond to the call this matter, date could you? Yes. Yes.
September 2.
Why the sudden hike in the tax? You deposit the admitted tax.
Admitted tax we are paying.
Where have you paid that for current year?
2021 also I have paid.
This demand is for which year?
For 2021-22.
You have paid admitted?
I have paid the tax. Yeah, paying the tax. But previously, I have paid the tax as per the.
Illappa, please show the current demand.
31.
Page number 31.
Initially, page 34. For 2021-22, I have paid the amount of 29,90,000. Because only they are mirrored this fresh demand. was
Have
paid.
they deducted the amount paid by you?
Yes. 10-11 annexation, yeah, first notice, page 37. They said that.
Yes. On what basis?
This is on the basis of last signal, they have paid, there is an increase in the amount of. Let him pay 50% of this.
He has deposited. Admitted amount he has deposited.
No, Milord, this is page 35, your connection, Milord, this is the amount 89,90,000.
Allappa, he has deposited admitted amount, he is disputing the amount which is sudden steep increase, is what he is disputing.
That's Milord, for that I have to take in session and then file it. Sir.
Correct. So now as far as he has deposited, so let there be stay for the.
For sale of.
Next date.
One submission. Now that the admitted amount, whatever is the one, we have already paid. What is that we have demanded? Out of that, we are getting paid 25% of that amount.
25%.
25% of that. This is
That will be adjusted future, sir. Your money will not go anywhere. Okay, Barkoli. Stay, interim order of stay as paid for, subject to petitioner demanding, petitioner depositing 25% of the amount demanded in excess of the admitted amount paid by the petitioner.
Because that
We said that 25% of the amount shall be paid by the petitioner within a period of 4 weeks from the date of the notice. It is made clear, if the petitioner succeeds in the matter, the amount deposit herein will be adjusted. It is also made clear that if in the event petition fails, it shall pay the demanded amount. Yes, Kodi, 25%. 4 weeks. 25% of the amount demanded in excess of the admitted amount to be paid in 4 weeks. Yes. Yes, both the matters.
Panchayat is concerned, acceptment.
How is it? That's not even Panchayat so and so takes notice. At the mail, it happened issue notice AGA, directly take notice. Not yes.
September 4, Anand case.
Yes.
Hmm.
2014 appointment. 2014 appointment. The order is of October 2020. You don't want him to work, is it? You don't want him to work. What are you doing? 2014 appointment and
In 2015 also we made a complaint before the
allow him to work peacefully. You should also work peacefully. Who are you to determine whether he is a qualified person or not? How are you affected? Whether your increment, whether your seniority, whether your payment is affected. Then what is this meant for you?
I am also one of the villager of the.
That's right, sir. Whether your employment is taken away because of him.
No.
whether your increment, whether your benefits, then what is this?
My respectful submission is not, is the way appointing the respondent.
Sir, they will take care, sir. They will take care.
They challenge the order before the second respondent.
We don't
They
do
are-
it.
they are-
This is not correct. This is not good at, this is not. We understand, if he is eating up into your employment, we can look into it. You are working on your own.
It is not the case of the fifth respondent, they challenge the termination order before this honorable court. However, the second respondent, while allowing the appeal, made an observation that there is a repetition pending. before
Please
this
tell us how his appointment affecting your rights.
Marat, I am also one of the villagers, Marat, because they will.
Is it a public interest litigation? Is it a public interest litigation? That you have gone, that they're going for cleaning up the employment system in the system. What's your locus standi? Please tell us. We can't allow you to go on hunting like this when you have nothing in your pocket,
Not only me, but other person also filed a complaint. I also produced the complaint, produced by.
including that person. Are you taking up the public cause? In an employment by the state to its employees? When it is not affecting directly or indirectly in any remote chances to your employment?
My submission that the very appointment is against the way. Against the, and the observation for a moment, KTC, our second respondent by allowing the appeal. They made an observation, the repetition pending before this honorable court. But it is not the case of the fifth respondent that they are challenged before this honorable court. And a said order was released, and then thereafter, because the concerned partner Panchayati filed an application for seeking review of the order. Then the second respondent, instead of review the order, they passed an order saying that once order is passed, they have second respondent have no relationship. But
No, let them satisfy with the locus, Milord, then you.
you will get a public interest, I will.
No, but that also. Nothing. Service. Nothing.
Council, all elementary things. You can't jump the fence as and when you want. Decide what you want to do with this petition. Before you could pass any order. Decide what you want in this petition. Advise. Advise properly, not good. This next week. Advise your claim properly. Why is he indulging? Let him concentrate and work his work, discharge his work devotionally. Why is he before this court? When it is not affecting in any manner whatsoever to him. Yes. When was this building constructed?
Building, in fact, I am company at this point.
Oh, you say it's a central government building. How? You are a private entity.
I am a company registered under the act.
Correct, sir. How is the property belonging to central government in this?
Property belongs to the government, because I am set up by the government of India. For having crude strategic reserve of the crude oil.
No, we understand that. Is this a property belonging to the government?
The property belonging to the government, because everything is funded by the government. I want to do anything for my own funds, but I want to take collect funds from the holding. It's all funding by the government under the Ministry of Petroleum and Natural Gas. I am in fact, just 2 minutes. I am set up under by the approval of the cabinet for having strategic crude oil reserves in the country. I have set up in 2004 based on the approval of the cabinet.
We have seen all that, sir. Don't repeat that. We are asking a specific question to you. For you to enable the benefit of Article 285, point out where is the property?
Yeah, the land, building, etc. which is there, is funded by the government of India. I don't think any saying that whatever is required is given by the government of India to me. That is why my contention is that this property building belongs to the government. That is not the primary contention.
Now, counsel, the petition submits that the subject property belongs to the government of India and the petitioner has no lien or claim or interest of any nature whatsoever of the property. Therefore, he submits the benefit of Article 285 shall be extended. Issue notice to respondent. The land AG is there to take notice to respondent number 1. Issue notice to respondent number
2, 3, and 4.
2, 3, and 4. List on, yes. You are. No. Burley. Let us hear that. You should notice, let us hear that.
And also on the question of which exemption, that's the reason I'm asking.
We will see that.
And like, they take the rest. Right.
Yes. Where is your sanction plan? When long back? Time immemorial. We have seen your paper. Please tell us when did you consider the building? We have seen your papers. Please answer our question directly. Don't waste your time. When did you put up the construction? Where is your gift deed? Where?
I have received it under gift deed.
Where is the gift deed?
Gift deed, in 2021, I have received.
Where is your gift deed?
I'll produce it.
Where? How did your father get the property?
I'll
We'll dismiss this with cast.
No, I'll produce it with the.
We are going to dismiss this petition with cast.
I'll pass over, I'll get the gift deed and I'll produce it.
Not only gift deed. How did your father get the property? If you give a specific date, when did your father construct the property? We will ask the order to be effected by tomorrow.
Okay.
All matters are court.
Yes, all this matter.
20 times.
Yes.
20
Yes.
times.
Yes. Yes. The site given by you belongs to somebody else. Take notice. You should, AGS director take notice. 1 to 3, no? 1 and 3, 1 to 3.
1 to 3.
1 to 3 issue notice respond before. Yes.
30.
ಅದು GST ಯಾರು ಕಟ್ಟಬೇಕಪ್ಪ? Whether the component of GST is it forms the part of the bill. ಅದ್ರಲ್ಲಿ ಇರ್ತದಲ್ಲ as and when payable. Why should they bear the GST? It is you will have to pay. Although as and when you have to make the payment. You have to make the payment. Issue notice to BBMP. Issue notice respondents. Yes.
14.
ಒಳ್ಳೇದೇ ಅಲ್ವೇನ್ರಿ? ನಿಮ್ ಸ್ಕೂಲ್ ಪಕ್ಕದಲ್ಲಿ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರೆ ಏನ್ ತೊಂದ್ರೆ ನಿಮಗೆ? ಅದು ಬೇರೆ ವಿಷಯ. ನಿಮ್ಮ ಗ್ರೌಂಡ್ ಏನು? ಹಾಸ್ಪಿಟಲ್ ಪಕ್ಕದಲ್ಲಿ ಮಕ್ಕಳಿಗೆ ಓದ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತನ? ಹೇಗೆ? We fail to understand the logic. That's your ground. The hospital is put up next to the school, so kids cannot study ಅಂತ. ಎಲ್ಲಾಗುತ್ತೆ? ಏನಾಗುತ್ತೆ? ಎಲ್ಲೂ ಇಲ್ವಾ? ಹಾಸ್ಪಿಟಲ್ ಸ್ಕೂಲ್ ನಡೀತಾ ಇಲ್ವಾ? That your kids will not be able to study because the hospital is next door. Why you want to expand the school there? You want to expand the school there?
No, they are running from up till degree. From LKG to degree.
Not in good taste. Not in good taste. What do you want to do? No. Think about it until tomorrow. Advise properly to your client. Come tomorrow. Monday. ಓದಿ ನೀವೇ ಒಂದ್ಸಲ ಪೆಟಿಷನ್.
15. Vijay Kumar.
ಆ ಸ್ಕೈ ವಾಕ್ ಗಳಿಗೆ ನಡಿಲಿಕ್ಕೆ ಆಗಲ್ಲ, ನೀವು ಲಿಫ್ಟ್ ಹಾಕಿ ಕೊಡಲಿಲ್ಲ ಅಂದ್ರೆ ಹೇಗೆ? ಯಾಕೆ ಮತ್ತೆ ಸ್ಕೈ ವಾಕ್? ಯಾರು ಹೂ ಗೇವ್ ದ ಪರ್ಮಿಷನ್ ಟು ಪುಟ್ ಅಪ್ ಸ್ಕೈ ವಾಕ್? ನೀವು ಡಿಸೈನ್ ಕೊಟ್ಟಿಲ್ವಾ ಮೊದಲು?
We are given.
In the design, did not provide for the lift.
Design and everything we provided, because of the case service near Mysore, Mangalore, main opposite to that bus stand, there was a, with the entrance of case service department, they are not allowing, therefore we provided.
But you tell us how this lift process will work when so much crowd is there. What is the capacity of the lift? Lift.
10 passengers each lift.
How will it serve the purpose?
Purpose is that.
What is the inflow of the people?
Same of plant, same of, for the senior citizen, migrants and the children for all, will be very mandatory. The different measure with along with the, we have to cooperate everything, the PPP model, private, public, this one not there, not as for that, we given a representation on.
Issue notice.
My intent is not to cause any address or that, the direction of this on good book,
You're asking for the larger relief.
Today is the, as for the last day, who complete entire Seva project. Third day, we completed the entire Seva project. Only that they have to give a permission to keep electrical engineer.
Have you installed the lift now?
Yeah, everything is on spot, without permission, without giving an offering letter, we cannot go on.
Where is the certificate of commissioning of the lift by the company?
That company, that is, your first, when I tried applicant before the.
Illelideppa. The company which installs the lift should give the commissioning letter. Where is it?
Your last kindly turn to the page number, please kindly see the annexure. This is the application we have given to the chief electrical engineer BDMP department, where in Milan, they subsequently Milan, they as per annexure head, it is found that skywalk for the installation of lift belonging to BDMP authorities, but applicant filed the skywalk installation erection permission in the name of 50 developers private limited, hence application will be applied in the name of BDMP authorities. As per that, not only we have to give a representative to the BDMP. Chief electrical officer said that directly without your consent, without giving a sanction letter, they are not allowing. Because in this regard, we given a representation as per annexure.
So what is this interim you're talking? What kind of adverse order? What is adverse? Any adverse order is what?
As per the first.
You cannot give a omnibus order. What do you mean by any adverse orders in the Reno?
They cannot cancel that.
Cancel what?
Because today is the last date for complete the entire Skywalk project. Within 4 months, direction was given by dishonorable.
Does it say that failing which any consequence contemplated there?
No.
So if it is there, we'll give that.
It is there.
Torsi. If you fail to adhere to the time schedule, any consequences page number 32. Torsi.
Para number 30. And para number 10 is page number 32.
Page 32 is what? What is page number 32?
32, that is the order passed by dishonorable court in repetition.
Yeah,
In view of the matter, the respondents are going to permit the petition to execute the project within a time frame by that may be fixed. Therefore, this activity is allowed. If you order passed by respondent, so dated earlier request, respondent number 3 is directed to permit the petitioner to install the skywalk as per the letter dated annexure 3 within a period of 4 months from the date of receipt of the certificate copy of the starter. If the petitioner fails to implement the project within time, the respondents are at liberty to take steps in termination contract without any further notice to the petitioner. Therefore, below we completed the project except installation of lift. Everything project is completed.
Now, show from your project, where is the provision for installation of the lift?
As per the Karnataka lifts, escalators, passenger conveyance rule, a permission is required. Authorities have to give that. Please kindly go through that.
In the project, where is the provision for the lift, sir?
That is a tender notification is there. Tender notification.
That accounts for the petition submits that the skywalk project is completed and the petitioner is awaiting permission to install the lift, which has been declined without any justification. It is further submitted to the petitioner that the petitioner apprehends precipitative action from the BDMP on the pretext of non-completion of the skywalk project within the scheduled time. Full stop. That in view of the delay being caused at the BBMP end in issuing the permission to install the lift, the completion work the skywalk work is not completed. Therefore, the petitioner is apprehensive of precipitative action at the end of BBMP. Third, peruse the records. There shall be the respondent BBMP shall not precipitate the matter in terminating the contract till next set of hearing. Yes.
Okay. Number 16. Lands were granted in.
Notice told. Notice told. HCGP is dated notice to respond number 1 to 3. 1 to 3 issue notice to respond number 1 to 16. Yes. ಅಷ್ಟು ಜನರಿಗೆ ಸೇಲ್ ಆಗೋಗಿದೆಯಲ್ಲ ಅದು ಯಾರ್ಯಾರಿಗೆ ಏನಂತ ಸ್ಟೇ ಕೊಡ್ತೀರಾ ಹೇಳಿ ನೋಡೋಣ. ಯು ಟೆಲ್ ಅಸ್. We will consider it. 16 ಜನ ಇದ್ದಾರೆ. We don't know what has happened. Notice open. He will understand. Yes. Yes.
This measure, number 17.
1 week. 1 week. Yes.
18.
On third respondent.
I am permitted to submit the inspection report.
Yes.
A copy is there available to us. We can from that.
Correct, not good.
You know, what is the result of the report?
My lord, from the BBMP, my lord, there is no sanction plan to this building, my lord. Even while conducting this spot inspection, my lord, we had requested the petitioner to submit the plan. My lord, they had not been submitted. And as of what the construction is there, we had examined and we had submitted.
What is that you found in inspection?
Inspection, my lord, it is, my lord, without the sanction plan, it has been constructed.
No sanction plan at all.
No sanction plan.
ಅಲ್ಲಲ್ಲ ರಿಪೋರ್ಟಿಗೂ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಏನಿದೆ ತಾವು ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಕೊಟ್ಟರೆ ನಾವು ಕಂಪೇರ್ ಮಾಡಿ ನೋಡ್ಬೋದು. ಆಸ್ ಸಿಂಪಲ್ ಆಸ್ ದಟ್ ಡೈರೆಕ್ಟ್ಲಿ ಶೋ ದ ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್. Senior counsel, we are asking is. So as of now, is there, you do have a sanction plan?
It's a 1972 construction. Our defense before the authority is responding to the proposal notice. It is not either reconstruction or it is a other thing. We contend that it is only a repair. Repair is considered not covered under the plan or other permission, other things. That was the contention we have writing. Last occasion, we not wasted the report. According to the report, we have taken an action. That report is directed to be based on record. It was not based on record. Then it is said there is no report record. Therefore, you will not be asked the questions of conducted part instructed and submit a report. That you have about 10 to 20 pages are there. I will keep to my.
So what is the position of law if according to you building is 30 years old and it is not in accordance with sanction plan of any nature whatsoever? All right. Yes. BBMP, counsel for the BBMP has filed any group?
Inspection report conducted on 4/11 as per the.
Inspection report conducted as per the order passed for this court on 19/10/2022. Then senior counsel appearing for the petitioner seeks 10 days accommodation to revert to the said report.
My humble submission in language. The original owner of the property, my application checked it without first, is really get a respondent, I also filed a petition number 38,894 of 2016, that is also pending by the state. Directing the BBMP authority to take immediate action for demolition of the existing building, that is also pending.
What do you mean you are the, who are you?
No, I'm the absolute owner of the property, Lord.
Which property?
Same property.
Ah.
And see, I purchased the property when the petitioner was residing in the premises, my Lord.
So then the property dispute between both of you.
No, there is no dispute. They claims to have, in possession of the property under the permissive possession. I have purchased the property under the registered sale deed, my Lord. Subsequently, my Lord, I have also initiated a proceeding for a suit for recovery of possession, my Lord. Suit for possession also is also filed.
So that's the story behind this proceedings.
No.
Then we'll dispose of this petition, have it disposed of, then the action be taken thereafter.
My Lord, one more sufficient, my Lord. The petition number 38,894 is also a 2016 matter, my Lord.
All right, get that also. Post it Monday.
Both together, please.
If there is a dispute of title, we'll dispose of this
No,
petition.
title is not disputed. No, there is no title. My Lord, there is no title dispute, my Lord. I am the owner. They have not purchased the property. They claims to be in possession of the property in the nature of permissive possession. In the nature of permissive possession, they cannot, they cannot dispute that I am not the owner of the property. I am standing in my name. Everything is standing in my name. In my absence, my Lord, they started to put up a construction. That is the reason I am also to put this on the board.
When did you purchase?
2010, my Lord.
When was this proceedings initiated?
Yeah, 2016,
When did you file a suit for recovery possession?
2020. Within period of litigation, my Lord, that's all for covered, my
All
Lord.
right, let those suit be disposed of. Then the question of validity or otherwise the sanction will consider.
No, my Lord, the illegal construction put up by the.
That we'll deal with it later, sir.
No, that has no relevance, my Lord. That has no relevance to the case.
We understand.
Let it both the matter.
We understand that.
Let the both the matter be taken up, my Lord, and then I will understand.
We understand that. We have made it very clear. If there is a proprietary, if there is a civil dispute between the parties, do not convert that into a illegal construction.
There is no, there is no.
That is different.
There is no.
We have been seeing that. We have been seeing that. Now it's very clear by your submissions, counsel.
My submission, I'm the owner. See, a person who is person of the party trying to put up construction without taking a license and the sanction plan, doesn't a justifiable ground, not, it should have a construction, not the authority, authority, because of my initiation of proceedings, the authority has initiated the proceedings and issued invoked section 321. And thereafter, they filed a suit for injunction. You know, that suit also has, I think, included a body proceeding. Again, they came to high court. Again, the petition to be dismissed. Subsequently, they withdrew the suit. Then again.
What do you mean he is in a permissive position?
The original owner in possession of the property, not, they are in my suit. They are given a possession to take care of the property.
So they are setting up title against you.
No, they can't set up a title. They don't have the title at all.
So who are they then, according to you?
They are the permissive possession.
You're not answering the question.
Yeah. One Shakama was the owner.
Sharma was the owner of the property. One Mr. Chandrasekhar.
Our Haley bidi. Our Haley. Haley.
Shakama was the owner. Shakama, I was a tenant for 2 days, 2 months. Then she intended to sold the property 1920. Then she received the entire sale certificate. Being in possession, I continued. Thereafter, this man, a third person filed a suit against.
So you don't recognize this man in any manner whatsoever.
Yes, and between that there is a serious dispute. He filed a conflict crime. We are also trying to property. He filed it. He filed.
What's the suit you have filed?
I there filed the suit in the time filed a conflict crime.
What's the counterclaim?
That I am the one. That owner, I am in possession. Are the.
File all the suit details.
I will place it on.
Is this matter on Wednesday? Connect this matter along with the other matter, which is the request.
38,894 of 2016.
Can't convert this proceedings into your shortcut recovery proceeding, sir.
No. I'm not seeking anything beyond the scope of the law, my lord. What is I'm seeking is that you are just whatever it is on my property.
We quite see that. We quite see that.
I understood, but ultimately, justification is he came together to keep it quiet, and they did not open their eyes and they started putting the construction. What should I do, my lord? I don't have any alternative. Therefore, I have to be followed. They did not exercise justification.
So you purchased the property in 2016.
2001.
12. Building was in existence then.
No, that's what. It's six.
Building was in existence then.
Square building was existed as on that day. There.
Was there a plan to the building then?
45, in page number 45.
Was there a plan to the building when you purchased?
No, my lord, there was no.
So you are ready to demolish the entire building.
Please, my lord.
It will be beneficial to you.
No, no. Of course.
Yes, wait, don't convert this in. Let there
No,
be,
no, I don't want.
let there be sense, let there be sense.
What may not happen.
Let there be confidence and sense in the people that somebody else out there to hear both the cases. Don't cut short.
They would. The one.
Don't encourage this. Don't encourage.
They.
Don't, and we'll see the Wednesday. File all those details of the cases also. We'll look into it.
23rd November.
The memo,
Memo ಕೊಡು.
file this memo in the register. Serve the copy of the.
Yes,
ತಗೊಂಡಿದ್ದೀರಾ? All right. File.
I'll.
Interim order.
Interim order granted earlier, this extended to next.
Yes, right.
December 19th.
First respondent. On the ground of may I refer to my statement of objections.
File in the registry. File in the registry. Yes, you want to.
Varanasi retired and explain the budget.
Yes.
May I make one comment? On the last occasion, my lord has made an order on our submission about this matter can be disposed of on a point of law.
You mentioned about the limitation.
Yes, and we are covered by a judgment, and I just pass over that, and therefore nothing would survive this level. This is just to log a dead horse law. Yeah, comment of the incident. Paragraph 7 and 8.
What is the relief sought in this petition?
They cancelled the kata after many years. The limitation of 148. Power of the commissioner cancelled the kata. My lord.
Kata was made in your name.
In my name, it was made as early as 2007,
Yes,
30th March 2007.
yes.
And the calculation was effected by an order of the third respondent, which is in challenge before my lord, on 8th May 2017.
On what basis?
On the basis that the kata was obtained by fraud, which is covered under 148. May I just, my lord, the judgment reproduces 148. My lord, see paragraph.
Yeah.
And the section is reproduced, my lord, at the latter half of paragraph 7. By the commissioner, either suo motu or otherwise. After such inquiry, I be considered necessary. To satisfy the very transfer of title under section 114 was what recorded in the corporation register of fraud, misrepresentation, or suppression of facts. Of a quality false, incorrect, or incomplete material. He may, within a period of 3 years. From the date of such recording of transfer of title, reopen the case and pass such order with respect to anything said.
What is your stand on the case of the allegation of fraud?
My stand on the allegation of fraud has been dismissed in a civil suit in our favor. A deed on the basis of which we claim is a release sheet of the year 2003 for challenge. And that judgment
Who challenged it?
they challenged it.
They money?
The respondent, the contesting respondent, Lord, SNS Plaza, and their predecessors entitled release.
They challenged?
They challenged the release date transferring this property in my favor. And that resulted in a judgment in my favor, upholding the release deed, and thereby the right to this property in respect of which the kata was transferred has been upheld in my favor, and it has become final.
So the kata was transferred pursuant to the release deed.
The kata was transferred pursuant to the release deed.
What is the date of the release deed?
2003, the exact date.
All right, where's the judgment passed confirming the title in your favor?
Yes. My lord, may I make this submission before?
Yes.
The transfer of the kata was also challenged in a parallel writ proceeding by them, which resulted in a dismissal, and that order has been provided. And my lord, this court, what makes this court has held, that if they have any dispute, the proceedings will not lie, they have initiated civil suit, and accordingly, a civil suit was initiated and it went against 7 final. And you see that order at very number.
And when was the order of the writ petition passed? The civil suit passed?
The order of the civil suit was passed in the year 2017.
Prior to this revocation of kata? Prior to revocation of kata?
No, after that.
Yes.
In fact, we have referred to the judgment and our objections to the learned commissioner. And may I just point out two things? Can you see page number 23?
Yes.
Page number 23, my lord, is the,
Review petition.
yes. And that is the order. That's the order. And can you see paragraph 6 at page number 25?
Yes.
It says, the respondent, my lord,
Please.
the respondent submits that the honorable High Court in Hyderabad 2004, Karnataka 1542. That is the judgment my lord has in hand.
Yes.
As clearly held, that the petition filed after the lapse of 3 years under section 114 capital A is not maintainable in law. And kindly see the answer of the learned commissioner at paragraph 22 at page number 28. Paragraph 22 at page 28. The other contention is that the petition is barred by limitation. The said contention is also liable to be rejected. In as much as the petition is filed within 3 years from the date of knowledge.
Where's the fraud? Where's the ground of fraud? He says, what does he say about the fraud?
Sorry, my lord.
What does he say about the fraud?
My lord, the finding of fraud is very perfunctory and you may have.
He says the gift deed is executed on a non-existing property.
Yes. Now, the court has held in the suit filed by us that his contention is taken and that property exists. And may I make the submission, my lord, if that is the case, I can see the operative part of the order at page number 30.
Yes.
If that were the case, how is it that he's transferring the strata in the name of the complainant?
Yes. Who are you?
But I will here for the first respondent. Will I make this submission?
Two things, please clarify.
Yes.
Were you party to the suit? Were you party to the
I was
suit?
not a party to OS for 1566 of 2012, which my learned friend is referring.
OS number?
It is, OS number is 1566 of 2007, which my learned friend is referring to. I am not a party to those proceedings. Look, the data has been transferred with respect to a non-existent land. Look, what happened was that they fraudulently executed the father of the petitioners, right? They executed a sale deed and a gift deed in.
What about the earlier writ petition that was filed by you?
Writ petition has been pending consideration before the honorable court. Writ petition.
He said you are relegated to the civil court.
No, the writ petition is pending. My learned friend is appearing in that petition as well. Writ petition triple 277 of 2015.
That's pending. NXRP 169, Mr. Counsel.
Come to page 205.
205.
This is pending is what I am saying.
As we heard you. Kindly paragraph, page 205, paragraph 35.
Yes.
May I read that out?
Yes.
This is a coordinated judgment, a challenge to be fairly affected by the PDA in my favor was under challenge. In respect of the property, where Karnataka has been involved.
There is an application filed to vacate the interim order.
Yes, can you see the observation in paragraph 25?
Yes.
Moreover, because of the complex disputed questions of fact, I not have that.
Yes.
Because of the complex disputed question of fact, the petitioner does not have a prima facie case in his favor. Further, and there is a judicial finding given by a learned civil court with regard to the existence of the two different parcels of land. Has reached finality. Along with that, finally, market is the basis on the Karnataka cancelled. A finding which has reached finality with the balance of convenience in order favor of the petitioner. Furthermore, in case
have you initiated any proceedings? Have you initiated any proceedings before the competent court?
There is one more suit that is suit for declaration that is pending before the court.
Filed by whom?
It has been filed by.
What's the OS number?
The OS number is OS 670. I think it's 671.
Against whom is it filed? Against the petitioner here?
Yes.
So you must be having the suit number.
What happened was.
What is the suit number?
I will just point out. OS 691 of 2012.
691 of 2012.
2012.
You have filed a suit.
I have filed a suit for declaration, which is not ready consideration.
May I make this submission, my lord? Just, my lord, may or.
Let the Khata go back to the original position.
My lord, may I just, please have a look at the, because what has happened is, my lord, the Khata is.
We can't expand the scope of this petition into litigation when you have gone to the
I
court.
don't want that to happen, my lord. I don't want the Khata with respect to a non-existent land
All
to
right.
be conferred on the petitioners. The Bangalore Development Authority, my lord, has executed a sale deed dated 28/12/2012 in favor of them. That sale deed, my lord, even according to the Bangalore Development.
Everything will be subject to outcome of the suit filed by you.
This submission will kindly be noted. The Bangalore Development Authority in its proceedings have noted that the sale deed has been fraudulently obtained. No sale consideration has been passed. Your the proceedings before the Bangalore Development Authority, I would like to place it before this property court. When there is a direct fraud that is placed on the Bangalore Development Authority, because what has happened.
Your suit is against whom?
He has not filed. My suit against the vendors. That suit has come to an end. My suit is against the vendors. They purchase the property after the release deed in my favor. They challenge the release deed through them. By the same counsel appearing in both the suits.
Yes, but present petition is filed.
Please take this statement on record.
Sir, you have to file the statement in the counter. This is a 2017 matter. We have heard you. We will not start the procedures. We have made it very clear. At the last moment, you cannot come with a bundle of papers, burden the court. We will not entertain that. You should have been cautious enough when you took that time. No, enough. Berkeley. Berkeley. This is a writ proceedings. You are aware. Berkeley. The present proceeding. Present petition is filed. We are dictating the order. We are dictating. We'll take note of all your submissions, counsel. We'll take note of all your submissions. Take a note of your submission.
I will make and then rest my.
Really.
The order that my London will refer to in the proceedings, that is only an interim order. An interim order had been granted in my.
We are not giving any finality to any order, sir. We are not approving or confirming any order. The admitted fact of the matter is there is a decree in his favor and you have filed another declaration suit. Let it get disposed of. Khata, which stood earlier, be there as it is. That's all. You win your case and get the Khata revoked. Berkeley. Present suit is present appeal, present petition is filed seeking following reliefs. It is the case of the petitioner that the father of the petitioner, the grandfather of the petitioner, Sri M.S. Pandit, had originally purchased the residential plot measuring 750 square yards, bearing number 40B at Kumarakripa High Ground, wide sale deed dated 3/9/1946. You got the property by what?
We got the property by release deed and by a sale by the deed.
Ah.
That is incorrect. They are claiming title based on a gift deed. That is what they say in their petition. My learned now says that it is based on a lease deed. It is based on a fraudulent gift deed and a fraudulent sale deed.
The petitioner has acquired the property. There's a marginal land 337 square yard.
That's right.
Yes, petitioner state that their father Pandit had executed a gift deed of a marginal land measuring 337 square yard, wide deed of gift dated 31/1/2007 to his wife and the petitioner's mother Parvati Pandit. The Khata in respect of the said 337 square yards bearing municipal number 22/2 was recorded in the name of the petitioner's mother Parvati Pandit, and a certificate in this regard dated 33/2007 was issued. When was the suit filed by you? What was the need for you to file the suit?
They filed the suit against.
First suit.
1566 for declaring the release deed as null and void.
Who had filed that?
They have filed
Against you?
against me.
Full stop. The first respondent hearing. No, you are referred to as a gift deed.
The release deed of 2003 in favor of the mother.
Ah,
Mother, and therefore the confusion will be created.
that release deed in favor of the mother was challenged.
Yes, yes. And therefore my friend unnecessarily created this confusion.
Full stop. That the first respondent hearing had filed a suit in OS number 1566 of 2007.
Please have a look at that judgment.
Sir, all right, just have some patience, have some patience. We are not rehearing the matter, we have made up our mind. Yes. Perfect. A suit in OS number 1566 of 2007 was filed for a declaration of title in respect of said marginal land. The suit was decreed in favor of the petitioners, confirming the release deed.
No, my lord. Because
A
it is incorrect, my lord.
writ petition
May I
had been filed in WP number
222 of 60.
2277 of 2016 by the first respondent hearing, questioning the khata conferred in favor of respondent number 3 and 4 for the petitioner's hearing. By order dated, it is the contention of the first respondent that the property which is being claimed by the petitioner is a non-existing property. Good stuff. An interim order in the said petition had been granted upon an application filed by the petitioner's hearing who are the respondent number 3 to 5 in the said suit. This court by order dated 4/7/2017 passed on IA number 1 of 2016 at paragraph 25 has held as under. It is also submitted that the petitioner, respondent number 1 hearing, has now, who is the purchaser from the your vendor, is it? Is a purchase from your vendor.
No, there was a.
First respondent is purchaser from your vendor.
No, I have not purchased it from him.
About the 337 square.
Your vendor and his vendor one the same.
Yes.
The first respondent, who is the purchaser from the vendor or the petitioner as well, has also filed a suit in OS number
My lord,
691 of 2012 for relief of declaration, and the set of his title. The said suit is pending consideration. Amidst all this, an impugned order at annexure
And the order of annexure A and B,
A and B has been passed by the respondent number 2, revoking the khata standing in the name of the petitioners on the premise that the same had been obtained fraudulently in respect of a non-existing property. And counsel appearing the petitioner submits that the said order is not sustainable for 2 reasons. Number one, firstly, that the proceedings initiated by the respondent under section 114A is barred by limitation in that the khata in respect of the aforesaid property was registered in the name of the petitioners on 30/3/2007, and the revocation of khata has taken place on 8/5/2017. Referring to clause 114, section 114A, which provides for initiation of any such proceedings within a period of 3 years from the date of registration khata, and the council submits that the proceedings thus barred by limitation. To buttress the said submission, he relies upon the judgment of this court in the case of K. Sushila versus Bangalore Mahanagara Palika and others, ILR 2004 KR 1542. As regard the allegation of fraud is concerned, the council submits that the entitlement, right title and interest of the petitioner has been determined in a properly constituted suit in OS number 1566 of 2007, 1566 of 2007, and the same has attained penalty. Therefore, he submits the purported ground of fraud giving rise to the impugned order is also not sustainable. Hence, seeks for allowing the petition. On the other hand, Sri Vikram, the counsel for the respondent one, submits that the case of the petitioner is factually incorrect. He submits that the documents obtained by the BDA itself is fraudulent. He also submits that there is no property as claimed the petitioner is in existence. He also submits that the petitioner, not having proved the existing property, is not entitled for the khata. More so, the documents relied upon with the petitioner are fraudulent. Therefore, he submits that the order passed, order impugned, does not require any interference. Full stop. He also submits that the decree which is being relied upon with the petitioner, invoice number 1566 of 2007, is not binding on the first respondent as he is not a party to the said proceedings.
Even that impugned order, it says there were two plaintiffs.
We will not get into that. You are not a party, you are not a party. We will not, we are not. Counsel, you know the limits of the court. We can't get into the finding that you are not a party, you are not binding. Fine. However, he fairly submits that the suit in OS number 691 of 2012, filed with the respondent for a comprehensive relief of declaration of title in respect of subject property is pending consideration, which is between the petitioner, between the respondent number one as a plaintiff and petitioner number 1 and 2 as the defendants therein. Submission taken on record. Hence, seeks for dismissal of the petition. Submission taken on record. Third, there is the records. It is not in dispute that the khata in respect of the subject property was registered in the name of the petitioner on 30/3/2007. The proceedings under section 114A of the BBMP Act, Karnataka Municipal Corporation Act, was initiated on 26 March 2017, and the order impugned here has been passed on 8/5/2017. Section 114A of the Municipal Corporation Act reads as under, as held by a coordinate bench of this court in the case of K. Sushila Supra, paragraph 7.
Yes, and 8.
Paragraph 7 and 8 extract money. Thus, any proceedings, even on the ground of fraud, has to be initiated within a period of 3 years from the date of registration of khata by the concerned authority. That not having been done, the proceedings are barred by limitation. However, notwithstanding the same, since the issue with regard to the right title and interest between the petitioners and the respondent number one is pending consideration in a suit constituted by the respondent number one, invoice number 691 of 2012, pending adjudication, the outcome of the said suit will determine the rights of the party, including right to have the khata entered in the register. In view of the aforesaid factual background and the decision, the impugned order passed with the respondent number so and so requires to be quashed, and the khata as stood on 30/3/2007 be restored to its original records.
The lady died, and the legal has there the khata was restored in 2014, 26 February 2014.
Yes. In the name of the original khatidar, all the legal representatives, if they satisfy otherwise, full stop. As regards the annexure N, as per annexure N, full stop. As regards the right entitlement of the respondent number one is concerned, any observation or finding given in this petition shall not influence the outcome, shall not influence determination of the right of the respondent number one in a suit constituted by the adjudication shall be without being influenced by the outcome of the present petition. Yes. A and B. This.
20 minutes. Our name is shown, but we had taken the consent and gone, my lord.
Yes, madam, ಯಾರಿದ್ದಾರೆ ತಮ್ಮ ಪರವಾಗಿ ಯಾರು ಇಲ್ವಲ್ಲ?
ಅಲ್ಲ, ಕನ್ಸೆಂಟ್ ತಗೊಂಡು ಸೈನ್ ಹಾಕಿ ಹೋಗಿದ್ದಾರೆ. ಆಲ್ ದಿ ರೆಕಾರ್ಡ್ಸ್ have taken away.
ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೇನೋ?
Pramila Associates, my lord.
Correct. So you're no more on record now.
No, my lord, no, my lord, no, my lord. Because my name is on, I'm waiting, because I wanted to
Yes, yes,
represent your
yes,
lordship.
yes.
There should not be any
Very well,
misunderstanding.
very well. Mrs.
Yes.
Pramila Nesargi, the senior counsel, appearing on video conference submits that the petitioner has taken the file along with the consent wakalat. Full stop. None appears for the petitioner. Sri Chidanand, ತಾವು ಯಾರಿಗೆ?
ಅಲ್ಲ, ನಾವು applicant.
ತಾವು.
Yes.
Okay.
They have also filed an application to include me.
All right.
I have also filed an
All
application.
right. List this matter on so and so. Then delete the name. ತಮ್ಮ ಹೆಸರು delete ಮಾಡ್ಲಿಕ್ಕೆ ಹೇಳ್ಬಿಡ್ತೇವೆ.
ಖಂಡಿತ.
ಇದು ಯಾರು? ಹೋಗಿ ಚಂದ್ರಚೂಡ್, ಇದು ತಮ್ಮ ಆಫೀಸರ್ ಚಂದ್ರಚೂಡ್? ಅವರು ಓಕೆ, ಇಬ್ರು ಇಲ್ಲ ಇವಾಗ. Okay, to delete the names of so and so, issue notice to the petitioner. Yeah. List this matter on 5th December. Yes.
Grateful to your lord.
Yes.
Okay.
Number 21. ಮೊದಲು ತಗೊಂಡಿದ್ದೀರಾ? Have you given the ಇಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿಲ್ವಾ? ಇಲ್ಲಿ ಬರ್ಕೊಟ್ಟಿಲ್ಲ. Will dismiss this petition. No, not today. 2020 matter, you are not even taken steps till date. And all of us are running behind this file. 1 week time. 32. 1 week. 23. 1 week. 1 week. 24.
26 minutes.
Petitioners. Your colleague is also here.
Sorry, my lord. Serial number 26, my lord.
No, we are not reached it.
24, sir.
We are at 24. Yes. Coffee serve ಮಾಡಿ ಅಂತ. ಅದು ನೋಡಿ ಸರ್ವ್ ಮಾಡಿ ಕಾಪಿನ. Yes. 35. Number 25. 1 week finally. 26.
Please, my lord, I am for the petitioner, my lord. I have served the copy with the acknowledgement to R2, my lord. Kindly days accommodation, if there is any, my lord, kindly taken up on Monday for admission, my lord. If there is any objection today and tomorrow, I'll comply it off, my lord.
Yes, to comply with the office objection, 1 week time. Yes.
Monday, my lord.
1 week. Move comply ಮಾಡಿ ನೋಡು. Yes.
27.
Not the respondent, who is the second executive engineer of First respondent is Commissioner Town Municipal Council. First respondent is already represented. But may I request not the council representing for the first respondent to take notice of respondent work.
ಇದು ಬನ್ನಿ ಏನಿದು ಸೈನ್ ಆಗಿಲ್ಲ ನಂದು ಹಾಗೆ ಬಿಲ್ ರಿಪೋರ್ಟ್ ನಂದು ಆರ್ಡರ್ ಸೈನ್ ಆಗಿಲ್ಲ ಕರೆಕ್ಷನ್ ವೇರ್ ಇಸ್ ದಟ್ ಆರ್ಡರ್ ಹೌ ಇಸ್ ದಟ್ ನಮಗೆ ರಿಪೋರ್ಟ್ ನೋಟಿಸ್ ಫೈಲ್ ಬಂದಿದೆ ನೋಡಿ ಬರ್ತದೆ ನೋಡಿ ಎಂಟ್ರಿ ಮಾಡ್ತಿದ್ದಾರೆ when what is the date of the 2018 2018 after sign ಆಗಿದೆ yes ಹೇಳಿ what is
Take notice of respondent to respondent 2.
Yes, ಯಾರಿದ್ದಾರೆ ಅದಕ್ಕೆ?
Not the respondent two, not for RTA will take that, not for the respondent two also got direct notice and out to respondent two and three.
R3 ಎಲ್ಲಿದಾರ್ರಿ? ಇಬ್ಬರೇ ಇರೋದಿಲ್ಲಿ.
So the R3 was the EPA applicant. Application was filed to include.
Has it been allowed? R3 ಅಂತಿದಾರಲ್ಲ.
Sorry, my apologies, because the formal is not respected as respondent three. My apologies, but I will take steps to including applicant also to respond.
Issue notice to respondent number 2 and the proposed respondent number 3. Yes.
But the undertaking.
ಎಲ್ಲಿ ಅವ್ರು ಇಲ್ವಲ್ಲ ಅಂಡರ್ಟೇಕಿಂಗ್ ಅವರು? ಎಲ್ಲಿ ಅವರು? ವೇರ್ ಇಸ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1? ಏನ್ ಹೆಸರು ಅವ್ರದ್ದು ಅಡ್ವೊಕೇಟ್ದು? ಲಾಸ್ಟ್ ಟೈಮ್ ಇದ್ರಲ್ಲ ಅವರು. The respondent shall not precipitate, shall not take any precipitate action till next date of hearing. Yes. Very compound wall ತಾನೆ? Only compound wall ಅಲ್ವಾ?
58.
1 week. Interim order granted extension till next step.
29.
Directed to report. Regarding unauthorized conduct. Members are not received as the legal matter. Your lordship insisted to make it either report.
Why should we insist? If you don't insist, you don't take action.
No, I'm just facing for that. But
No, you said we
I will go
insist.
to that effect.
Huh.
Wherein after equaling the notices, will be the person who is putting up unauthorized construction. He is got 45 days time to bring the building in conformity with the scientific plan. That being the situation, my lord, and I to make it done, my lord, I will be filing the report after compliance of.
What's the report? What's the report? What is the deviation?
But the deviation in the report has also been filed.
You know, unfortunately, these kind of petitions are being
True,
used
madam. True, madam.
to
That's
settle some other score, which is why we have to be tight fist in these cases.
The photograph itself, my lord, page number. That is page number 9, my lord.
Huh.
Especially at page number 12 and 13, sorry, 11 and 12, my lord.
ಏನ್ ತರ್ತೀರಾ? How will you bring to what compliance will you bring?
That is what they want to settle, my lord. I have my own objection for which I.
Karen, what are you trying to make out in this? Entire street has the same buildings. What action are you intending to take? Just say I wash.
We should not understand 248, 1, 248.
No. What is the deviation? Have you pointed out?
My lord, the deviation in the report.
Where is the sanction plan? Is there a sanction
Page
plan?
number 6, my lord.
100% deviation.
100% deviation.
So you have to demolish the entire building.
It is still under construction, for which the person who is putting up the unauthorized construction says that he will again bring this building.
Where has he said that?
My lord, at page number, the last page, my lord, at page number 18, I mean, 8. He is given a letter to me dated 21/10/2022. For 45 days time.
Who is this fellow? He is a petitioner or respondent in this case?
My lord, the person who is given this is the respondent. Respondent number 5. My lord.
Respondent, ಹೇಳಿ.
I can suggest is that, my lord, some time may be granted. So once the building is brought in conformity, my lord, the BBMP will be again filing a report.
We are waiting for the building to get cured, then take action.
It's not for so much time. This time, my lord, will be expiring.
Then calls for the BBMP file report along with 6 documents, including the representation given with the respondent voluntarily undertaking to demolish the violated portion of the building at his own cost. Report taken on record. None appears for the petitioner and the private respondent. List this matter on date.
1st December.
1st December. Yes.
No,
Barley, 1st December March Dosi. Let us see.
My lord, that is with my lord, my kindly direct my BBMP to attend from the report.
In the BBMP to file action taken report in the matter. Yes.
December 30. Yes, been what?
1 week. Yes. 1 week.
31.
What's the rectification of subjection?
But we can repetition that I will come back, then the application for.
Some office subjects are there. No, 1 week. Yes. Yes. Who moved this matter? Who has moved this matter? ಯಾರು ಮೂವ್ ಮಾಡಿರೋದು ಇದನ್ನ ಮೆಮೋ ನೋಡಿ ಮೆಮೋ ಯಾರು You have moved this matter, madam. Why have you moved this matter? To take steps, you have moved the matter. Office issue notice is the requisite for me. Yes. Yes, some urgency was shown in this matter, therefore it was taken.
Yes, we moved the matter. The problem is not understanding that despite the fact that it is recognized as a corporate sector. And this not recognition was made in the month of September 2022. Objection statement between filed and existing response.
Before that,
The problem is the BJP. It appears not that handling.
first of all, what is the fair made injury petition? To consider the complaint by the BBMP. Report has been submitted.
There is no plan, let me say.
Because of R20, filed against them on 31/7/2022. Against the
You decide amongst 3 of you who is 1, 2, 3, 3, 2, 1.
Then I will make this.
Then we'll lend our ears.
The prayer sought that the court has directed.
Since he is a petitioner, proprietary warrants, he opened the argument.
So because I want some more time, so that's why I am submitting. See, the.
ಕೇಳೋಣ ಸರ್ ಅವರಿಗೆ ಅವ್ರ ಅವಗಾಹವನ್ನು ಏನ್ ಕೇಳೋಣ. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ರಾಜ್ ಕಾಲುವೆ. Who are you?
There is a road which will all lead to my home. This,
All road goes to your home.
this is the main road, not square. This is the only way of access. And what, if building is being done by the hands on the number four, without planning this center. The problem is this one, initially it was a gravel.
Where is his house? Where is your house?
But this is in Tipperary. Tipperary is a village.
Those construction is obstructing your right of access.
Right of access and not it is contributing the buildings. So, and it is an unsanctioned construction. We are really requesting the BPM to ensure that they take action and when we see what this start from September. Our representation starts from August. And actually, we are not 2022. Thereafter, there is a whole lot of altercation issue there. There are police complaints which have been lodged against them. For just trying to tell the BPMP to ensure that they.
Any other houses on the street except this? Any other houses on the street?
There are houses there.
They are all in compliance with sanction plan?
Yes.
They are all in compliance with sanction plan? None of them. Then why have you chosen him alone? Why have you picked him alone?
He is no, this is what the precise question which came up.
The old questions are condoned. Old constructions are condoned.
Yes, this question came up, I think, once before the Supreme Court in a matter.
No, we'll come to that later. We'll come.
Yes, yes. So what the Supreme Court said, this is the problem, what the municipality faces when new areas are brought into. So there are guidelines which have been issued. When construction is not, will have to be issued only after the plan side. In so far as all modifications are concerned, not, there are guidelines. In fact, Supreme Court has said that the CA software will have to be used for these purposes.
Yes, what are the guidelines?
Dealing with the Karnataka enactment, these guidelines have been issued. Statutory provisions have been listed at para 4. Then verse 6. They're almost in parametric with that. Then what? Para 15. 16, 17.
Yes.
About bill restrictions which are being ordered there. It would take 3 minutes, maybe.
Go ahead, go ahead.
Yeah, considering also that we cannot do of them, I think it is about these concerns, they have been respected without permission. That is, so even demolition is carried out without, the party was made without raising the construction without saying permission. We permitted to raise another legal structure which only has to be raised now after following the procedures described. Why should the nation then be misapplied with issue for raising a legal construction, which eventually has to be demolished? Make it clear that we don't have to be acting on the corporation or situation. Demolition is not following the procedure, right? The relief it has to be given must be according to law, not violated. If the structure is an illegal structure, you know that the demolition structure is not be permitted to come up with. The municipal corporation violates the procedure by demolishing the building, but the structure is going to be illegal, some compensation will be avoided. And in all cases where such compensation is avoided, the same will be immediately recovered in the office of acting building. How would we again reiterate that the illegal structure cannot be permitted to be created? Assuming that the structure is not illegal, then also the court will have to come to a finding that the structure was constructed legal. It was come to a clear cut finding as to the dimensions of the structure, what area it was covering and which part of the plot it was covering. Most of the high court got the conclusion that the structure which has been demolished was not illegal structure. It is rectified in permitted reconstruction of the structure, but by court was clearly indicated the structure it has been permitted to be constructed. What will be the length of the structure? What will be its width? What will be its height? Which side will be those which are the windows? How many numbers of stories are permitted? In most cases, the report may anyone to answer these questions. Therefore, it put it to permit the structure to be very according to the existing level. Direction can be issued to
issue liquid permission for construction of legal structure within time bound to 6 years. This may vary from case to case, depending on the nature of the structure and the area where it is being built. Blanket orders permitting re-election leads unplanned in habitat.
Who's for the private respondent?
Respondent number.
Private response.
Where's the sanction plan?
What happens? What I narrated in the statement of objection. This
Simple
is-
question, sir.
We applied because of the petition. Have been kept in pending. Please see my.
So without, you are constructing without sanction plan.
Please see my annexure R6. It was collapsed due to heavy rain. It is a old building, mud construction. Can you see my?
Where is the annexure R6?
R6, my alarming my statement of objection. The condition of the building, if one side has been collapsed, but can I wait for the sanction plan be from BBMP when it's very heavy floods? It is a old, the construction in the village. One, they are not my neighbors. They are.
ಇದೆಯಾ ಹಾಗೆ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಇದೆಯಾ
Illa.
that in these exigencies you can without even sanction can construct as and how you want?
Sanction plan, this is the village Gram Prana, now BBMP has come. Now the BBMP has not been issuing the, for the village Gram Prana properties are concerned. Honestly, we approach it. I am not the owner. It is in the name of my wife. My wife is not better than my party. We approached and submitted the plan also because of the heavy rain. It is in a dilapidated condition. Will I be demolished? Can you see the photograph, Parag? And the neighbors also have not been objected. They are very far away from my house. Either side is a road. I am not encroaching. The total area is 780 was.
Where is your present construction?
Present construction 670.
Page number?
675 square feet I have constructed out of 781.
ಎಲ್ಲಿದೆ? Where is your photograph present construction?
The photograph.
Sorry.
It is being constructed, even if you go correctly. Previous photographs have also been submitted.
No. We have stopped. I have stated in the statement of objection, we have stopped the construction. Only where the you are not.
We have also taken.
No, last petition you not.
What action have you taken, sir? What action have you taken?
See, actually, so the court has directed you to get the report. So report has been received.
Yeah,
So, but.
what are the reports?
Here, his allegation is, he has enclosed the road along with the drainage, but there is no drainage at all. The road has not been enclosed. The report.
Is there a sanction plan, sir?
No, not yet, madam. So even the petitioner also put up constructions about 6 months back, about 3 to 4 years, not furnished even his plan. So if he has put up construction in accordance.
We don't appreciate this argument. We don't appreciate this argument, Mr. Counsel, from an authority.
That is.
We don't appreciate
He
this.
also.
Come here, sir.
Every.
Your good name?
PM Secretary.
Mr. Venkat Reddy. We don't appreciate this argument.
That
We are
is-
asking you the simple straight question.
Yes, but I have received the. So
Yes,
that's
when
why
are you
last
taking,
case,
when are you taking action in this matter?
That's why in the last case.
When are you taking action in this matter, sir?
Sir, I will find my detailed objections. I have received the.
No objections. When you say there is no sanction plan, what objections are you going to file?
So I will take a minute. I will by filing along with the objection. So even 2.2 also
Tomorrow.
issued.
Tomorrow,
One submission.
tomorrow.
One submission. I'll find it right now.
We don't appreciate this, Mr. Venkat Reddy.
So even he has not put up.
Submitted the plan, but thank you.
So,
My wife.
The authority also trying take action to permit the plan by the petitioner. So already we have taken action. So thereafter I have received the report. So along with the report and what action taken, I will file my counter affidavit or statement of objection in detail.
Where is this construction happening? How far it is?
Even.
12 kilometers.
It's a Gram Prana property, construction somewhere in your name.
Entire village.
This is why.
Therefore, my lord, they have stopped the construction.
We are surprised with the action and the reply being made by the authority.
Please, my lord. They made a complaint. All these
And they seem to be holding your brief in this matter, Mr. Council. Authorities seem to be holding your brief.
Please, my lord.
Action taken, report by next Monday.
Yes.
Very, let the council for the rest. BBMP alva. Then the council for the BBMP submits that direct pursuant to direction issued by this court, inspection is conducted and it is found that the entire construction being put up by the respondent number 4 is without the benefit of sanction plan. And that he would be submitting action taken report in this matter by Monday. Yes.
The petition have been affected by the virtue of this construction. That also report will be submitted because where they are.
Next matter, your next matter, next matter, next matter.
No, sorry. Only before.
Next. Next.
Interior work we are carrying out.
Next.
Other side, there, the BBMP has to submit the report with regard to.
Council, we have asked them to take steps. They have to come with the report by next set of hearing.
That's right, madam. There, they are deciding, that is very important because of the police supply. With this FIR has been filed in the month of July, personal immunity.
Next Monday.
Number 34, the Amrutesh speak.
Probably to be incorporated in the internal and external part of the bank.
We'll see on Monday on this.
This is Ramatana village,
Venkat Reddy. We don't want to say this, but then you are constraining us to say this. You must uphold. You are there, you are appointed, you are constituted under the statute to uphold these rules, not to justify the illegal construction. Very sorry to say this.
Not only petitioner, anybody.
Of course. They should take action. That's why we are asking them to take action.
I have already taken action, I will permit after.
Don't encourage this. Yes. Yes, sir.
Why annex the build, operate and transfer of the knowledge or given to the petitioner. This is for the 20 years legal. In the meantime, they have given the notice due to some political local people. I have answered Annex C is my answer. Annex C is.
In office subjects is Amrutesh. Some office subjects is
I have completed everything. The dispensation I have filed and the legible copy I have, typed copy I have filed. Everything I have completed. That's why.
What is office subject?
Only annexer.
Copy BPMP serve madilla.
Other than because of that, we have moved it of the earliest. And the board gives the direction that only they this local body is not happening. The office of vision they are writing down. KSSIDC, BBMP, BDA. Let's get see, I have properly prepared 49 and 59. Even without the notice.
What is the relief you are seeking to Annexure A?
Annexure A is my agreement of 20 years lease. That is, you are not to kindly see in the page number 23.
Correct.
Agreement is there, 239 months.
Yes.
My agreement started only in the year 2009. 20 years lease is there. I have constructed the in my own mode.
Where is 20 years lease in the relief?
That is page number 23. Page number 23. 2. With a left with agreement period.
Yes.
Left. Immediately hereby interest to concentrate with the task of carrying the activity set out in the Article 4 of this agreement for a period of 239 months from the applicable date. The agreement period provided that in the event of termination, In the next clause, my lord.
Termination is also provided.
Yes.
It is not absolute period of,
That is 21.
why was, so what's your grievance now?
Notice.
Annexure D. ಏನ್ ಹೇಳ್ತಾರೆ?
Number 51.
ಹಾ.
ಇಲ್ಲಿ is all the other functions are notice that are 52 or
ಹಾ.
52 and already. Ullogena notice. They have given a start for the 51.
No, we didn't follow what you're saying, referring to page 53. Really? You refer to page 52 and said something. What is that?
52 reference ಅಲ್ಲಿ the reference 5, 6, 7, 8. The other ones who are running in the Congress.
ಹಾ.
My name is A.K. Mishra, Akhila Bharata Parivarana, Evam Gramina and Pakistan, village number so and so.
Huh.
Even notice.
No, what have they done now?
Now they are governing it. Another person will be.
Have the terminated agreement annexure A?
By this order they have done.
Where does it say?
This is the.
ಎಲ್ಲಿ ಹೇಳ್ತದೆ? Read which portion says that the annexure is. Yes.
51.
ಹಾ.
ಆದೇಶ ಮೇಲಿನ ಪ್ರಸ್ತಾವನೆಗೆ ಈ ಗಣತಾಂತ್ರ ರಾಜ್ಯ ನಿರ್ವಹಣಾ ಕೋಶ ಗಾಂಧಿನಗರ ರಾಷ್ಟ್ರೀಯ ವಾರ್ಡ್ 109 ರಾಷ್ಟ್ರೀಯ ಜನಖಂಡ ಅವಧಿ ಮಾಡಿ ಉಪಯೋಗಿಸುವ ತೋಟಗಳನ್ನು ಜನಖಂಡ ಪೌರಕಾರ್ಮಿಕರ ಮಕ್ಕಳಿಗೆ ನಿರ್ವಹಿಸಿ ಮುಂದಿನ
ಹಾ.
This is the allotment. Next page is the allotment.
ಹಾ.
Then there is this are.
Correct. Cancellation ಎಲ್ಲಿದೆ sir? Where is the cancellation?
ಹಾಲಿ ನಿರ್ವಹಿಸುತ್ತಿರುವವರು
ಎಲ್ಲಿದೆ ಹಾಲಿನ ರಿಜಿಸ್ಟರ್? ಸೆಕೆಂಡ್ ಕಾಲಮ್. ಎಸ್. ಅದ್ರಲ್ಲಿ ತಾವಿದ್ದೀರಾ? ಎಸ್. ಸೊ ತಮ್ದು ತೆಗೆದ್ಬಿಟ್ಟು ಯಾರಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಇವಾಗ? ಎಸ್. ಎಸ್ ಬರ್ಕೊಡಿ. ಬರ್ಕೊಡಿ. Case of the subject of compliance office objection. Heard and counsel for the petitioner. It is a case of the petitioner that he was issued with a contract as per annexure A for the purpose of construction, maintenance of pay and use public toilets at Bangalore for a period of 20 months, 20 years. And that the said period of 20 years would expire on ಯಾವಾಗ? ಇದು 2010 ಇದು ಜನವರಿ ಹೌದಾ? January 2009 2030 ಆಗುತ್ತೆ. And the said agreement is still valid and subsisting. That being the case, the responsible authority without any notice or opportunity or any opportunity, the petitioner have issued annexure D work order in terms of which the ತಮಗೆ ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರು? ಅದು that was to be operated near Belli Basavana temple is it? ಅಲ್ಲಿ ಮೇಲೆ was what is the contract to construct maintain pay toilet at Belli Basavana temple road Mamulpet. Full stop. ಅದಾದ್ಮೇಲೆ ಕೆಳಗಡೆ is current and that means without any opportunity the petitioners have cancelled the said contract and have now allotted the same to one Chinnamani. ಅವ್ರಿಗೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ರು ಚಿನ್ನಮಣಿಗೆ? ಅದು ಉಂಟಲ್ಲ ಚಿನ್ನಮಣಿ ಅಂತ ಹೇಳಿ, ಚಿನ್ನಮಣಿ ಕಬ್ಬನ್ಪೇಟ್ ಬೆಂಗಳೂರು. one Chinnamani Kabbanpet Bengaluru without even providing the details of his address, thus constraining the petitioner to this court. Yes, I'll make an issue notice happily. Issue notice so and so. There shall be an interim order of stay of annexure D till next date of hearing.
So far it relates to petitioner, because there are 6 now.
As regards is related to petition. How the other? Don't go anything. Yes. Annexure D is the extent of the petitioner. Here, case of the petitioner. Yes.
Number 31.
The office objection complaint ಮಾಡಬಿಡಿ.
I think this matter David for yesterday. It appears that on the last occasion, this honorable court has directed to file a status report regarding the deviation in respect of the petitioner's building. Not received the instructions as I have yesterday I have instructed them. Kindly, it may be kindly taken on Tuesday.
Yes, Sri Chidanand Peel and counsel for the respondent 1 and 2 submits that he is yet to receive the report directed by this court on 7/11/2022 regarding status of the construction. Is time
Tuesday.
yes.
My name
Let's
is, my name is deleted.
has to ask name of CMC, Miss MC Nagashri we deleted. List this matter on 23rd.
There was a mark of status for minutes protecting minutes, the possession of the petition. Now, minutes, the previous petition, the parts, there's no interim minutes protecting the possession of the petition. I would request minutes, till they file minutes, they have said that minutes they are doing on Tuesday, till such time minutes later the summer.
What protection?
Minutes, now minutes, the matter responded Tuesday, minutes, either on Saturday or on Sunday. If they were to try to dispose of the minutes, I will without any remedy.
Why will they dispose? You are in possession now.
I am in possession of the property.
Occupied, according to that petition, they are. It appears
Yes.
that they are occupied.
What interim protection you want?
But it's better not very precipitative action. Now that not confirmatory orders passed, that not was challenged in the appeal.
We have asked them to furnish the report, that's all.
Minutes, if I may submit, even when there was an order, still they are trying to precipitate the matter, they are trying to disconnect the matter connection, they are trying to.
Yes, but it is made clear that the respondent shall only furnish the status report and shall not take any precipitative action against the petitioner till next set of hearing. Yes.
36.
The illegal construction is going on. The white annexure A is the sanctioned plan.
Tavyaru,
And the resident adjacent to that is building. The conservatory itself is they have to. In page number 15, the plan. The first floor plan was also mentioned. Center of the site, the staircase is there. When I come to the page number 18. 18 and 19. The staircase is, they are shifted directly to the left side of the building, and thereby they have occupied the back conservancy where they at least 2 wheelers are going. I am going to reach my house to the back side, backyard. This is the illegal.
issue notice to the respondents. Stay of construction till next set of hearing. With the respondent number 4.
37.
This will not wait once of the party. That's how your daughter has been given the clarity to the PG. Also, they will come with some other story.
Let's set the better.
Yes. But it should be very quickly they have.
Yes.
On the food part. And that is being made by the second respondent without any permission from the commission.
Yes. What happened?
I have lost it, according to informant, he is right.
He's right, but what action are you taking?
As for yesterday, we have gone there, we have requested them to stop the construction. Accordingly, they stopped, but they asked where is the court order. But accordingly,
Why if you do want, why do you require court order? You are a statutory body.
of course,
Why you require a court order?
then they told them not to put up any.
So who is powerful? The person constructing, they're powerful or statutory body powerful now? Yes. That counts for the respondent number 1 submits that an inspection they have found the construction being carried on by respondent number. ಅವ್ರು ಬರ್ತಾ ಇಲ್ವಾ ಕೋರ್ಟ್ ಮುಂದೆ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಕನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತಿರೋದು?
Number 3 to 5.
Respondent number 3 to 5 encroaching upon the road, road margin. That counts road margin. Okay. Respondent number 2 construct ಮಾಡ್ತಿರೋದಾ? ದಕ್ಷಿಣ ಕನ್ನಡ ನಿರ್ಮಿತಿ ಕೇಂದ್ರ. Oh, this is ತಾವೇ ಮಾಡ್ತಿರೋದು. Deputy Commissioner Office is doing this. And you are asking a court order. This is mockery.
Any sanctions are there, approved, then only can go ahead with the work.
We don't know. The right hand is saying, showing the mirror to the left hand. Pass over. Nodi, direct them to take instruct ಮಾಡಿ ಅವರಿಗೆ pass over. Private party ಅನ್ಕೊಂಡ್ರೆ ತಾವು DC ನೇ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಹೇಗೆ? ಅವರೇ ಕೇಳಿದ್ರೆ ಇದನ್ನ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ he asked court order. ಕೊಡಿ copy.
Number 38.
I prefer the respondent.
Endorsement. Rectified and final separate endorsement is issued. Based on that, I have filed an application for amendment of the petition.
ಏನು? What was earlier? What was your petition for originally?
I have applied for allotment of site.
ಏನಾಯ್ತು?
In 1985,
Ah.
I have attempted 9 attempts. But before constitution of the MUDA, Mysore Urban Development, 3 attempts, it was deleted and 6 attempts are undisputed. But further, respondent has said only 5 attempts we have done. And according to the seniority list, they have cut off date 1945 to 47, so therefore we are not eligible. There is no statutory limitation of regarding the work is age is concerned under the statute. So that is I have challenged. And the 6
age ಇದೆಯಾ? To seek site there is a age limit.
There is no statute.
Where is it?
Under the MUDA, there is no.
Where is endorsement to say that there is age limit?
Can you see election P in my trial?
P. Page number ಹೇಳಿ sir.
Application and amendment. Amendment application.
Amendment application. Amendment application seem to be. Amendment applications seem to be heavier, larger, bigger than their original petition itself. Then why don't you file a fresh petition itself?
Subsequently, 2017.
Have
you filed your objection, Mr. Counsel, for this?
That's IA for amendment, my lord. I have not received the hard copy. I have received the soft copy, my lord, without the annexures. That's I'll file my objections to the application.
Annexures ಕೊಡಿ sir ಅವರಿಗೆ.
They have filed. They themselves have filed the additional statement.
ಅವ್ರ ಹತ್ರ ಇಷ್ಟೇ ಪೇಪರ್ಗಳಿದ್ದಾರೆ ಆಫೀಸಲ್ಲಿ? ಅಲ್ಲ, ಇಷ್ಟೇ ಪೇಪರ್ ಇದ್ದಾರೆ ಆಫೀಸಲ್ಲಿ? ಅವ್ರ ಆಫೀಸಲ್ಲಿ ನಿಮ್ದು ಒಬ್ರದೇ ಪೇಪರ್ ಇರ್ತಿರೋದಲ್ಲಿ ಕಾಪಿ ಕೊಡಿ. ಆ ತರ ಎಲ್ಲ ಸಬ್ಮಿಷನ್ ಮಾಡಬಾರ್ದು. ಅವ್ರದೇ ಪೇಪರ್ ನಾವು ಕೊಡಲ್ಲ. ಸರ್ವ್ ದ ಕಾಪಿ ಸರ್. ಅವ್ರದೇ ಏನ್ ಹಂಗಂದ್ರೆ ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ. Counsel for the petitioner is directed to serve the copy of the application along with the documents enclosed therewith on the counsel for the respondent. This matter date ಕೊಡಿ.
28.
Yes, 28.
Please apply.
39.
Clever. ಏನಾಯ್ತದು? 5 ಎಕರೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
No, my lord, nothing.
Lord, I appear for the petitioner in this case.
Yes.
Sorry,
Yes.
I had some outside
No, no,
matter.
no
I-
problem.
My lord, this is a case, your lordship adjourned this matter for today.
Yes.
Only for the purpose of limited issue.
Ilvante, they are
What
not,
is
they
the
are not
stage
reserved.
of the,
They have not reserved, they have not passed any such resolution ante.
there is a meeting which has been conducted and the minister
Yes.
has agreed, but
Yes.
steps have not been, we have got meeting proceedings.
Yes.
Anyway,
we
your
will
lordship
take
may
the
have
matter
it
merits,
on
yes.
some other day, my lord, so that
They will take up the matter merits.
they will
yes.
have to take steps.
Assistant Title C, first, prayer of the petition. Issue mandamus directing the respondent 1 to 3 to comply with the rules framed by the state government dated 12/6/19 and implement the direction of the honorable Apex Court. So far as this is concerned, throughout the state, we have formed the committees.
What are the details, sir?
Even the BBM.
Give those details, committee details.
Yes, I have it, my lord. I
What
take
is
it
Mugitu, then what is the next prayer?
That is the first prayer.
Not to evict the
Yes,
petitioner.
not to evict the petitioner.
If you are constituted and yes,
Now the BBMP and the state government. We have
no,
already.
you need to give us the scheme formulated by you in terms of the guidelines of the Supreme Court, number one. Number two, if you are intending to take action against any of those petitioners, give the details as to why and how. That's all.
Yes.
We'll dispose of the petition.
Please.
Yes. List this matter on ಯಾವಾಗ ಬೇಕು ತಮಗೆ
First petition, concern, my lord,
ಕೊಡಿ ಎಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ.
second prayer, the BBMP.
No, both work in tandem and furnish. We will not ask them piecemeal and to you. Either of you, ಅವರು ಬರೋದಿಲ್ಲ, ಒಬ್ರು ಬರೋದಿಲ್ಲ. ಯಾರ್ಯಾರೋ ಬರ್ತಾರೆ.
My lord, they will have to identify the zones, my lord.
We have made it clear to them. Your first prayer is for the
Please.
direction to implement the Supreme Court order. Let them give the details as to what the committees, what the course of action adopted by them.
Please.
Second is concerned, let them give, if they are taking any action, any of the petitioners, why and how and when. Yes, list this matter.
Second or third.
Second, yes.
Second.
My lord, third, my lord. Second, there is one
Third,
SL.
okay, third.
Please.
Third, ರಜೆ ಇದ್ದಂಗಿದೆಯಲ್ಲ?
Fourth.
All right, fifth ಹಾಕೊಳ್ಳಿ.
Fifth.
Third is
Please.
Saturday. Yes.
Seventh party.
What is matter?
Cancellation of cost, America can't exit. And I feel the act.
Who are you?
And the respond number 7.
ತಮಗೂ ಏನು ಅವ್ರಿಗೆ ಸಂಬಂಧ ಏನು? What is the property? Letter complete. Yes, go ahead. So what is the measurement of site? 50 by 75. This is your site. Correct. ಇದು ನಿಮ್ಮ ಜಾಗನಾ? ಏನಾಯ್ತು ಆಮೇಲೆ? Is there any civil suit pending in this matter? Yelli. What suit? Who has filed the suit? Suit number? ತುಂಬಾ ಇದೆಯಲ್ರಿ. Come to page number 11. The entire page is filled with the OS numbers. Who has filed this OS number 25? That is your opponent. For what?
For the possession, for the declaration.
There's one more suit filed. What is this? 25537 of 2018. 25552 of 2018. What are these suits? And again, there is one more suit, 25553 of 2018. What is this suit? Same property. Huh. What happened to these suits? Alright, what are you asking in this? When was Khata made?
But it's a preliminary that was not for number 70 being acquired by a preliminary notification dated not 4/1985. Preliminary notification by the BDA. Final notification 22/9/1986.
Preliminary notification was
4/1/1985.
85. Yes.
Final notification 22/9/1986. Possession was taken by the BDAR during 1992. This site, which is site number 7, which like petitioner, being acquired by the society, being acquired by the notification. Everything is finalized. She purchased the property on 2/1995. Everything is over.
1995.
Subsequently, the society, the BDA has approved.
He purchased from whom?
Purchased from the landowner.
Whether the landowner name was notified in the notification?
It was notified. Possession was say.
What was the name of the landowner?
That
Kamlabai.
Her name was notified and award is being passed.
Yes, this is the award.
Possession was taken. BD approved the layout and site was 657 was also released. Subsequently, the society issued possession certificate in my favor. Thereafter, we can issue Khata license. We are putting up the construction. Now they start to cancel my Khata license and appeal is provided under the Act, BVP Act. If they have any reverse secondary Khata license, they have to approach the commissioner under 6 months BVP Act. Without that, not they approach before the Supreme Court.
They also filed a suit, no?
She also filed a suit.
What is the suit filed by her?
Suit for injunction. Entry protection was also suit for injunction she filed. And the court, the district court passed an order not to put up any concession against me. It is operating. We are not putting any concession.
Yes, purple. Present petition is filed by the petitioner seeking following relief. It is a case of the petitioner that you are done well. No, you are done well. Don't worry. You are done very well. Following relief. It is a case of the petitioner that she is the absolute owner of a property being site number 17. Site number 17, measuring 50 by 75, having purchased the same in terms of registered deed of sale dated 2/2/1995 from one Krishnamma, that ever since the purchase, the petitioner has been in possession, enjoyment of the property, and have been paying the property tax, said property, and she has also got all the connections of water and other amenities. That during 2008, without notice to the petitioner, 6th Respondent Society had filed a petition WP number 10054 of 2008 against the second respondent, seeking issuance of the work order and release of sanctioned modified layout plan relating to an extent of 161.08 acres in various survey numbers of Kodiganahalli and other villages, on the premise that the said lands were acquired in terms of a preliminary notification dated 4/1/1985 and final notification dated 22/9/1986. That a layout plan was prepared by the society in respect of 184.1 acres of the land and was submitted for approval in the month of March 1992. But since the BDA did not approve the said layout plan up to the year 2008, the petition was filed. That taking advantage of non-formation of the layout in the said land, actual owner of the land, including the owners of land in Survey number 17/3 and 17/6 of Kodigali village, had illegally alienated the said land in bits and pieces. And the petitioner herein has also filed a suit in voice number 1297/2020, seeking relief of injunction against the sixth respondent here, seventh respondent, in which an order of status has been passed.
Injunction was passed.
Injunction order. Hello, the petition. Suit decree agidya.
No. Okay, interim relief.
Interim relief of injunction has been passed. Society and respondent, full stop. That in the meanwhile, khata agidya or hesrigivaga. That when the above being the factual position, the BBMP has clandestinely registered the khata and has issued building approved plan in front of seventh respondent, which is per se illegal and arbitrary. Hence the petition. Then counsel for the respondent number 7 on the other, so and so, note done, appearance so and so submits that the subject lands, including the land being claimed with the petitioner, put it like this, site being claimed with the petitioner forms part of the land in Survey 17, which is part of the acquisition made in the year 1985 and 86. The original owner of the land, Limari Krishnamma, has received the compensation, has received the award amount issued, given to her in lieu of acquisition of property. That being the case, the claim of the petitioner having purchased the property in terms of a deed of sale dated 22/2/1995, per se illegal, unsustainable. And he submits that the layout has been formed and the sites have been allotted to various prospective purchasers. However, since the suit by the petitioner is pending consideration, the respondent hearing has not taken any action and has abided by the interim order passed with the court. Any action that will be taken by the respondent number 7 would be subject to outcome of the said suit pending consideration before the trial court. Any action that would be taken by respondent number 7 in respect of the property in question would be subject to outcome of the pending suit in voice number.
That one submission. The interim order was passed, it was confirmed, the charge before the MFT. But MFT revert the annual court for
Suit pending alva.
Suit pending, to revert back for fresh consideration.
Just
Not
outcome of the suit here is
the interim order, the interim application. Interim application still pending for the consideration by virtue of the order.
Yes, in Pradramali. Any action that would be taken.
By respondent in respect of property in question would be subject to outcome
of the orders that will be passed in the said suit. Full stop. Learned counsel for the respondent 7 further submits. You have BBMP Garu. Then counsel Sri Murlidhar and counsel the BBMP submits that there is an alternate remedy of review under section 114. 150 150 of BBMP Act is provided, and as regard the grievance against issuance of plan is concerned, section 253 of BBMP Act provides for filing of appeal. Therefore, he submits that the petitioner may be directed to avail such alternate remedy. Submission taken on record. Heard counsel for the petitioner and the respondents. Peruse the records. It is not in dispute that the subject land being site measuring 50/75 being claimed by the petitioner is subject matter of a suit invoice number 1297, in which an interim order, in which an application for interim order is pending consideration. And counsel for the respondent, number 7, fairly concedes that whatever be the outcome of the orders that may be passed in said suit, they will abide by the same. Then counsel for the BBMP submits that the petitioner has alternate remedy provided under section 150 and 253 of the BBMP Act with regard to registration of khata and issuance of sanction plan. In view of the above, factual, in view of the above factual, in view of the above factual situation of the matter, petitioner, petition is disposed of, directing the, reserving liberty to the petitioner to avail remedy available under law as noted here in above. It is made clear that the respondent number 7 would be entitled for the property being claimed by the petitioner, subject to outcome of the orders that may be passed in the pending suit. Yes.
41. The instance of responding to one matters. Without any where I pointed out that into notice has been issued, it's not in the manner noted. And it was stated in the into notice that there is a direction, therefore we are directly to demolish the construction. It is what it put up. And within 7 days, there is a direction. And last time it was pointed out that there is no such.
Yes.
Respondent number 2.
You are seeking.
Yes.
Page 19.
Yeah. Just a minute. What is this annexure A?
Annexure A. The respondent number proceeded on the premise that there is a direction of this code to demolish the wall, failing in which ಕಟ್ಟಡವನ್ನು ಸಂಪೂರ್ಣವಾಗಿ ಪಂಚಾಯತ್ ಜಪ್ತಿ ಮಾಡಿಕೊಂಡು ಸುಲಭಗೊಳಿಸಲಾಗಿದೆ.
ಎಲ್ಲಿದೆ ಆರ್ಡರ್?
Section 2, page number 51.
51.
Yes.
Yes.
Relevant paragraph is that paragraph number 2, page 52.
Yes.
What instruction report was read? Based on what instruction report, paragraph number 3 is the direction.
Yes.
What the office court has held is that the approach of the respondent is bound to consider the representation of the petitioner. The approach based on the action as listed under. The impute notice indicates that the mayor has directed him to remove the law. Where no opposition of hearing has been granted.
What's your apprehension now?
Please, madam.
What's your apprehension?
Well, so my apprehension is this. Well, the respondent number 2 has earlier filed a suit against me and other family members for partition. And it was claimed by the respondent number 2 stating that I am a tenant under the. The trial court has framed the issues and held against him, holding that I am not the tenant under the respondent number 2. That is judgment is second final. And apart from that, since he was interfering with my properties concerned, I also filed a suit for injunction. The injunction suit was also declared in my favor. Now, when respondent number 3, when I made an application before the respondent number 1 panchayat for seeking permission to repair the building, the same was objected by the respondent number 2.
What happened to your suit?
Please.
What happened to your suit for it?
That has been decreed. That has again finality. And when I was just point out, what had happened was I made an application seeking repair of the building. That was objected by the respondent number 2 on the ground that I have no right to over the property. Pursuant to the objection raised by the respondent number 2, the endorsement was issued by the authority holding that.
This is called recalling the photographic memory.
Yeah.
This is called recalling the photographic memory. Yes. Yes, go ahead.
Endorsement was issued on the ground that I have not produced title documents. That endorsement was partly questioned by me in the registration.
Is it required that a person seeking construction or modification should prove his title?
Yes, that my notes sir. This court has already held that.
Illa. What's wrong?
I will make submission because
I think.
Would you like to?
Two things. There is no order at page number 53.
53, yes.
53, there is no order to take action of demolition.
No.
You may have to consider his representation and pass orders in accordance with law.
Yes.
Which would be permitting him to put up the construction or refusing to put up the construction. Either of it.
Yes, what he has done is, what was permitted was to carry out the repairs. What was permitted was.
Where is it?
My lord, kindly see my statement of objection to the application for vacating.
Application for vacating. Put it.
Yes. Annexure R1 may kindly be seen.
Annexure R1, yes. Page number 8. Yes, Kelly.
My lord, to this, the respondent number 2 is not a party to this petition, but the panchayat is a party. Para 2, the learned counsel for the respondent gives an undertaking before this court that in case an application is made seeking for permission to carry out the repairs of the property in question, the permission will be granted by the respondent within 2 weeks from the date of receipt of the application.
You are for the private respondent in this.
Yes, I am not a party to this.
No, in this petition, you are for a private respondent.
In this, yes.
Present petition.
Respondent number 2.
Yes.
That is the owner of the property.
Yes.
My lord, the writ petition was disposed of. After that, my lord, then there was a report called for. I have placed the report of the respondent number 2 along with a memo. Would your lordship kindly that is submitting report
Yes.
in WP 30042, madam. Your lordship has
R2 is an application endorsement issued by the panchayat.
yes,
R2.
respondent.
Tama respondent. Annexure R2, page 11.
Yes,
Wherein they have declined to give the permission to carry out the repair because he has not put the ownership.
yes,
Correct? That
Yes.
panchayat has declined.
yes.
Thereafter,
Then
He
he
came and
filed the
repeated.
writ.
Heli.
The endorsement was issued, then I came to this. Before this, in the writ proceedings, my lord, an undertaking was given by the panchayat, stating that if an application is filed, they would grant a permission. Page number 48.
48.
Yes, yes.
That's the same order, Annexure R1.
Yes. Then what
Yes,
happened
yes.
is, I made an application. Then my lord, after filing an application, my lord, they had granted me permission to proceed with it. Then my lord, my opponent, that is respondent number 2, again objects for that for granting an endorsement. Then later, my lord, panchayat has withdrawn that endorsement, granting permission in favor for repairing it. Pursuing a withdrawal of the permission, which is the order which is passed by the panchayat, again it came in use. That in that order, my lord, this one report, I draw my note attention, my lord, that order, which I placed around, my lord, page the memo dated 3rd August 2022.
Yes.
My lord,
Yes.
in that, my lord, this report is called out, the area is the.
Yes. Yes. Yes.
My lord, sir, in that. Para number 4, page 5. I was present respondent number 2. The second respondent and his family members are filed as proof before the civil judge in Madikeri for partition and separation.
Yes. It has been held that he is not justified in opposing the construction.
Yes. Now, my lords, again, my lords, this court has also, at para number 7, has found out the invitation which was granted in my favor.
And hold that he doesn't have
Yes.
any justifiable reason to prevent the construction.
Yes.
And also hold that you cannot take this as a title confirmation title in your
Yes.
favor. Yes.
Now, my lords, the endorsement which was the withdrawal of endorsement was passed, and the panchayat was directed to consider fresh.
Yes.
My lord.
Yes.
Subsequently, I have proceeded to put up to proceed to repair the building.
Ah.
Again, it doesn't fit part. He again gives a representation to the panchayat, holding that I have violated the condition that I have put up the wall instead of repair. Since the representation was not considered by the authority, again it will further expedition before this court. In that expedition, my lord, this is a direction which is taken by this court and we will be part.
Yes.
In the writ proceedings, my lord, the court inspection was directed and inspection report was. Pursuant to the report, my lord, this court has directed to consider the proceed in pursuant to the report proceed in accordance with not directed. No, my lord, on the premise that my lord, holding by misinterpreting the order of this court, my lord, that is the issue of remove. All that I am requesting, you may an opportunity to file my objection. Whatever the report which is submitted,
Yes, Barkoli.
My lord, one submission. My lord, I could read the mind of the court, how it's proceeding. Just for a minute, would your worship kindly see the memo filed by learned print in which paragraph 7, it reads, I will just read. Therefore, the first respondent is not justified in stopping the petitioner from preparing the shop in question. After that, the report was called for, that is also before the court, in which it is the report by the chief officer inspected the building which is in possession of R3, found that R3 has not made repair of the building, but has constructed the fresh wall on both sides.
What is the meaning of repair? What
My
was
lord,
sought to be
repair,
repaired?
my lord,
What
repair,
was sought to be repaired?
my lord, the
What
application,
authority?
repair,
Authority. What was sought to be repaired? What did you permit him to repair for?
we learned that the building has to be repaired, what appears to have happened.
Where is the order of repair, permission to
It's
repair?
not a, but can you see not the annexure 890? The first not relate the one, three lecture in the company affected to the village, should have to, but the Anumani in a large road, Shaka, equal to Naku, get some.
Eಲ್ಲಿದೆ?
That appears to not see permission given to repair.
Correct, sir. We are asking the simple question. What is the meaning of repair? Setting, removing the bolt and nut, or really putting up some construction for to retain the building?
Certainly, but repair would mean not.
Or removing the tails and replacing the, what is the repair by, what do you mean by the repair? You are the authority.
Whatever.
And on what basis you say that repair is not considered, wall is considered, what basis?
But they appear to give some conditions given in this,
Where? Appears means where? In the air.
I need time. That has not
No
been
time.
placed on record. But I will place this permission on record. This is a permission of 2016 that has not been placed on record by either the petitioner or.
You are the authority.
I am the-
You are a party here.
I am a
You have been a party to all the proceedings. You had to give an undertaking before the court earlier. If he makes an application, you permit him. Then why you are blaming on them?
No, I'm not blaming him.
Ah.
All I'm saying, is not, let me not inspect this permission. What appears to have happened, not they have gone beyond the permission and put up a new construction, it's coming from the report. Report called out in this on the report's order. Let me not inspect whether the conditions have been violated. Now, till then, not I won't take any action under annexure 8. Let me not furnish some details.
Perfect.
That's all I find my objection.
Heard petitioner, the response of the petitioner and the respondent. Peruse of the records reveal that the petitioner was permitted to carry out the repair works to the settled premises, subject to obtaining the permission from the respondent number 1. It is alleged that in the guise of repairing the permission building, the petitioner has put up the wall. However, it is not clear from the records. And the counsel for the respondent is also, respondent 1 is also not able to point out as to what was the permission granted in favor of the petitioner to, and what was the repair contemplated in the permission. We'll stop. The allegation therefore is that the petitioner has put up the wall instead of carrying the permission, cannot be comprehended. Now the counsel for the respondent number 1 seeks accommodation to produce the order oblique permission granted to the petitioner to carry out the repair work and to make further submission in this regard. He also undertakes not to initiate oblique take any precipitative action against the petitioner pursuant to annexure A till next date of hearing. Yes, submission taken on record. List this matter on. Yes. You clarify what is repair also.
First week of December.
Oh, the first week of December.
Appearing for respondent number 4, your lordship.
Yes, what is this matter?
See, a madam is taking with her, remove the obstruction from her door. The responsible for it, limited is right.
Who are you? Who are you?
I'm a company who constructed a layout there.
Ah,
I have two sanctions and there.
ah,
I have 3 and I have 3 of these. Number 53/1, 64/2 and 67.
ah.
And with the north side of 53/1 and western side of 67, there is a road that connects and goes to my property. No, that the respondent one and we relinquished it rights. I also a relinquishment deed, which he has which was that time 2012 annexure D. So now the respondent one, despite having relinquished the rights, he has put up proper works and put up gates both connecting and which is running through my property. And those are the only two ways which allow me and access to any visitor.
Yeah, for the authority.
Based on my lord, we have complained, my issue the notice, should notice to the respondent number 4, my lord. Meanwhile, my lord, they filed a suit, my lord. OS number 44, 8 of 2022, my lord.
Who?
My lord, respondent number 4, my lord.
What suit they have to file? What injunction? Against whom?
Against my lord, respondent and also my lord petitioner.
On what basis?
Looking for my lord, there, the road is because of the that we are only in some, where is that my lord? The road is including all the respondent number 4 level, sir. The road is belongs to the only respondent number 4 level, sir.
Where is the sanction plan?
The sanction plan is my lord, annexure.
Who's for the respondent before?
Appearing for respondent number 4, your lordship.
Yes.
Your lordship, we request 2 weeks time to file our objections, your lordship.
No.
But also final sanction plan will be 85.
In respect of my lord, annexure fees, my lord, in respect of the respondent number 4 is concerned, my lord, they have the plan and commencement certificate.
Page number?
Page number 80.
Which condition is violated, sir?
Annexure, my lord.
Where is your property?
My property is survey number 53 for 1. The right side of the sanction plan was right on top. 53 for 1. And then to the right.
You don't have any other way to go to your property?
That road goes through my property.
So through is fine, but you don't have any access road otherwise? You don't have any other access?
Those are the two main entry points to my house.
Why can't people get the question and answer straight? Do you or not have an access alternative?
Road is not linked to the planning authority. There is no role on this for the respondent. Meanwhile, my lord, file a suit. There is a my lord, we have issued notice to the respondent number 4.
What has happened to the suit?
Suit pending, my lord. The order 29 4 29 for orders.
How can a suit be maintainable on this?
We have
You are allowed them to file a suit.
No, my lord, we have filed that statement also, my lord, now, my lord, voted for orders, my lord.
No, what is the condition of sanction?
And see, my lord, next year, see, my lord.
Yes.
Lord.
Really?
Right, my lord, my lord, right, page number 82, my lord. Item number 3, ವಿನ್ಯಾಸ ಪ್ರದೇಶದ ಪ್ರಾಧಿಕಾರದ ಅನುಮೋದನೆ ನೀಡಿದ 24ನೇ ಒಳಗಾಗಿ ಸಂಪೂರ್ಣ ಉದ್ಯಾನವನ ಆರೋಗ್ಯ ಸೌಲಭ್ಯಕ್ಕೆ ಮೀಸಲಿಟ್ಟ ಜಾಗ, ರಸ್ತೆ, ಒಳಚರಂಡಿ ವ್ಯವಸ್ಥೆ, ನೀರಿನ ಸೌಕರ್ಯ ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ತಪ್ಪಿದಲ್ಲಿ ಅನುಮೋದನೆ ಸೂಚನೆ ಇಲ್ಲದೆ ತಂತಾನಾಗಿ ರದ್ದಾಗುತ್ತದೆ. ಮಾರ್ಪಡಿತ ವಿನ್ಯಾಸ ಸೂಕ್ತ ಕಡೆ ಪ್ರಮಾಣಿತ ರೀತಿಯಲ್ಲಿ ಸೀವೇಜ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಪ್ಲಾಂಟ್ ಅನ್ನು ಸ್ಥಾಪಿಸಬೇಕು. ಕರ್ನಾಟಕ ರಾಜ್ಯ ನಿಯಂತ್ರಣ ಮಂಡಳಿಯಿಂದ ಷರತ್ತನ್ನು.
Which is the condition violated?
Section 17(2)(a) of the ATCP Act, my lord. At the time of my lord approval, my lord, they established the road and to park, my lord, hand over to the planning authority. That is the rule. Local authority, they will, my lord, hand over to the. That is the condition. The seeking for, my lord, we have issued notice, my lord, kindly see, my lord, annexure. Definitely.
None of you are ready with the matter. Oh, that's why you sought. That's a justification. Because you are not ready. Then we'll dismiss this petition. We are not interested in prosecuting this matter. No, you are saying that's why you are sought for passport.
My assumption was the sake of passport.
Page number 97. ಆನೇಕಲ್ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದ ಉಲ್ಲೇಖ ಹೊಂದಿದೆ. ವಿನ್ಯಾಸ ಅನುಮೋದನೆ ಪ್ರಾರಂಭಿಕ ಪ್ರಮಾಣ ಪತ್ರದಲ್ಲಿ ನಿಬಂಧನೆ ಕ್ರಮ ಸಂಖ್ಯೆ 11 ನಿಬಂಧನೆಯಲ್ಲಿ ವಿನ್ಯಾಸದಲ್ಲಿನ
ರಸ್ತೆಗಳಿಂದ ಅಕ್ಕಪಕ್ಕ ರಸ್ತೆಗಳಿಗೆ ಇರುವ ಸಂಪರ್ಕವನ್ನು ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ನಿರ್ಬಂಧಿಸಕ್ಕಾಗಲ್ಲ ಎಂದು ಷರತ್ತಿದೆ. ಸರದಿ ಹನುಮಂತ ವಿನ್ಯಾಸದ ರಸ್ತೆ ಕಾಂಪೌಂಡ್ ಅನ್ನು ಕಟ್ಟಿ ಸಾರ್ವಜನಿಕ ಸಂಚಾರಕ್ಕೆ ತೆರೆಯುವುದು ಕಂಡುಬರುತ್ತದೆ. ಈ ಕೂಡಲೇ ರಸ್ತೆ
And the suit is filed against this notice. Suit is filed against this notice.
No, my lord, they are seeking for the injunction, my lord,
On
to.
what basis? Against whom?
My lord, I have. Suit is.
Yes, where is your plaint? Where is your suit?
Your lordship will just put it in the objections, your lordship, the next day.
Day after tomorrow.
With your
Monday.
lordship, a long 1 week time at least is required, your
Monday,
lordship.
Monday. At the request of the council for the respondent number 4. Leave this matter on Monday. You will have to show the action taken report in this matter. You grant the sanction plan with all the condition and you allow them to file the suits.
My lord, we have taken immediate action against my lord, respondent number 4, my lord.
Sir, issuing the notice will not stop, no?
This is my lord, ಅದನ್ನ ಹಂಗೆ ಮಾಡಕ್ಕಾಗಲ್ಲ, ನಾವು survey ಮಾಡಿ.
And if they enclose the entire property when they claim there is no alternate road.
My lord, both respondent have no role, my lord, because my lord, they have no right at all, because my lord, they are released to the authority.
Correct. So what action should you take?
Meanwhile, my lord, they file a.
You are waiting them to come with the order of restraint against you.
My lord. Meanwhile, my lord, they file a suit, my lord, and also my lord.
No, you are talking as if you're helpless. See the provision of law. Can they maintain the suit? We don't need to teach you on that. Whether such a suit is maintainable, look into the provisions of law. You want us to tell you that? You should be telling us. You can't express this helplessness, no?
File a legislation also, my lord, on 29th, 11th, my lord, the petition for orders.
Monday.
Ready for a swear it and find it in the counter next week.
Urgency ಹೇಳ್ತಿದ್ದೀರಾ ನೀವು? ಎಷ್ಟು ತಿಂಗಳಿದೆ ಅಂತ?
Case number 2 is on the fabricated document that for right. The last application the senior council at the time directed the government to file others and the documents.
ಅದೇ in the pending the matter you seem to have
Fabricated
Fabricated.
signature and all that.
and they have filed 340 application also.
Notice is not issued the respondent number 8 to 12, my lord. Based on the direction of this honorable court, my lord, they have given the representation. That as per that, my lord, I have acted. That is my humble submission.
All right. What are you filing now?
To be sworn, my lord.
All right. The request the AGA is this matter on. Put it date.
Second.
Please.
Yes.
ಕೊಡ್ತೀನಿ.
ಅವ್ರ ಕೈಲೇ ಬಂದಿಲ್ಲ ಕಂಪ್ಲೀಟ್ ಆಗೋದು. Yes.
Yesterday I did it, my lord.
Yes.
Preliminary matters, number 44.
Ella sir, this is petitioner. You have filed an application. What do you want now? Already there are ಎಲ್ಲಾರು ಬಂದಿದಾರಲ್ಲ. Which disease is the petitioner? Which? No, you see the caste title. Chennaya since deceased. Sarojamma, Pushpa, Radha. Already there alla. You have amended. Kodi idu ಅವ್ರದನ್ನ ತೋರಿಸಿದ್ದು. ಇದೇನಿದು? ಅವ್ರೇನಾ? ಅಪ್ಲಿಕೇಶನ್ ಎಲ್ಲ ಹೋಗಿದ್ಯಾ?
Court order dated 11/2022 on phone.
You should be knowing about your case. You are asking the court to assist you. Are we your secretary? Huh? ನೋಡಿ ಆರ್ಡರ್ ಮಾಡಬೇಕು. If you do not know about the docket of your case and you come and argue the matter based on your cause list, what can we tell you? ಯಾವಾಗ ಆರ್ಡರ್ ಆಗಿದೆ ನೋಡಿ. 11 2 ಕೊಡಿ. Submit You have made the same submission last time also without looking at records. And billing your version, the court has taken note of it. And 12/7/2022, in Alfonso, the petitioner is granted time to take steps to bring legal representative. This is petitioner. We can see that here. We can see that here. So what do you want to do now? Today? Argue. What is the matter? Yes, what is the matter?
Original agreement for the relief of partnership. And that is not that we can follow. It is available because it can be purpose. In the meanwhile, they negotiated based on the agreement proceeding, they want a regular record to be located to them.
Proceedings are inconclusive.
And my case was that during the pendency of the real suit I have purchased. There is a decree law which says that those properties which have already been sold, we are not in the share of the vendor and see the DPPs for work. Even in respect of the properties which have been already sold, they want a regular record to be entered with them.
So that is declined. What's wrong with the order? Where is that order?
Actually, yes,
Page number? Yes, read.
ಕೋರಿರುವ ಬೆಳೆಗೆ ಈ ಸಂಬಂಧ ಮಾನ್ಯ ನಗರಸಭಾ ಕಾನೂನು ಸಲಹೆಗಾರರ ಅಭಿಪ್ರಾಯ ಕೋರಲಾಗಿದ್ದು ಸಲಹೆ ಖಾತೆ ವರ್ಗಾವಣೆ ಮತ್ತು ಸಭೆ ನಂಬರ್ ಜಮೀನು ಸ್ವತ್ತುಗಳ ಜಮೀನುಗಳಾಗಿದ್ದು ಸದರಿ ಜಮೀನುಗಳ ಸಂಖ್ಯೆ ಹಾಗೂ ನಿವೇಶನವಾಗಿ ವಿಂಗಡಿಸಲು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಕಚೇರಿಯಿಂದ ಗಣ್ಯಕಾಂತ.
No, this is for only for production of the betterment charges, conversion order, not for the FDP.
No, FDP was drawn and then same thing is given and subsequent to which there was a commissioner.
So how are you agreed by this order? This order only calls for you to produce this Anyakranta Manjurati Padidiruva ಬಗ್ಗೆ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರ ಮಂಡ್ಯ ರವರಿಂದ ವಿನ್ಯಾಸ ನಕ್ಷೆ ಅನುಮೋದನೆ ಪಡೆದುಕೊಂಡು ಪ್ರತಿ ಅಭಿವೃದ್ಧಿ ಶುಲ್ಕ ಪಾವತಿ ಪ್ರತಿಗಳು ಅವಶ್ಯವೇ ತಿಳಿಸಿದ್ದಲ್ಲಿ ಅದರಂತೆ ಸದರಿ ಖಾತೆಗೆ ಸಂಬಂಧಿತ ಮೇಲ್ಕಂಡದಾಗ ಹಾಜರುಪಡಿಸಿದಲ್ಲಿ ಖಾತೆ ವರ್ಗಾಯಿಸುವ ಬಗ್ಗೆ ಕ್ರಮ ವಹಿಸಲಾಗುವುದು. What is this notice? Annexure F only giving you 3 items to produce. Where is the reference to FDP there?
No, there is no reference to FDP, but that's my entire case number. My must be because about the Honorable High Court in a written man seeking for man seeking for duties. The same thing is seen at an extra team. And this order was pleased to pass an order directly respondent number 1 to consider. However, my lord, when the financial approach respondent number 1, same was not considered. Stating that, I mean, in view of this, the interim order is passed and annexed. The party, the respondent in this particular suit member also party is the FDP.
Where is the petition number 5059 of 2012 order? I will produce the order. That is your main ground. That's the main ground. Ground 4C is that. Where is that order? Have you seen your ground number 4C? Where is that order? Anybody has that order copy? Yes, consider that. If there is an order already by declining rules for authorities.
Not the lands and the city proceeding.
That is not the reason you assigned, sir.
Surveillance. They have to approach him at the planning authority. The layout plan has to be approved by the authority. Then only we can enter Kata.
Which provision of law says?
Section 17 of the town planning. Act.
Kodi,
When the flats,
Kodi, give that. Give it.
17 state government shall by rules prescribe the standards to be followed and minimum extent of land to be considered for approval of layouts or subdividing a flat and prescribe the minimum extent area to be earmarked for park, open spaces and civic community sites and laying out roads. Every person who intends to develop a single flat or a subdivided property plot by making a plot layout plan or after the date of publication of the declaration of local planning area under subsection 4A shall submit a detailed plan of.
So what is their case? What is their case? Why are you
Their
invoking
case is
1070?
to change the Kata.
In respect of what?
In respect of survey number which is mentioned in the EFTP proceeding.
What is the extent?
At the extent matter.
Page number 6.
We are asking him. When we asked you, you kept quiet. So please. Yes.
In FTP proceeding matter. At page annexure.
No, Mr. Counsel, please tell us. How Haley, if a person who is allotted a share in a partition zone comes and asks you to register Khata in his name,
Yes.
you ask him to get documents in section 17?
Reason is this man. If the lands are survey land. Without there being any conversion order. Then they have to comply with section 17 of the act.
What about the guidelines which we read yesterday? Is there a condition there to that effect?
But if the survey numbers
That guidelines what we read yesterday, which we have posted the matters on Monday, do not provide any such condition. Khata in form number 9, 11, 11A, 11B to be issued, do not prescribe any such condition. To the extent even if they get some kind of document to show the title sufficient. That's what the guidelines, your own guidelines. And you use as and when you want to your choice. Read that entire thing. We made the learned AGA to read entire thing yesterday.
Which are situated within the municipal area. If it is unconverted land, conversion is compulsory. Then only after the conversion, after the planning authority approved the plan approved by the.
Already if the property is situated within municipality, which is still agricultural land, what happens to that?
If it is unconverted land, Kata, we cannot enter the Kata.
So who will have to enter? If a person wants to keep the land, if a person wants to keep piece of land in the nature as it is, you still insist him to get the conversion?
No, if it is within the area, not then we have no option.
So what? No. What we don't have option? Is that he should convert it?
So if it is in the municipal, within municipal area, may not.
No. He seemed to be expressing helplessness, which means a person wants to keep a piece of land, want to grow some fruits within the city area, he cannot. You want him to convert, get an approval under section 17, then only you make the Khata. Read that guidelines. What is this unreasonable condition? That I should use the property the way you want to tell us? You must prepare and serve. You are only here to take diets. You must go extra mile. Anything which comes after because and reason is useless. You can't give the cyclostat answers without application of mind. As it is, those conditions are impossible to perform. We read yesterday. On the top of it, if a person holds a piece of land which is not converted, you want him to go under section 17, get the approval plan, then only make the khata. What is this? Where do you get all that?
No acceptance. So
Now, where do you get all this? Please tell us.
then 17, you have to follow section 17 of the Karnataka government.
Please tell us, where is it? Is he asking for the subdivision of the plot? Is it a plot in first place? Is it a plot in first place? How section 17 is invoked? Please tell us that. ಏನೋ ಬರೀತಾರೆ ಜನರಿಗೆ ತೊಂದರೆ ಆಫೀಸರ್ಸ್ ಏನೋ ಬರ್ದು ಹಾಕ್ಬಿಡ್ತಾರೆ ಇವ್ರು ಬಂದು ಇಲ್ಲಿ ಪರದಾಡ್ತಾರೆ ಇರೋ ಚಿಕ್ಕ ಲೈಫ್ ಅಲ್ಲಿ ಅರ್ಧ ಲೈಫ್ ಕೋರ್ಟಲ್ ಕಳೀತಾರೆ ನಿಮ್ಮ ಖಾತಾ ಬಂದ್ಬಿಟ್ಟು ಅವ್ರು ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿ ಯಾವಾಗ ಜೀವನ ಮಾಡೋದು ಅವರು and no answer for all this. There is a provision. ಅದು ಕಟ್ಟಡ ನಿರ್ಮಾಣಕ್ಕೆ. That is for the purpose of construction of building. He wants to keep the piece of land as it is. Maybe he want to grow chili and tomato there. Do you have any objection that he should convert the land, then only he should grow chili and tomato there? Yes, authorities, what's the answer for this? Why are you holding his khata? And your endorsement is not because FDP is pending. Your endorsement is get the conversion,
Yes.
get the betterment charges. Why? Why should he get? Which provision of law says? Please point out that. You can't impose these unreasonable conditions, make them to serve. At that rate, there will not be any green vegetation in the city area. If you want every land to be converted from agriculture to non-agriculture use, they can't use anything. There cannot be any vegetation at all. Always.
Go through this circular.
Go through, make submissions. And you have to see, it's not that every case you want adjudication. Authorities are there, you have been given statutes, provisions are given, administration has to be effective, alva. You can't expect every single issue to be resolved by the court.
If they want khata to the extent that the only for the purpose of khata entries that we will make.
Aste.
Make it clarify that minute. So if you want to make any construction in that minute.
That is of course, that goes without saying. Which is why you see, we fail to understand, Mr. Counsel, the provision of the law, which makes very clear, we have been seeing this. The authorities say that only when the direction there, I will go and see the building. The language used in the statute is when the building is being constructed, a commissioner shall often give a visit to the property. And here is the case, you give order, we'll go. Statute is so simple and clear. When the building, the first brick laid, from that day you need to have a periodical inspection of the building. It is your job to see the building is constructed in accordance with the sanction plan. Otherwise, all this kind of mushrooming will not be there. And you don't do this. And now you are saying, so when will you make your submission? Barkoli,
Based on the circular.
the concept for the BBMP, City Municipal Corporation, Mandya submits that he will look into the guidelines and the relevant provisions of law and make necessary submission with respect to the endorsement in question, which calls for the petitioner to furnish conversion order, receipt for having paid the betterment charges, and the plan sanction as required in section 17 of the Town and Country Planning Act. It is noticed that the piece of land, which appears to be still in its agriculture nature, khata in respect of which is sought with the petitioner, claiming to be the owner of the property, having acquired the same in terms of a partition and the FDP proceedings. Full stop. Now, counsel for the respondent authority submits that he would make necessary submission as to which of the provision and the manner and method to be adopted to register the khata in respect of property of this nature. List this matter on. Yes. 1st of December. Really, we are not. All that is subject to that. Whatever the khata are subject to all those proceedings.
This petitioner wants the khata, khata of the property which is in mind. I am the owner of the property. FDP decree is very clear. As long as my property is concerned, we should not seek any partition.
That khata is only for the purpose of collecting the
It
revenue.
is already standing in my name.
It's only for the purpose of collecting revenue. Let us see that.
I am paying the revenue. Khata is in my property.
No. Yes.
First.
45.
To keep the have
ಏನ್ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಏನ್ ಕೊಟ್ಟಿದಾರಪ್ಪ?
endorsement was page number 28. So actually, we are not going to the new
ಸೇಲ್ ಆಗಿದೆಲ್ಲಪ್ಪ, there is a dispute in the property. ಅದು ನಾವು ಹೇಳಕ್ಕಾಗತ್ತಾ? Endorsement says that somebody else is claiming the property rights. Have you made them party here? Have you made the person whose name is mentioned the endorsement as a party? You're not made. Sir, what is that? Last 4 lines, please read Annexure F. ಅವ್ರಿಗೆ ಮಾಡಿದಿರಾ? ಪಾರ್ಟಿ ಮಾಡಿದಿರಾ? ಅವ್ರಿಗೆ ಮಾಡಬಾರ್ದ ನೀವು? ಅವ್ರಿಗೆ ಕೇಳಬಾರ್ದಾ? We will take your submission hands down. We will accept all your contentions. Is that sufficient to answer Annexure F endorsement? Tell us. Do whatever you want. They request the petitioner list this matter on the petition. Yes.
Preliminary big group matters, number 46.
Reservation made by police order 11/7/2022. There was some time. Burn concern would have otherwise been
What observation? 11/7/2020. What's observation? Vodi?
Learned experience of the general after adjustment argument. Coming that in the lines of one or two of the plan revenue act 1964. Steps would be taken by the difference of officers for identification of the units of the issues of the women village based on the own model. Described under the survey of and thereafter the district will be first for taking further steps as described under the subsection 2 of section 122 of the Act of 1964. We found that the petitioner is an unauthorized visitor. The beginning part of survey number 2 will be to and that the respondent is given back to this court after outcome of the
Yes. I cannot.
Please, my lord, the ADLR has requested one more week, my lord, that with all the stakeholders, we would conduct survey. But that is the intimation given by the, my lord, I will place it on record.
Yes.
But therefore, my lord, may I seek for 2 weeks.
Yes. Learned ASG submits that the ADLR has sought for further time to comply with the order dated 11/7/2022 passed by this court. Then the ASG produces the letter issued by the ADLR in this regard. The letter dated 5/11/2022 issued by ASC Center North reads that the survey would be conducted after intimation to all the stakeholders in a week's time. Submission taken on record. Submission taken on record. List this matter on
6th December.
6th December for submitting of the survey report.
47.
Password. When do you want? What does this matter?
It is a lot that have been tried to-
Hata.
Based on the not the issue never is after the compromise petition, because of the compromise petition, not certain sites have been granted petition. Petitioner not operating inside to sell the property is not in favor of third. Registered trading not is of the year 2001, reliable in respect of one of the sites. Tata is there on 2001, property has been developed. Subsequently, he took the execution petition, stating not that in terms of the court decree, he is entitled to be registered, the safety has to be registered in his name. Executing court not without making a party, not proceeds to mark the order to issue the safety in his name. Not I filed an application on order 21/97, bringing it to the notice of the court. But the very same petitioner had authorized the society to execute the safety. In terms of the safety, in terms of the authorization, safety has been.
You are a purchaser.
I am a purchaser for this society. And when that particular application is pending, they move this for the town for a direction. My safety is not answered till date.
They're still pending.
However, I got even a party to the proceeding also.
Who are you in this particular?
Respondent number 6.
All right.
I am also one of the purchasers.
All right, let the suit be decided. Pending proceedings we get over.
I will kindly pass on.
Yes, ಹೇಳಿ. ಒಂದು ನಿಮಿಷ.
Entire execution proceeding duration
ಪೆಂಡಿಂಗ್ ಇದೆ ಅದು ಕೂಡ. ಆಯ್ತಪ್ಪ, that is akin to a suit. The proceedings under 97, 101, 100 is akin to a suit. All the issues have to be considered there. How can khata be made when the suit is pending consideration, execution proceeding pending consideration? ಹಾಗೆ ಔಟ್ಕಮ್ ಆಫ್ ದ ಸೂಟ್ ಮನಿ ಎಂಡಾಸ್ಮೆಂಟ್ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ? ನೆಕ್ಸ್ಟ್ ಇಯರ್ ಏನ್ ಹೇಳಿದ್ದಾರೆ?
Page 40.
ಏನ್ ಹೇಳ್ತಾ ಇದ್ರಿ? ಅರ್ರಿ ಪಿನ್ ಮಾಡೋದು ಏನಕ್ಕೆ ಪಿನ್ ಮಾಡೋದು?
44, 43, 43.
ಅಲ್ಲಿ ಎಸ್ ರೀಡ್ ಮೇಡಮ್.
ಅರ್ಜಿದಾರರು ಖಾತಾ ವರ್ಗಾವಣೆ ಕೊಡುತ್ತಿರುವ ಸಬ್ಸಿಡಿ ಸಂಬಂಧಿಸಿದಂತೆ ತಕರಾರು ಸಲ್ಲಿಸಿರುವ ಶ್ರೀಮತಿ ಕಮಲಾಕಾಂತಿ ಮತ್ತು ಸುಧಾ ಮತ್ತು ಹೆಸರಿನಲ್ಲಿ ಖಾತಾ ಇರುವುದು ಕಂಡುಬರುವುದರಿಂದ ಹಾಗೂ ಹಾಲಿ ಖಾತೆದಾರರಲ್ಲಿ ಆಯಾ ಸ್ಥಿತಿಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾಲೀಕತ್ವದ ದಾಖಲೆಗಳು ಇರುವುದೆಂದು ತಿಳಿದಿರುವುದರಿಂದ ಮತ್ತು ಪ್ರಶ್ನಿತ ಅರ್ಜಿದಾರರು ಮಾನವ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಲಾದ ದಾವೆಯಲ್ಲಿ ಹಾಲಿ ಖಾತೆದಾರನು ಪ್ರತಿವಾದಿಗಳನ್ನ ಅಲ್ಲಿ ಮಾಡದೆ ಎಕ್ಸಿಕ್ಯೂಷನ್ ನಂಬರ್ ಸೊ ಅಂಡ್ ಸೊ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಿಂದ ನೋಂದಾಯಿತ ಕ್ರಯಪತ್ರಗಳನ್ನು ಪಡೆದುಕೊಂಡಿರುವ ಎಂದು ಸೇರಲಾಗಿದ್ದು, ಪ್ರಶ್ನಿತ ಅರ್ಜಿದಾರರು ಹಾಲಿ ಖಾತೆದಾರರ ವಿರುದ್ಧ ದಾವೆ ಹೂಡಿ ಪ್ರಶ್ನಿತ ಸ್ವತ್ತುಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅರ್ಜಿದಾರರ ಹೆಸರಿಗೆ ಪಾಲಿಕೆ ಖಾತೆ ಮಾಡುವ ಬಗ್ಗೆ ನಿರ್ದಿಷ್ಟವಾದ ಆದೇಶವನ್ನು ನ್ಯಾಯಾಲಯದಿಂದ ಪಡೆದುಕೊಂಡು ಸಲ್ಲಿಸದಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಪರಿಶೀಲಿಸಿಕೊಂಡು ಅರ್ಜಿದಾರರ ಮನೆಯ ಬಗ್ಗೆ ನಿಯಮಾನುಸಾರ ಕ್ರಮ ವಹಿಸಬಹುದು. ಆ ತನಕ ಕಡತವನ್ನು ಬಿಡಿಯಿಡಲು ತೀರ್ಮಾನಿಸಬಹುದಾಗಿ ಅಭಿಪ್ರಾಯ ನೀಡಿದೆ.
What is the reference to 140? What is reference 114A?
That only they are just referred.
Yes, but present petition is filed by the petitioner seeking to quash the endorsement dated 16/11/2018 at annexure A issued by the respondent number 3. The said endorsement has been issued pursuant to the application filed by the petitioner in as per annexure B1 and B2 seeking registration of khata in respect of such property. Full stop. The said endorsement reads as under Akadara. Full stop. The counsel for the petitioner does not dispute the pendency of the execution number 680 of 2009, in which respondent number 4 and 5 have filed application under order 21 so and so claiming title in the such property in their favor. Full stop. It is also brought to the notice of this court, being agreed by the said proceedings. Petitioner hearing has filed writ petition in WP number pending idea has filed a writ petition in which the said execution proceedings are pending have been stayed. Full stop. In view of the above, undisputed fact of the petition, execution petition, in which the respondent number 3 to 4, 4 to 6 claiming the right or the property, until determination of the said application, no irregularity or illegality can be found with the endorsement issued by the respondent authorities. The endorsement only speaks that the application is kept in abeyance and no order has been passed thereon. In the view of the matter, nothing survives considering this petition. Petition is disposed of. The application for the petitioner should be considered by the respondent authority on disposal of the pending execution petition. Yes. Execution error. ಹೌದಾ 4 sets 2 sets ಕೊಡ್ಬೇಕಂತ ಇದೆಯಾ?
ಸಿಕ್ಸ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿಲ್ಲ. ಮಾತ್ರ ನನಗೆ 2 ಸೈಡ್ ಸಂಬಂಧಪಟ್ಟಾಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗವರ್ಮೆಂಟ್ ಬೈಕ್ ಸಂಬಂಧಪಟ್ಟ ಮಾತ್ರ ನಾನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀನಿ. ನನ್ನ ಅಪ್ಲಿಕೇಶನ್ಗೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಸಿಕ್ಸ್ತ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪ್ಲಿಕೇಶನ್ ಆಗಿದೆ.
It is made clear that the application is made by the petition in respect of 4 sites, whereas the execution is pending in respect of 2 sites. In that view of the matter, respondent authority may consider registration of khata as sought for by the petitioner in respect of the sites which are not subject matter of the execution proceedings. Yes. 48. Yes, what action taken?
My lordship, as per our plan, is said, concerned ADDP is presenting the search for a plan
But he could not get it. He's
Who?
asking for a short.
Who will search for the plan?
ADT.
ಯಾಕೆ ಅವ್ರು ಸರ್ಚ್ ಮಾಡೋದು?
Plan is issued in the year 2010 and 11, my lord.
Yes, where is the plan?
Not plan is that, but I mentioned the plan number is. LP number is made number.
How many floors?
Page 19.
Page?
Page 19, I have mentioned the LP numbers.
Uh,
Of the page.
Page?
Page 19.
Page 19. The plan was. My wife had happened here is by the way.
No, we are aware of this senior council.
Yes.
Probably you must have been briefed why this matter is taken like this. What can we say? It actually rattled us. When a lawyer can make a submission that the building was offered, making known to the person that it does not have OC and EC and he has no right to claim. What can you say for this kind of audacity? And then next day, memo is moved to withdraw the petition. Can it be countenanced?
We cannot say that we will not.
If this is where we are leading,
Yes.
he has been fighting to protect the law of the municipal corporation. And if this submission is given, he would probably have sued them.
They have signed the consumer code here.
Artha ಆಯ್ತು.
Only like it is there.
He will not be able to comply with the order of the consumer code unless a direction is given here.
But again, I can 3 years back it was filed.
What is the extent of deviation? What is the extent of deviation? Devendra ಏನ್ ಹೇಳಲ್ಲ.
As for the consumer court order, they have instructed 15 minutes.
Sir, what are you doing, sir?
The plan is for 12 minutes.
What are you doing? What are your officers doing? Whose job it is? It's our job
No, my lord.
to find out the deviation, to get you the sanction plan, give you everything in platter, and then tell you this is the deviation. What's your job?
Yeah, Mr. Today only they are going to issue privacy notice. My lord.
Why?
For the production of documents, whether they have any plan or not. Or plan and other relevant documents.
Analyze it.
Then as per procedure, they will do the spot marker and they will take action.
Then the senior counsel appeal the petition submits that there is a plan.
This is the brochure, my lord. And this is the photograph. I can produce on.
You are also party to it, sir.
My lord, after this, my lord. consumer-
You are also party to it.
Consumer case is going on.
You are also party to it. What to do? Huh? When the relationship turns sour, you come to this kind of things.
I mean, second floor, my lord, they have made additional floor, my lord. That's the only.
It's okay for you to remove that headgear.
But what happened 3 years ago?
All right, let senior counsel for the petition submit the sanction plan. And then it's the same is produced in the next year.
ಇಲ್ಲ sanction plan produce ಮಾಡಿಲ್ಲ.
You know, here, page number 19 ಅಂದ್ರಲ್ಲ. And the same would be produced by next date of hearing. The council appearing for the BBMP submits that the officers are also searching for the sanction plan. And no sooner they trace the sanction plan, they will verify should there be a deviation and action in this regard will be taken. The council for the respondent number one, on the other hand, flagging the what's that?
This is a brochure.
Brochure submits
BBMP approved.
that the brochure issued by the petitioner is misleading. And there is a complete violation of the sanction plan. Submission taken on record to provide an opportunity to the petitioner. List this matter on 1st December. In the meanwhile, respondent BBMP shall also furnish the status report and the action taken report in this matter. Kudi.
They want to issue 313 notice. That may be record. I can give the documents.
Yes, ಅವ್ರು ಕೊಡ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಕೊಡ್ಲಿ ಆಕ್ಷನ್ ಟೇಕನ್ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ
Action taken, but at least a 313 notice. And that's submitted.
ಕೊಡಿ ಸರ್ ಮಾಡಿ ನೆಕ್ಸ್ಟ್ ಕೊಡಿ ತಾವು ಎಸ್
Action taken, because they will finish it. At least I'll have the opportunity to show the documents.
ಅದೇನ್ ಬರ್ದಿರಮ್ಮ submit that he would be issuing notice.
Shall furnish the status.
Allah shall furnish the status report and also then comes for the BBMP submits that no sooner the plan is traced, they would inspect the property and would issue notice required under law. Adadmel bariri BBMP to submit the action taken report as per the submission made above. Yes.
Date.
Date. Seventh. Many of the petitions are filed here to settle the person's score. I don't like your face, I'll demolish your building. Ah. Yes.
Neighbors now, they are filing petitions against.
ಹೌದು.
Your lordship,
Yes.
your lordship's name, Miller.
Yes.
Miller, serial number 55 in the list.
55.
Yes, Miller, what happened is an appeal was filed by the appellant
Ah.
in the High Court, in the appellate court. Yesterday, some orders have been passed, modifying the order. So he has to amend the appeal memo, writ petition, and transpose me as a respondent. Unless that is done, I can't appear.
2 weeks time we application was challenged. Yesterday division bench has modified and extended.
At the request of the counsel of the petitioner, list this matter.
5th December.
5th December.
Yes, Miller, grateful to you.
Whatever request to be done.
Other demolition matters we can move, Miller. Demolition matters can be moved, Miller.
Oh, yes.
In one case, you will, stay has been granted. I wanted to move for vacating.
Madi, move Madi Khedi.
Yeah. Yes, sir. I am
Yes.
grateful.
49. Next week, babe. Who's for the petitioner? Ah.
Sought for the same amount as.
ಏನು? Recovery na?
That is little.
ಹಾ.
ಅದನ್ನ ಸೇಮ್ ಏನು ಕೊಟ್ಟು ನಾವು ಮುಂದುವರಿಸ್ತಿದ್ದೇವೆ.
ಅರ್ಥ ಆಗಿಲ್ಲ. What is the matter?
ನೆಕ್ಸ್ಟ್ ಇಯರ್ ನಾವು ಮುಂದುವರಿಸ್ತೀವಿ ಒಂದು ವರ್ಷಕ್ಕೆ.
ಏನ್ ಮುಂದುವರಿಸ್ತೀರಾ? ಅದೇಪ್ಪ ಅವ್ರೇನೋ ಮೀನ್ ಹಿಡಿಲಿಕ್ಕೆ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ತಾನೆ ಅವರೆಲ್ಲ ಬೆಳೆಸಿದ್ದಾರೆ, ಬೇರೆ ಯಾರಿಗೂ ಕೊಟ್ಬಿಟ್ರೆ ನೀವು? ಹೌದಪ್ಪ, ಆ 2 ವರ್ಷ ಅವ್ರು ನೋಡ್ಕೊಂಡು ಮೀನ್ ಬೆಳೆಸಿದ್ದಾರೆ, ನೀವು ಬೇರೆಯವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರೇನ್ ಮಾಡೋದು?
3 months ಮಾತ್ರ ಕೋವಿಡ್ ಬಂತು 2019 ಅಲ್ಲಿ.
2020 ನಲ್ಲಿ
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ಲಿಸ್ಟ್ ನೋಡು. ಆಯ್ತು, the request of the council for respond number 1, this is matter on 23. 5 ಇಲ್ಲಿ yes 49 ಅಲ್ವಾ?
49.
All right.
53 ಅಬ್ಜೆಕ್ಷನ್ ರೆಡಿ ಆಗಿದೆ.
ಇವೆಲ್ಲ ಹೋಲ್ಸೇಲ್ ತಗೊಂಡೋಗಿದೆ.
ಇಲ್ಲ ಒಂದೇ
ಅವ್ರಿಗೇನೋ ಪರ್ಸನಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಅಂತ he has a personal inconvenience ತಗೊಳ್ತಿದ್ದಾರೆ ಅವರಷ್ಟು. ಅದಕ್ಕೆ ಕೊಡ್ಲಿದ್ದಾರೆ ಹೇಗೆ ಮಾಡ್ತಾರೆ? ಆಯ್ತು Wednesday. Yes. Yes. What your date? Yes, 59. ಬನ್ನಿ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ, ನೀವು ಸಾಕು ಸರ್. Yes,
Serial number 54.
But
that is a matter where notes they have sought for writ of mandamus for maintaining of the park notes keeping open the road. Notes now that is notes the tender has been issued by the authority, and thereafter notes so far as the road is also concerned notes action plan notes is prepared, and we are going to do that.
you're not forming the road there.
Notes there is a road.
There is already existing road.
There is a road.
No, but your complaint was they're forming a road in a park ಅಂತ ತಾನೆ?
ಪಕ್ಕದಲ್ಲಿ ರೋಡ್ ಇದೆ ಸುಮ್ಮನೆ ಅದನ್ನ ಅವರು ಅಪ್ಲೈ ಮಾಡಿ ಬಿಟ್ಟು ರೋಡ್ ಪಾರ್ಕ್.
So your main grievance is the road is being formed in a park ಅಂತ ತಾನೆ?
It is not so many. What has happened notes is that no, there is no difficulty. Notes there was a road 30 feet road, and according to that road there is a park. Instead of notes using that road for quite some time, notes the residents have not used the road. Now notes the bush and
So his apprehension will be protected, guarded.
Everything road.
ಹೇಳ್ತಾರಲ್ಲ ಏನೇನಿದೆ?
In the adjacent to that, there was another layout. And with that layout.
Agati, if there is no person there, the land will be used for the walking purpose, then that will become a road.
That's
Or
how
gate-
notes it has happened.
It might have become a trodden path. The council is making submission. What else you want now? He's saying that as per the plan, the action will be taken. What else you want?
But as per the plan, they have not made the part. Instead of. using
That we don't know which plan and what is that. They are saying the authority make
Developing the
submission.
park, not what they have produced, not is the approved plan. We are not going by the very same plan itself. That plan. not
Saka.
the park is-
Okay, 2:30.
Yes.
2:30.
Yes,
Very 57 was passed in order. Because two sides with the case is pending, not
Two-
and liberty.
ಕೊಟ್ರೆ ಹೇಳಿಲ್ವ ಅವರು?
ಇಲ್ಲ, liberty.
ಎಲ್ಲರೂ ಕೇಳಿದ್ರು.
Please, I'm sorry.
Out of 4 sites, 2 sites subject matter of the execution, they will have to hold their hands. Other 2 sites are not subject matter execution, khata be considered.
Please, the other two sides, liberty can move the, because it's not a rejection.
No, they have only kept in abeyance ಅಷ್ಟೇ, reject ಆಗಿಲ್ಲ.
If GMC, see, if the matter is over 27, it allows.
They have not passed any orders, only they have kept your application in abeyance.
Please.
That will continue till the outcome of the proceeding. Always.
Move this,
ಅದು ಹೇಳಾಗಿದೆ ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ.
please.
Subject to outcome of those proceedings, consider the application respect of 2 sites. The 2 sites which are not subject matter, consider now only.
Please, and that 2 sides, if it is allowed in our favor, I may be permitted to move this petition.
ನಾವು ಹೇಳಾಯ್ತಲ್ಲ ಪುನಃ ಏನ್ ಹೇಳುದು?
Because again, I have to file a fresh petition.
Why should you move? We say we are directed in the order itself.
In respect to 2 other sites, which is. pending.
Somebody explain it, please. So, it's correct. Yes, no, the construction is ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Section ನಿನ್ನೆ we have told them accordingly they started and it is now
ಹೇಳಿಲ್ಲ.
stopped.
ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ಸ್ಟಾಪ್ ಮಾಡ್ತಾರಂತ.
They take it as their immediately.
Like ಬರ್ಕೊಟ್. Then council for the respondent number 2 ಅಲ್ಲ ತಾವು respondent 1 ಈಗಲ್ಲ.
I am for one.
Respondent
Madam is for two.
Yes, respondent 1 and council for respondent number 2 submit that as contended by the petitioner, there is indeed construction being carried on the public road. The council for the respondent 1 and 2 respectively submit that they have issued necessary instructions not to proceed the construction involving the public street and necessary steps to be taken to ensure free ingress and egress and access to the public street. Full stop. They would submit the action taken report in this matter by next date of hearing. ಏನ್ ಮಾಡ್ತೀರಾ ನೆಕ್ಸ್ಟ್ ಅದರಲ್ಲಿ? ಈಗ ಆಗಿರೋದು ತೆಗಿಬೇಕಲ್ಲ?
ಹಾಗೆ ತೆಗೆದುಕೊಳ್ಳುತ್ತೆ.
ಆಗಿರೋದು ತೆಗಿಬೇಕಲ್ಲ?
Respondent ಗೆ private respondent ಗೆ notice ಮಾಡಬೇಕು.
ಅದ್ ಮಾಡೋಣ. Full stop. Issue notice to respondent number ಆಗಿದೆಯಲ್ಲ? Await service. List this matter on service of notice to respondent number 3 to 5. So construction is not.
Yes, I.
Respondent number 4.
Number? Please.
Has formed a layer. The petitioner tried to do for partition, and later on after the brother died, there was a settlement issue. After was made out in the name of the brother. Either. Now, not after the allotment of my share, 20 plots were allotted to me. I made an application, as required under the section 129 of the traffic act. They issued a notice and saying under this decree I have obtained rights in the property. They will transfer to me and transfer the property. There is no objection from either. The municipality has two ways. The endorsement, my last presentation, next step E. Page 137. This is the issue. The authority says that a plan has been obtained and relinquishment of the roads and the public community plots has not been done. And certain other discrepancies are there, so till that is done, we will not. My submission is my brother
obtained the plan. After his death, his name was entered in the register. Subsequently, I have acquired title in the partition in 92. I am seeking transfer of my name, division of my name in the tax register. Now, for them to say that the plan is not the.
Now, in the brother's name, whether this khata in respect of the sites was made in the name of the brother,
It was made in the
site wise,
it is an annexure A series.
and they want you to again obtain the plan.
He obtained the plan. They
Correct.
don't
Now,
want
what
to
they
obtain the plan. They say, in fact, in accordance with the plan. They say that there are certain discrepancies. They have not relinquished public amenities to the country. Therefore, till that is done, we will not make out happen. I am in no way connected with this plan.
Now, these khatas which are already made in the name of your brother, they were after release of those sites for registration by the authority.
But this has been done as soon as the plan was here.
No, there would be some release of sites after.
40% of sites were released initially.
That's why we were asking whether this khatas pertain to the release of 40% sites.
They are asking which from all vendors, both the categories. And subsequently,
I would clarify that you will make the khata only in the rest of the site which are made, not in the rest of the site which is not made.
in so far as the layout plan, a provisional layout plan was approved. Initially, 40% was released. Subsequently, another 30% was also released, but no relinquishment deed. They've not even provided the basic amenities of roads.
So you still hold
lights.
30%. You still hold 30% of the site with you.
We still
All
hold
right.
30% of the
The application made by them
yes.
is in respect of the 70% site already released.
Falls under both the categories.
You can't make that way. You have to be very clear. How many sites fall within that?
Number of sites, because and subsequently now there's a dispute from the landowner as well as the developer. Petitioner brother was the developer. We've also been made as a party in 2021 with a suit filed, including municipalities made a party. So, my lord, so far as the title dispute is cleared, again, we cannot issue kata in favor of the petitioner as such.
There is a.
But produce, my lord, the plain copy.
There is a transfer. It is brought to the notice of. Now there is a transfer from Sridhar to me. Sridhar is my brother. There is a transfer.
No, that's right. The question is this: your brother would have been entitled for the sites, provided the conditions the plan imposed on him were complied with, and apparently he had complied 70% of it. So therefore, the 70% sites have been released in his favor. Now, probably you will be entitled for registration khat in respect of those sites which are already released. In respect of sites which are not released, there may be a condition in a plan, Nodi. You might have undertaken to have it done by somebody else.
Unfortunately, my lord, that's 10-20%. Initially itself, they had to release all the parks, roads, and common areas, which was not done.
We understand. Therefore, we are saying
Released 40% was subsequently released without any development made.
as a favor.
The consideration is not.
There what is happening. My brother has transferred certain plots to another people. In their names, kata has been amended. Only they are holding me like 226 plots. They want to hold me back.
Oh, correct.
My lord, it's the endorsement.
Yes.
They say you are the legal representative of the person who found the land. I am not a legal heir of the person.
Which person?
I am his brother and sister. But I am not legal heir. Legal heirs are there. My brother's legal heirs are there.
How did you get the property then from your brother?
Well, it is my father's property. I filed a suit for partition. After he died, they came for a settlement. There was a settlement, there was a compromise before the law, and they continued.
No,
he says your brother was a developer.
He is the one who obtained the Salient plan also.
Huh?
Well, that's not because he developed his plan, but I have nothing in his plan.
No, two things you have to clarify. If your brother was made a developer and in considering development, this site property given, how does it become your father's property?
No. This property belongs to our family. Developer in the sense he developed the property.
No. These sites have come to your brother's share.
Some of the sites have gone to his share. Some of the sites have come to my share. It's a joint family property. Developer in the sense he was the person who developed the property. Not that there is a
There's some other person is the owner and he was a developer.
That's what he's trying to make out. He said there's a dispute between the original owner and the brother.
There is this, my lord, in fact, annexed R4, my lord, has produced along with my objection, because the title dispute in so far as these sites are concerned. After development, he had arrangement with another person to, once developed, these many sites had to be given to him. He's filed a suit, including the municipality, to made a party here.
But that is not the ground you are given the endorsement.
No, endorsement, my lord, did
So
not.
you can't expand the scope of your endorsement now.
Absolutely, actually. In so far as.
You
my lord,
have to
what-
clarify with regard to the sites which are already released, we may have to make a khata. The sites which are not released, probably you may have justification.
Yes, sir.
Moreover, this is the municipal.
All right, put it this way. If there is nobody to comply with the condition, what happens to the layout?
My lord, if the layout is not complete, my lord, those sites will have to be seized, my lord, and the development has to be done by the municipality.
That's
And
what
this
we
will
said.
have- without a-
Have you done that? Have
not
you done that? Have you done that?
No, my lord.
Have you given that reason in the endorsement?
My lord, in so far as not being developed, yes, my lord, we have issued that reason.
What reason?
There's not, the layout not being developed.
Ah,
And last paragraph,
ah,
annexity,
yes.
page number 130.
138.
ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ನಿವೇಶನಗಳನ್ನು ಗೊಳಿಸಿರುವುದು ತಮ್ಮ
ಉಳಿಸಿಕೊಳ್ಳುವುದು.
ಗೊಳಿಸಿಕೊಳ್ಳುವುದು ಆದ್ಯ ಕರ್ತವ್ಯವಾಗಿದ್ದು ಸದರಿ ಆದೇಶ ಹಾಗೂ ಷರತ್ತುಗಳನ್ನು ತಾವು ಉಲ್ಲಂಘನೆ ಮಾಡಿರ್ತೀರಿ. ಶೇಕಡ 30% ನಿವೇಶನವನ್ನು ಬಿಡುಗಡೆ ಮಾಡಿ ಸುಮಾರು 6 ವರ್ಷ ಗತಿಸಿದರೂ ಯಾವುದೇ ರೀತಿ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ನಿರ್ವಹಿಸಿರುವುದಿಲ್ಲ. ತಾವು ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆ ಆಧಾರದಂತೆ 1/9/2020 ಶ್ರೀಧರ್ ಅವರು ಮರಣ ಹೊಂದಿರುವ ಕಾರಣ ವಾರಸುದಾರರಾದ ನೀವುಗಳು ಸದರಿ ಬಡಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೂಲಭೂತ ಸೌಕರ್ಯಗಳನ್ನು ನಿರ್ಣಯಿಸಿ ಛಾಯಾಚಿತ್ರಗಳನ್ನು ಸಲ್ಲಿಸಿದ್ದಲ್ಲಿ ಈ ಬಗ್ಗೆ ಪುರಸಭೆ ಹಾಗೂ ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆ ವತಿಯಿಂದ ಪರಿಶೀಲನೆ.
Where do you get that? Where do you get to, and which provision can you call upon the legal representatives, the legal heirs of the person in whose favor the sanction plan is issued?
My lord, so far as they are claiming, my lord.
Why don't you people answer that
Yes, sir.
question? You have given this reason.
Yes, sir.
From where do you get this reason? Which provision of law? Please show that.
My lord, in so far as, because the person, the brother of the petitioner died, and there is nobody who wants to develop this land, nevertheless, they only want to benefit out of it. And we've requested them, if you're claiming it, you have to develop complete the layout, complete the formation, as well as then you can make an application for it.
We asked you this question earlier itself.
Yes.
If there is no development as per the terms imposed by you, you know the consequences,
Yes, yes,
you know the responsibility of the authority.
yes.
Have you done that?
No, my lord.
Then where's the question of you calling upon the legal heirs to develop and complete it? How can you do that?
Can't be done.
You can't do it.
Municipality has no right to terminate that. Town and country planning authority gave me the plan.
Who has issued this plan?
My lord, this plan is issued by the town and country planning authority, my lord, the property is situated within the municipality. And so.
There are two different functions.
No, that's fine, but then they will have to work in tandem. They will have to work in coordination with each other. Now,
There are
now.
consequences.
Correct. So, no. That consequences will have an impact. Then have you made them party in this?
Everything.
Who is appearing for the Town and Country Planning Act? Who is the planning authority? Yes, response number 3. Yaru, response number 3 again. Who is appearing response number 3? ಸ್ವಲ್ಪ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಕೂತ್ಬಿಟ್ಟು ಯೋಚನೆ ಮಾಡಿದ್ರೆ you will have all the answers.
In fact, what is the.
Planning officer ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅದಕ್ಕೆ.
It is only a fiscal entry. 130 does not decide any right. Municipality makes a fiscal entry in the register for the person who is liable to get that. In fact, they don't even issue a khata certificate. They just have to enter my name. to the books.
Who is for response number 3?
Respondent number 3, madam, planning officer, district planning officer ಅಂತ ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ. Therefore, madam, it has been, this court has directed the state to take notice.
So
Separate
now
mean, madam, town and country planning ಅಂತ ಹೇಳಿ ಅದನ್ನ
ಮಾಡ್ಬೇಕಾ?
ಮಾಡ್ಬೇಕಾಗ್ತದೆ.
You make appropriate parties in this. Find out who is the proper party in this. Madi, take note. Yaru, what's his name?
Project, town and director.
Chitradurga.
Chitradurga.
ತಮ್ಮ ಇದರಲ್ಲಿ ಇರ್ಬೋದು ನೋಡಿ, ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಮಾಡಿರೋ ಅಥಾರಿಟಿ ಹೆಸರು ಇರ್ಬೋದು ನೋಡಿ. Who's the authority issued the sanction plan?
ಯೋಜನಾ.
ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆ ಚಿತ್ರದುರ್ಗ.
ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ.
ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆ ಚಿತ್ರದುರ್ಗ.
ಅದೇ ಮೆಂಬರ್ ಸೆಕ್ರೆಟರಿ ಇದಾರಾ, ಯಾರಿದ್ದಾರೆ ನೋಡಿದಕ್ಕೆ? ಹೂ ದ ಪರ್ಸನ್ ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ಇಟ್?
ಡೈರೆಕ್ಟರ್
ನಿರ್ದೇಶಕರು.
ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಟೌನ್ ಅಂಡ್ ಕಂಟ್ರಿ ಪ್ಲಾನ್ ಡಿವಿಷನ್ ಮುಖ್ಯ ಅಧಿಕಾರಿ.
Yes.
ಹೊಳಲ್ಕೆರೆ ಪಟ್ಟಣ ಪಂಚಾಯತ್.
Then DGA submits that the respondent petition be directed to plead assistant director, planning deputy director,
ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆ.
ಟೌನ್
ಅಂಡ್ ಕಂಟ್ರಿ ಪ್ಲಾನಿಂಗ್
department, Chitradurga, na?
Yes.
Chitradurga, in view of the fact that the endorsement issued at annexure E reads that there is that the terms and conditions of the sanction plan, layout sanction plan has not been complied with.
Yes.
In that view of the matter, 30% of the sites have not been released. Full stop. And only the aforesaid authority is competent to respond to the issue. Petitioner, upon the oral request of the petitioner, petition permitted to implead so and so petitioner to amend the cost title and file the amended cost title. ಯಾರಿದ್ದಾರೆ ಅವರಿಗೆ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲಿ? ಯಾವ ತಾವಟ್ಟು ಹೋಗ್ತೀರ ಅವರಿಗೆ?
ಚಿತ್ರದುರ್ಗ.
Issue notice to respondent number 5. Yes, this matter on 5th December. 5th December, yes. Amendment not given.
For respondent number 5, the copy has not been served. So, office will not here served notes.
Respondent number
5.
could you copy? Yes, petition to serve the copy of the petition, respondent number 5. Is this matter on
2nd December.
2nd December? Interim order, if any, extended till next set of hearing.
Lord, appear for respond number 4 and 5 in this case, Lord. 4 and 5 in this case. Lord, in this case, I am not well, Lord, today I have not come here because on that reason, I am appearing through online. Lord, here the reason is that, Lord, today there is a meeting between the, Lord, the petitioner and the third respondent along with 4 and 5. So, Lord, the outcome of that, because there is an engineering technically problem in the engineering section. So on that issue, Lord, I'm seeking, because that is an instruction given by my client, that there is a meeting is going on between the Lord petitioner and the in this case.
Let's kindly see the order passed on the last occasion. Let's the Council for Respond number 4 and 5 has undertaken that the construction of retaining wall is under process and it will be completed on or before 17/11. From the last date of hearing, my instructions are that no construction has taken place yet. And as submitted my learned friend, there is no such meeting arranged today afternoon. I have no instructions as regards the said meeting. I have no objection for grant of adjournment on that ground. Please, sir.
We will not trouble him today.
Please,
trouble him next time.
Please, next week, any day, next week, madam.
He is saying next week, any day we can trouble you.
After 2 weeks, any day.
Better 2 weeks, better. Because you have undertaken to put up the construction.
No, true, my Lord, because no, it is, I don't know, the petitioner has not given any.
Yes, the request respondent council for the respondent number 4 and 5 is this matter on 25th.
Please,
much.
Obliged.
54. One Kumar.
Page. Ah.
Petitioners have first prayer is with regard to the configuration of their representation. The second prayer is with regard to development of the road and the path. But we will not consider the first one because since we are taking action so for the second prayer is concerned.
Yes.
Now, page 11 this is the layout map. But there is the 30 feet road and not the park area. But this entire park area roads is being now developed roads and I'm placing on record roads the decision of the corporation. And so that the 30 feet road is also concerned. But the allocation of funds notes have been made. Now notes they have to issue the tender and thereafter notes to that may happen within notes is
Annexure.
this not the plan.
That's annexure.
Yes.
Yes. Aspect.
Yes.
But
Currently notes consider. The first document is the 18/10/2022. Is the work order in relation to the development of the park. Towards the next document notes is 22/8/2022. Is the proceedings of the standing committee in which notes at serial number 40. This particular area, the road roads falls within that ward number 28, where notes the corporation has reserved 50 lakhs for the development. Roads, this particular road is around notes 70 meters in length. That area notes will be developed, but after equating tender and notes issuing the work order.
yes. But present petition is filed with the petitioners.
On submission, you can file in Wakalat corresponding number 4.
Officer. The council for the.
Request note that on instruction not that.
Yes, yes. Idara officer idara.
Not officer is also there.
All right. Present petition is filed with the petitioner seeking following reliefs. It is the case of the petitioners that they are the residents of the layout bearing layout formed in land in surrender number 45 bar 1 capital A of Maraluru village, Tumukuru, which was an approved layout by Tumukuru Urban Development Authority, consisting of about 15 sites in terms of the approved layout plan produced at annexure A. That the Tumukuru Development Authority had identified parks and had reserved area for the said purpose in the layouts. In the said layout, an extent of 5,600 square feet has been reserved for the purpose of park. The said layout has not been developed as per the plan, and the area reserved for the park is utilized for the purpose of road. That there is already an existing road next to the park as per the layout plan. However, the respondents have formed another road in the area reserved for the park. This has constrained the petitioner to approach this court, seeking the aforesaid relief. P. Subramanian and counsel for the respondent authorities submit that files a memo dated 17/11/2022 along with two documents, namely work order dated 18/10/2022. One another.
The other one notes in the proceedings of the planning committee.
And
the
proceedings of the town planning
committee.
Referring to the said two documents, then council submits that the development work of the park has already been handed over in terms of work order dated 18/10/2022. And the work of development of the park would be completed on or before 17/4/2023. As regards the construction of the road is concerned, 18/4. Then council submit that as per the resolution passed by the standing committee of Tumkur Mahanagara Palika Tumkur, an amount of ₹50 lakhs has been earmarked for the purpose of development of the road.
That is for the entire park.
Has been earmarked for the development of roads in the ward, and the said amount would also be utilized for the formation of road in the layout in question. And the layout and such road will be formed. Then council, C. Subramaniam makes the efforts to submission based on the instruction given by the officer concerned who is present before this court, namely
Suma, Assistant Executive Engineer.
Suma, Assistant Executive Engineer of Tumkur City Corporation. Submission taken on record. ಎಷ್ಟು ಸಮಯ ಬೇಕಾಗಬಹುದು?
3 months.
Okay. In response to the above, let comes with the petitioner insists that the petitioners, the respondents be directed to complete the formation of road in terms of annexure A within time bound period. Land Council for the responding corporation submits that such endeavor will be made to complete the work.
What happens mostly that you may have to invite tender. Thereafter, not one part.
Correct.
That process plots itself takes plots around 2.5 months. But thereafter, plots within a plots short period that
within an outer limit of 6 months. 6 from the date of receipt of certificate copy of the order.
So far as the work
order, we have taken note. We have taken note of the date of completion also. We did not hear that. Yes. Near the above, the petition is disposed of. Yes.
That is instead of 17 notes, 18/4.
18/4.
Lordship have recorded the date of completion of the work. Because the park is 17, not 17, 18.
18/4/2023.
Yes.
Yes.
Finally, there were 56.
ಬೇಡ ರಿಟರ್ನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಏನಕ್ಕೆ ಬರ್ತೀರಾ? ಇದು ಓರಲ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
There was some talk for the proposal. That's the reason. Short of time. Because here, the contention of the petitioner is that land has been allotted at auction.
Yes.
Their contention, there are two contentions which they have raised. One is much that the land has been obtained by auction. Second much is that there was an earlier application, it was in the year 1953, which came to be disposed of. That is there.
1980. 1980. 1980.
85.
85 is it?
85. He makes an application, 85 gets disposed of.
1980.
That's what we said.
1980.
That's what we told.
1985 was disposed
You
of.
guys are confusing. We made it very simple. We asked you the application file in 1980.
Yes,
Then
1980.
why are you saying 1985?
No, 85, the matter got disposed of. Sorry. Plots in. So far as the first, and their contention is that it is not a land which comes under the PDC. Let's kindly look at annexure A. Let's, I have inquired, gone through the form file also, had an opportunity, but the entire, those days, the format of the grant was, the same format was used for both option and for grant also. For PTCL for grant also is very nice. So there was no separate format. In the same format, they have issued the grants. So now to examine whether this was done at an upset price or at a market option value. We'll have to look into the what price it was being granted. But the price what they are saying is 15 rupees per acre. And then let's can see it at an ink page. Land certificate says that origination is not very common. Page 9, grant certificate, and the page 10 works next page. Kindly look at the land revenue. The land revenue is 50%. And the option price, what they are saying, they claim to say it is not an upset price. It is 50 rupees. Just the 5 times the value is not the market price. But it was allotted as a grant to the SES. So far as the certificate they produced, that an AC certificate they have produced, along with the memo copy of the certificate. But we are not aware of that.
What certificate?
Memo has been last time they were submitting that. They have produced a certificate saying that I don't belong to SES community.
It is not, well, the order of the AC, which we have made the application in 1918 was disposed of in the year 1985. The order which I have placed before you, and they also want to.
No, let's try to look at the order. Try to look at the order.
Is there a finding? Is there a finding on this matter with regard to the whether the land is a auction land or a granted land?
Simple analysis. Because those days they did not use a separate form. State did not use a separate format or a separate form for any grant or for auction. They were using the same format, same form which they used to fill up it and give it. But similar, I think the original file is the same. But and simple application of the pricing the land revenue into 5 times is what, not even 5 times, less than 5 times. It is 3 rupees 50 paisa is the land revenue, and 50 rupees is the, they say that they have purchased in.
I too, next money.
So then let's
come next. What
so
next?
Far as the page, so far as the order which they are relying, can you look at page 28? They are saying that it is a land which has been disposed of. The appeal was disposed of 1985. Application was disposed of. On the application made by the father of the present applicant. Can you look at page 28?
28 of what?
The AC order numbers.
Yes.
PTCL ಪ್ರಕರಣ 22/2004
Yes.
Annexure.
Yes.
Sorry, annexure F. In page 28. ಪ್ರತಿವಾದಿಗಳು ಲಾಸ್ಟ್ ಪ್ರತಿವಾದಿಗಳ ಅರ್ಜಿದಾರ ತಂದೆಯರಾದ ವಿಶ್ವಾಸನವರು ಈ ಹಿಂದೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸದರಿ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು ಸದರಿ ಕಾಯ್ದೆ ಅರ್ಜಿಯನ್ನು ನ್ಯಾಯಾಲಯದ ವಜಾಕರಿಸಿದೆ ಎಂದು ವಾದಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಅರ್ಜಿದಾರರು ನ್ಯಾಯಾಲಯವು ಅರ್ಜಿದಾರ ತಂದೆಯವರ ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡದೇ ಇರುವುದರಿಂದ ಬೆಲೆ ಇಡಲಾಗಿತ್ತು ಹೊರತು ವಜಾಗೊಳಿಸುತ್ತದೆ. Kept aside, it was not disposed of. Because what she would have, they are belong to SCST, uneducated, illiterate people, they would have not submitted. This could have happened. And for that reason, it is not a disposal on merits. There was no finding on merits as such. Hence, we cannot take that the 1985 application was disposed on merits.
No, that was a submission.
No, it is a finding there. There is a finding there. ಅರ್ಜಿದಾರ ತಂದೆಯವರು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡದೆ
ಓದಿ ಸರ್ ಅದು. Read the entire paragraph. Read from the beginning.
ವಾದಿಗಳು ಅರ್ಜಿದಾರರ ತಂದೆ
ಪ್ರತಿವಾದಿಗಳು
ಪ್ರತಿವಾದಿಗಳ ಅರ್ಜಿದಾರ ತಂದೆಯವರಾದ ಮುನಿಶ್ವಾಪನವರು ಈ ಹಿಂದೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸದರಿ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಅರ್ಜಿಯನ್ನು ಈ ನ್ಯಾಯಾಲಯ ವಜಾಗೊಳಿಸಿದೆ ಎಂದು ವಾದಿಸಿರುತ್ತಾರೆ. ಆದರೆ ಅರ್ಜಿದಾರ ನ್ಯಾಯಾಲಯವು ಅರ್ಜಿದಾರ ತಂದೆಯವರು
That was the submission of the Prativadi. Now you read the Vadi or the response Vadi. Next is the Vadi or Arjidara Vadi.
ಅರ್ಜಿದಾರ ಸಲ್ಲಿಸಿರುವ ವಂಶವೃಕ್ಷ ಹಾಗೂ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ಪ್ರಕಾರ ಇವರ ಪರಿಶಿಷ್ಟ ವರ್ಗಕ್ಕೆ ಸೇರಿದ್ದು ಮೂಲ
ಮಂಜೂರಿದಾರರ ಮಗನೆಂದು ಸಾಬೀತು ಕಂಡುಬರುತ್ತದೆ.
ಓದ್ತಾನೆ ಇಲ್ಲ ನೋಡಿ ಸೆಂಟರ್ ಪಾಯಿಂಟ್ ನ. Read the entire paragraph, Mr. Counsel. Don't mislead. How many times to tell you? One second. One second. Read as we want you to read. Read the first sentence first. Read from there. Prativadigal ಓದಿಲ್ಲಿಂದ.
ಪ್ರತಿವಾದಿಗಳು ಅರ್ಜಿದಾರ ತಂದೆಯವರಾದ ಮುನಿಸ್ವಾಮಪ್ಪ ನವರು ಈ ಹಿಂದೆ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಸದರಿ ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದು, ಸದರಿ ಅರ್ಜಿಯನ್ನು ಈ ನ್ಯಾಯಾಲಯ ವಜಾಗೊಳಿಸಿದೆ ಎಂದು ವಾದಿಸಿರುತ್ತಾರೆ.
Hold on. Who's saying that?
He said
Who? Prativadi. So he's asking, he's saying that it is dismissed. Now see the next sentence. Read the next sentence. No, you read once.
ಆದರೆ ಅರ್ಜಿದಾರ ನ್ಯಾಯಾಲಯವು ಅರ್ಜಿದಾರ ತಂದೆಯವರು ಸಲ್ಲಿಸಿದ ಅರ್ಜಿಯನ್ನು ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರ ನೀಡದೆ ಇರದಿರುವುದರಿಂದ ವಿಲೆ ಇಡಲಾಗಿತ್ತು ಹೊರತು ವಜಾಗೊಂಡಿರಲ್ಲ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ.
That's not a finding, that's a submission. Then where's the finding?
ನೆಕ್ಸ್ಟ್ ಈ ವಾದವನ್ನು ಯಾರು ಸಾಕ್ಷಾಧಾರವನ್ನು ನೀಡಿರುವುದಿಲ್ಲ.
There is no proof for the submissions. There is no proof for the submissions made by both the parties.
Yes. ಅರ್ಜಿದಾರ ಕಂಟೆನ್ಷನ್.
Read next.
ಅರ್ಜಿದಾರ ಸಲ್ಲಿಸಿರುವ ವಂಶವೃಕ್ಷ ಹಾಗೂ ಜಾತಿ ಪ್ರಮಾಣ ಪತ್ರದ ಪ್ರಕಾರ ಇವರು ಪರಿಶಿಷ್ಟ ವರ್ಗಕ್ಕೆ ಸೇರಿದ್ದು ಮೂಲ ಮಂಜೂರಾತಿದಾರರ ಮಗನೆಂದು ಸಾಬೀತಾಗಿರುವುದು ಕಂಡು ಬರುತ್ತದೆ.
So there is no conclusion regarding what happened to the earlier proceedings. The court is only taking to consider, the authority taking into consideration the present application file. That's all.
Yes.
What happened to the 1980 proceedings?
Well, it's 1980 proceedings.
1980 proceedings. What happened to that? His contention is 1980 there was proceedings, and in 1995 again there is a proceeding. So you must answer what happened to 1980 proceedings. After all, it was your father who had done it. So answer it. Then that's what the court house has found here. ಈ ವಾದಗಳಿಗೆ ಸಾಕ್ಷ್ಯಾಧಾರಗಳು ಇಲ್ಲ. That means rejected then only.
But he further proceeds and says that the ವಂಶವೃಕ್ಷ ಪಟ್ಟಣದಿಂದ he belongs to SC.
That is later. That's not connected to that. That is to consider the instant application.
There is no material place here so far as 1980 records.
So are you saying 1980 there was no proceedings?
That's
Is it your case that there was no proceedings at all in 1980?
Go through the common file.
You said you had a benefit of going through the file, you have gone through thoroughly. That's how you started your argument. Be cautious in making submissions. We trust your submissions, counsel.
Yes.
We trust your submissions.
Yes.
But when you make us to read between the lines, that will not do.
No, my intention was not that.
We understand your intention was not there, but this glaring from the records. Going against, going contrary to submissions being made by you. That's why we are just putting your notice. Yes.
I'll go through the file and next.
Go through.
Time may be, any date may be this. Any date may be.
I agree.
And the memo dated also, there was a clear adesha. Because adesha
ಯಾವ ಮೆಮೊಪ್ಪ?
memo dated
I don't have. 22/10/2007.
Who has filed? Where has it been filed?
Which one? Fine.
ಏನಂತ ಹೇಳಿದ್ದಾರೆ?
In this, there is a Adesha.
Memo dated?
86 million.
Memo dated?
22/10/2007.
Produce the report.
In the last occasion, hardship has been.
2007,
Yes, ma'am.
ಏನು ಹೇಳ್ಕೊಟ್ಟು ಓದಿ. What memo is? What is that?
ಆದೇಶ ವಾದಿಯು ದಸ್ತಾವೇಜು ಜಮೀನು ಮಂಜೂರಾದಾಗ ಹಿರಿದನ ಪಂಗಡಕ್ಕೆ ಸೇರಿದ ವಾದಿಗಳಿಂದ ಸಾಗುವಳಿ ನೀತಿಯಲ್ಲಿ ಯಾವ ಷರತ್ತುಗಳು ಇಲ್ಲದೆ ಇರುವುದರಿಂದ there was no such condition.
ಓದಿ ಸರ್.
ಇರುವುದರಿಂದ ಹರಿಜನ ಗಿರಿಜನ ಕೆಲವೊಂದು ಜಮೀನುಗಳ ವರ್ಗಾವಣೆ ವಿಚ್ಛೇದ ಕಾಯ್ದೆ 78ಕ್ಕೆ ಅನ್ವಯವಾಗುವುದಿಲ್ಲವೆಂದು
Your application rejected earlier.
Not only based on the caste certificate results, even though they have
Yes, government, you have to answer. How can you pass two orders in respect to same matter? You know.
I'm producing that's a copy which my.
You answer it. Copy. Earlier occasion, you rejected the application saying that he neither belongs to scheduled caste, scheduled tribe community, nor there is a prohibition and applicable ಅಂತ ಹೇಳಿದಿರಾ. ಇವಾಗ ಅವ್ರ ಮಗನಿಗೆ ಕೊಡ್ತಿರೋ ಸರ್ಟಿಫಿಕೇಟ್ ಯು ಆರ್ ಪಾಸ್ ಆರ್ಡರ್. ಹೌ ಡು ವಿ ಕೌಂಟೆನ್ಸ್ ದಿಸ್? ಯು ಆನ್ಸರ್ ದಿಸ್.
That cannot be.
So
But the order has to.
this has to go. Subsequent order has to go. Yes, Barkun.
No, that's one submission.
What is there now?
No, one submission. If you look at the grant certificate.
We will not look into grant. We are not here to look into grant. That's
No,
a,
no, no.
that's a job of the ACs. You are not challenged, Allah. That's a job of the ACs, not our job.
No, Milord,
That's the job of the AC, not our job. And the finding is given.
It was granted at an upset price. And then Milord,
We don't know, sir. We got the answer from the government. We will only stand by that.
make submission, Milord, so date we shall examine it.
What submission can you make in the light of this order and the original record available here? Please tell that. Tell that. Can there be any better submission than this? Please go through the records. We'll wait for you. Go to your record.
Date may be fixed, Milord, sir.
2007 matter. 2007.
Either dismiss or dismiss
No.
default ಆಗುತ್ತೆ. 2018 ಅಲ್ಲಿ recall ಆಗುತ್ತೆ.
Then all the more reason.
And ಇದ್ರಲ್ಲಿ ಏನು ಮತ್ತೆ ಏನಾಗಿದೆ ಅಂದ್ರೆ after subsequently after 2007 ಇಂದ after the order I have been in possession of the property. 18 ಇಂದ 18
We avail the remedy available. We are
I
only.
make submission.
Sir, please look into that, sir. We will give time. We will wait. We will wait.
Date may be fixed, at least tomorrow.
Note.
ನಾನು go through it, sir.
ನಮ್ಮ ಮುಂದೆ ನೋಡಿ ನಮಗೆ ಗೊತ್ತಾಗಿತ್ತು ಅವ್ನು ಗೋತ್ರು ಮಾಡಿದಿರ ಅಂತ ನೋಟ್ ಪ್ಲೀಸ್. Please read the document. Opportunity should not only be given, but opportunity should seem to have been given. So let us see that you achieve that. ಅವ್ರಿಗೆ ಕೊಡಿ ಆರ್ಡರ್, ಒರಿಜಿನಲ್ ಆರ್ಡರ್ ತೋರಿಸಿ ಅವರಿಗೆ ನೋಡ್ಲಿ ಅವರಿಗೆ. ಹಾ, ಯಾವ್ದು ಪುರಾವೆಗಳಿಲ್ಲ ಅಂತ ಬರೀತಾರಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳೋಣ ಹೇಳಿ. ಯಾವ್ದು ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಲ್ಲ ಅಂತ ಬರೀತಾರಲ್ಲ ಏನ್ ಹೇಳೋಣ ನಾವು.
Please, please.
ಅಲ್ವಾ? ಸ್ಯಾಟಿಸ್ಫೈಡ್? ಬರ್ಕೊಡಿ. ನೋಡಿ original. ಏನು what is that covered ಅಂತಿರೋದು ನೀವು ಕೊಡಿ.
ಅಲ್ಲ,
Satisfy
ಅದು-
you also.
But the first alienation takes place in 1963 itself. Even applying the, but when the upset price is taken, it cannot be.
ಏನಪ್ಪ what is this matter?
In this matter, the civil court has decreed the subsequent after the decree. He has made an application for seeking police protection. Once a judge or any authority makes an order regarding that, he ceases to have control over that matter. He has to approach the subsequent court, and the court, which has court or any authority pass the order, he doesn't have any review power regarding that. He cannot review the same matter once again. Whether it's in page 15, whether the court has observed that.
Present petition is filed by the petitioners seeking following leaves. The case of the petitioners, quickly please. Case of the petitioner that they are petitioner, sorry. Case of the petitioner that he is the absolute owner of the property in surrender number 44, ward number 17 of Matribali village, Cherarayapatna, Hubli, Devanadi Talu, Bangalore, rural district, measuring 2 acres, measuring 2 acres ಮೇಲೆ actually, which had fallen to his share in terms of a family partition. That originally this said land was a government land, and that in the year 1960 to 63, in an auction, public auction conducted with the government, the said land was purchased by one Munishamappa, who was the father of the third respondent hearing. The said Munishamappa has sold the said property, which was allotted to Muniappa, who was the vendor of the petitioner, in terms of a deed of sale dated 17/11/1967. The said Muniappa continued to be in peaceful possession and enjoyment of said property. Next para. That during the year 1980-81, original grantee, namely Sri Munishamappa, the father of third respondent, or respondent number 3 as the case may be, had filed a petition alleging violation of provisions of KPTCL Act, Karnataka Prohibition of the System, against Muniappa, which came to be dismissed on the ground that the said grantee did not belong to the scheduled caste or scheduled tribe community, and that there was no violation of any terms of the grant. The said order remained unchallenged and attained finality. What is this? Innoppa Surapayar? Who is that? Innoppa Surapayar ಹಾಕಿದ್ದಾರೆ ಅಂತ? ಅದೇ ಟೈಮ್ ಇನ್ನೊಂದು.
ಅದೇ ಸೇಮ್ ಬ್ರ್ಯಾಂಡ್ ಅಲ್ಲೇ ಇನ್ನೊಂದು
that the said Muniappa had sold the subject property to one Kenchappa in terms of deed of sale dated 8/11/1995. The said Kenchappa is none other than the father of the petition. And subsequently in a family partition between the father of the petitioner and the petitioner, the subject property has been allotted to the share of the petitioner. Hence, he is being in peaceful possession and enjoyment of the property. When things stood thus, the third respondent, son of the original grantee, yet again initiated the proceedings under the provisions of KPTCL Act in case number PTCL SR bracket DEV, close the bracket, 22:2004-2005. And the second respondent hearing, second respondent, Assistant Commissioner, passed the order allowing the said application passed the order dated 22/4/2006, allowing the said application and directed resumption of the land. Agreed with the same, petitioner hearing preferred an appeal before the second respondent in LND.SC.ST bracket A close the bracket 4/2006-7. The first respondent by impugned order and actually dated in a
3rd April 2007.
2007 allowed the said appeal, confirming the order of the Assistant Commissioner. Being agreed with the same petition before this court. Your name? Shri so and so, that council appeal for the petitioner, reiterating the grounds urged in the memorandum of petition submitted. That in the first instance, submitted that the subject property do not fall within the purview of the provisions of Karnataka Scheduled Caste Scheduled Trade Prohibition of the Act, inasmuch as the subject property was purchased by the father of the third respondent in a public auction for a valuable sale, for a valuable consideration.
15 rupees per hectare.
And as such, the said land cannot be termed as a granted land within the meaning of the Act.
And there is no non-alienation clause.
That there was no prohibition for alienation of the land, as no terms of prohibition was imposed. That the said Munisamappa, the original grantee, having unsuccessfully initiated the proceedings in the year 1980, which resulted in rejection as he had failed to prove that he belonged to the community of persons contemplated in the Act, and also he having failed to prove violation of terms of any grant. That the subsequent proceedings initiated by the third respondent in the year 1995 were superfluous, inasmuch as it is settled position of law that once the authority has discharged his function, it becomes functus officio, and the same cannot be re-agitated. On this submission, he seeks for allowing of the petition. On the other hand, Shri so and so, that counsel for the third respondent.
Also, one more condition, there was a delay of 26 years.
So stuff he further submits that apart from the above, mail petition also, apart from the above, counsel petition further submits that even assuming that the petition filed by the third respondent was maintainable, the same is still barred by limitations, as the same has been filed after lapse of 25 years from the date of the first sale. Hence, the
Enactment of the
from the enactment of the Act. Yes. Then HCGP, who HCGP referring to the original records, more particularly the order passed, order dated order dated 4/12/1986, passed in LND SC ST 41/80/81, submits that the earlier proceedings initiated by the original grantee have been rejected in view of failure on the part of the original grantee to prove that the land fell within the purview of the Act. He submits in that view of the matter, subsequent order cannot be sustained. See, so and so, there are counsel for the third respondent, justifying the orders passed by the second and first respondent, submit that what's the submission?
Lord's, my submission is that the land was granted at an upset price. Just and the earlier certificate it was issued. Lord's, those days, Lord's, it was all
Yes,
the same kind of
It submits that the land the subject lands which were granted was against the upset price.
Because the land revenue is around 3 rupees 50
Full stop,
paisa
and
and
that the
the option price is 50.
and that the grant certificate forms were used for all sort of grants. Therefore, mere reading of the grant certificate, it may not be justified to hold that the land was auction land. As regard the order, 1980 was,
So far as the grant certificate also, we referred that the land revenue is 3 rupees 50 paisa and it is.
he further submits
And the
that
auction price is 50 rupees.
he further submits that the reference
Which is
to the
Comparing
revenue,
that, it's an
he
upset
submits
price.
the revenue entries, the value of the revenue mentioned in the grant certificate is 15 times lesser than the value of the property mentioned in the grant order. Therefore, he submits that it was not an auction land and it was a granted land. What about the order? Full stop. Thus he submits that
And
the
further to that, this is covered by the section 4 of the.
therefore he submits that the provisions of section 4 of the act is squarely applicable to the present case and seeks for allowing of the petition.
And covered by the
Covered by what?
rule.
Heard, with the records. At the outset, it is necessary to note that the original grantee, Sri Munisamappa, had initiated the proceedings in case number LND SC SC 41/8081 before the second respondent. The order passed by the second respondent is as under. ಇಲ್ಲಿ flag ಹಾಕಿರ್ತೀನಿ ಅದು ಮೆಮೊ ಎಲ್ಲೆಲ್ಲ ಸೇರ್ಕೊಂಡಿದೆ I hope you will find out this. Happy. Firstly, filed along with memo dated 22. Okay. The said order has admittedly been not questioned or challenged either by the original grantee Munishamappa or his heirs, and the same has attained finality. This aspect of the matter is confirmed by learned SCGP, and the same is not disputed by learned counsel for the respondent number 3. That being the fact, there is considerable force in the submission being made to the learned counsel petitioner that once the respondent number 2 became functus, has passed the order, he became functus officio and ought not to have entertained a subsequent application on the similar cause of action without the earlier order having been reversed or set aside by the higher authority. Good start. Even otherwise, as rightly contended with the petitioner, even otherwise, as rightly contended with the petitioner, the subsequent proceedings initiated by the third respondent, claiming to be the son of original grantee, also not being within the reasonable time from the date of enactment of the act, covered by the judgment of the apex court in the case of Nikanti, the petition, the proceedings could not have been entertained. For the aforesaid reasons, the petition resists to be allowed. The impugned order are set aside. Yes.
Number 993 of 2020.
Huh.
And number 20979 of 2021. There was a 11 years period.
Yes, Nikanti will do. ಅದು ಕೆಲವೊಂದ್ಸಲ harsh ಅನ್ಸುತ್ತೆ, but for a different cause. We know we asked for the date in the morning, 2007. Somewhere you have to put our foot down and do that. Yes. No, you have to do it. You are doing your job.
I'm sorry.
No. No. You are doing your job. We are doing our duty. Yes. Yes.
57.
I am appearing for the respondent number 426, my lord.
ಯಾಕೆ ನೀವೇ ಸಾಕು, ನೀವೇ ಸೀನಿಯರ್ ಹೇಳಿ, ಏನ್ ಮಾಡಿ ಹೇಳಿ. ಗ್ಯಾರಂಟಿ ಏನಾಯ್ತು? 4 ಸೆಂಟೆನ್ಸ್ ಇದರಲ್ಲಿ ತಾವು ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ. 20? ಕೂತ್ಕೊಳ್ಳಿ ಬನ್ನಿ, ಕೂತ್ಕೊಳ್ಳಿ. ಹಾ ಹಾ ಗ್ರಾಂಟಿ ಹೆಸರೇನು? ತಿಮ್ಮಪ್ಪ ಸನ್ ಆಫ್ ತಿಮ್ಮಪ್ಪ. ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಆಲ್ಸೋ ತಿಮ್ಮಪ್ಪ. ಎಸ್. ಪರ್ಚೇಸರ್ ಯಾರು? ಎಸ್.
Respondent number 4 to 6 subsequent purchaser, my lord.
4 to 6 subsequent purchase.
Subsequent purchase.
ಯಾವಾಗ? 1984. No dispute of land being granted land. You admit? ತಾವು ಅಡ್ಮಿಟ್ ಮಾಡ್ತೀರಾ? ಮೆರವಣಿಗೆ ಹೋಗ್ತಾ ಉಂಟು ಹೊರಗಡೆ, ಹೇಳಿ. ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇನಿಷಿಯೇಟ್ ಮಾಡಿದ ಯಾವಾಗ? 84 ಅಲ್ಲಿ. ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಲ್ಲ?
Annexure A, my lord.
Annexure A ನಾ?
Annexure A.
ಹಾ ಎಸ್. ಹಿಂದಿರುಗಿಸಿ ಅಂತ ಆಯ್ತು. ಆಮೇಲೆ ಹಾ same thing what happened to the previous case?
ಫೈನಾಲ್ಟಿ ಆಗಿದೆ. ಆಮೇಲೆ AC ಆರ್ಡರ್ ಮತ್ತು DK ಆರ್ಡರ್ ಆರ್ಡರ್ ಇಲ್ಲ. ಇವರು 2012 ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ರೆ ರೆಸ್ಟೋರ್ ಮಾಡಿ ಅಂತ. ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ರು ದೇರ್ ಇಸ್ ನೋ ಆರ್ಡರ್. ಹಾಗಾಗಿ they have issued endorsement. On the basis of endorsement, they have approached the DC. DC also issued endorsement.
Only a question is an order of data commencement of the act. Particularly only a question is in Annexure B.
Annexure?
B.
Annexure E ಅಲ್ವಾ?
Annexure B.
86 order ಬಿಡಿ. 86 order rightly or wrongly is passed. ಹಾ ಆಯ್ತು, ಅದೆಲ್ಲ ಬಿಟ್ಟು ಕೂಡ ನಿಮಗೆ ಈ 2012 ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್ ಏನು? So that itself is after 26 years.
26 years, 2 days.
2 days. ತಾವೆಲ್ಲ ಯಾವಾಗ ಸೇಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದು?
ಸೇಲ್ ಮಾಡಿದ್ದು ನಾವು
2006, my lord.
1984 ಆದ್ಮೇಲೆ 2006 ಅಲ್ಲ?
26/3/2006 and 29/6/2006.
ಮೂರೇ ಸೇಲ್ ಆಗಿದೆ ಇಲ್ಲಿವರೆಗೆ. ಮೂರೇ ಸೇಲ್ ಆಗಿರೋದು.
ಫಸ್ಟ್ ಸೇಲ್
Total 3 sale deeds.
ಅಪ್ಪ 84 ಒಂದು, 26/3/2006 ಅಲ್ಲಿ ಒಂದು, 29/3/2006 ಅಲ್ಲಿ ಒಂದು. ಸಾರಿ 66 ಅಲ್ಲಿ. ಆಲ್ ರೈಟ್. ಮತ್ತೆ ಇದು ವಾಟ್ ಇಸ್ ಲ್ಯಾಂಡ್ ನೇಚರ್ ಏನಿದೆ?
ಲ್ಯಾಂಡ್ ನೇಚರ್ ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್.
ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಯಾವಾಗ ಆಯ್ತು? 66 ಆದ್ಮೇಲೆ ರೆವಿನ್ಯೂ ಎಂಟ್ರೀಸ್ ಯಾವಾಗ ಆಯ್ತು?
dated 18/9/2015 19/6/2006
1966 ಇಂದ 40 ವರ್ಷ ಎಂಟ್ರಿನೇ ಆಗಿಲ್ವಾ?
I'm purchaser.
You are immediate purchaser. Did you get your name muted immediately? ತಮ್ಮ ಹೆಸರಿಗೆ ಮ್ಯೂಟೇಶನ್ ಯಾವಾಗಾಯ್ತು?
ಅದು ಹೆಸರಿಗೆ 29/5/2006 ಆಗಿರುತ್ತೆ.
Then how will they have the knowledge of the sale? Where is the sale deed? What survey number is mentioned in the sale deed? Whether the same schedule is given in the sale deed?
R4 ಆಗಿದೆ. R4 ಆಗಿದೆ.
R4
ಆಗಿದೆ. ನನ್ನ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿ R4 ಆಗಿದೆ.
You have for respondent number?
LR for R3.
R3. Objection statement ಎಲ್ಲಿದೆ ನಿಮ್ದು? R3 ಅಲ್ವಾ?
ಹೌದು.
ಏನು ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಅದರಲ್ಲಿ?
R4 ಅಂತ.
R4. ಶೆಡ್ಯೂಲ್ ಓದಿ ದಯವಿಟ್ಟು ಅದರಲ್ಲಿ.
ಇದು 5/6 ಆಗಿದೆ.
R4 ಇಲ್ವಲ್ರಿ ಇದರಲ್ಲಿ? Where is annexure R4? R1 and 2 ಇದೆ ಅಷ್ಟೇ.
R4 is RTC.
ಹೌದು ತಾವು. We are asking the sale deed, mister. Where is the sale deed? ಇಲ್ವಾ? Then how do you know 1966 purchase ಮಾಡಿದ್ರೆ ನೀವು ಅಂತ? 1966, after 1966, the first sale has happened 2006. That's why we are asking the sale deeds. If the sale has taken place 2006, read annexure A, annexure B.
For 84/85 dated 29/1/1985. Then the case came up for final hearing on 8/10/85. The respondent was observed ANC was placed in expert. I have heard the argument made by the council for appellate and gone through the records. The land measuring 3 acres in survey number 30/3 of Parvada village in Bandosaka village of Chittoor project granted to the respondent number 1 on offset right during the year 1960-61 with the non-alienation condition of 15 years. But the respondent granted violating the conditions of his land to the appellant on 7/5/1962. The Supreme Court in its judgment dated 1984 has observed that the cases in which lands have been transferred within the prohibition have not attacked the provision of the Karnataka SC Equitable Act 1978. If the transferee perfecting his title over the land as on 1/1/1979, when the act came into force, it is seen from the records that the land has been enjoyed continuously for a period of 2 years by the appellant when the Acts came into force. In the circumstances, the transfer of the land has not become null and void. The appeal is therefore.
Yes. ಏನ್ ಕಾಣಲ್ಲ. Yes, I request the council the petition. This matter finally. Great. For further hearing. For further hearing.
Please, my.
I think even just now I have served on them also. And finally, the office, last night, next week, hearing is just because I'm such of a criminal.
Yes. 2 weeks. They requested the council for the petitioner as well as respondent number 2. Let this matter on. First December.
I appear for petitioner in second petition, my lord. Oh, I have to serve a copy on you also. I give two petitions.
Take only copy iskoli.
Oh, good.
59.
ಏನಪ್ಪಾ ವಾಟ್ ಇಸ್ ಮ್ಯಾಟರ್ ಏನಕ್ಕೆ ವೀಕ್ ಕಂಡೀಷನ್ ಹೇಳಿ ಏನು ಹೇಳಿ ನೋಡು ಲೆಟ್ ಅಸ್ ಸಿ
Seeking for my lord, cycle area 50 to 55%. The approval was made on 2007, my lord. We have rejected that, my lord, because my lord already relinquished to the road and path is relinquished to the local authority, my lord. Now we can't modify that layout. There is a reason, my lord, we have given endorsement that has been.
That is after approval you sought for 55%. ಹೇಗೆ?
And also, my lord, layout is approved on 2007, sir. The contention is, my lord, as per the zonal regulation, 55% can you utilize for the cycle area. But they have filed the application in respect of 50% itself, they will file the application. That is the reason whatever the application made by the petitioner, my lord.
I too, that may be a wrong impression.
Maximum.
When the law provides for 55%, what's the difficulty?
No, my lord, they are not given. Initially, my lord, we have there is no such zonal regulation. As per the BDA.
When was the plan sanctioned?
2007.
Zone regulation September 2007.
This one.
What is the date of plan sanctioning?
2007, 26/7/2007, my lord. Relinquished the cycle areas, sorry, released on 27/2/2008, my lord. Site is relinquished, released from the site. And also, my lord, road and park is relinquished to the authority 26/7/2018. Now, my lord, is seeking for the modification on.
When was the modification application filed? After relinquishment.
Please.
Yes.
This is the main reason, my lord.
Now, this representation is made on 2013.
Please.
When was the relinquishment made?
My lord, I will submit, my lord, memo along with memo, my lord, 23/8/2022, my lord, released on 19/12/2007.
19/12?
Sorry, 18/12/2007. memo ಮಾಡಿದ್ದೀನಿ.
2007 relinquishment ಆವಾಗಲೇ ಆಗಿದೆ.
As per the condition itself, my lord, ಮಾಡಬೇಕಾದ್ರೆ ಅವರು ರಿಲೀಸ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಅಪ್ರೂವಲ್ ಆಗುತ್ತೆ.
Cannot undo everything now. ಎಷ್ಟು ಸೈಟ್ ಮಾರ್ಬಿಟ್ಟಿದ್ದೀರಿ ಇವಾಗ? What is the total number of sites?
Total number of sites is
21 acres, 23 guntas of land. ಎಲ್ಲಿದು? ಯಲಹಂಕ. ಎಲ್ಲಿ ಎಷ್ಟು ಸೈಟ್? Who are you now?
I am the owner of the land.
Now, how do you give effect to the representation, even if it consider ಹೆಂಗ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗುತ್ತೆ? From which portion of the site 5% ಕೊಡಬೇಕು ನಿಮಗೆ? Impossible ಅಲ್ವಾ? ಬರ್ಕೊಡಿ. The request of the petition is this matter next report. Monday. Finally, no more attendance will be given.
Number 60. The PM Sidmalappa.
Lord, yesterday's matter, my lord.
Yes. ಅದನ್ನು ಪಡ ಅಂದ್ರಲ್ಲ ಅದೇ ಅಲ್ವಾ?
ಹೌದು ಸರ್, ಹೌದು.
ಏನಂಗಂದ್ರೆ ವಾಟ್ ಇಸ್ ದ ಮೀನಿಂಗ್ ಆಫ್ ಪಡ?
Lord, in the event of default, Lord, of payment of tax, Lord, the government will forfeit the land. That means, Lord, in the Land Revenue Act, Lord, it is recognized as pada. Lord, the title and everything will not gone to the government until unless, Lord, it is restored. Before restoring, Lord, the property was put in action and it was sold under public action. It was purchased under public action and it was not a grant.
Yes. Whether this contention was raised?
Lord, it was raised and Assistant Commissioner appreciated and he rejects the claim of not the original grantee. Not the original grantee was not the applicant. Lord, the daughter who claims under a will from her father.
Yes.
She sold the property.
This matter was remanded earlier.
Earlier it was remanded.
After the remand, the same order is passed again.
Lord, the Deputy Commissioner reversed the order. Assistant Commissioner order was reversed by the Deputy Commissioner.
That application was resumption rejected by the Assistant Commissioner.
Please, Lord.
Read the DC's order.
Lord, the order.
Paragraph 4. Page 33.
Lord, para 4.
Yes.
ಪ್ರಶ್ನಿತ ಜಮೀನುಗಳ ಬಗ್ಗೆ ಉಪ ವಿಭಾಗಾಧಿಕಾರಿಗಳು ದಾವಣಗೆರೆ ಇವರು ತಮ್ಮ ಆದೇಶದಲ್ಲಿ ಮಂಜೂರಾದ ಜಮೀನು ಸರ್ಕಾರ ಜಮೀನಾಗಿರದೆ ಹಿಡುವಳಿ ಜಮೀನಾಗಿದ್ದು ಸರ್ಕಾರಿ ಪಡ ಆಗಿದ್ದು ನಂತರ ಈ ಜಮೀನನ್ನು ಹರಾಜು ಮೂಲಕ ವಿಲೆ ಮಾಡಿದ್ದು ಈ ಜಮೀನು ದರ್ಖಾಸ್ತ್ ಮಂಜೂರಾಗಿರದೆ ಹಿಡುವಳಿ ಜಮೀನಾಗಿರುವ ಕಾರಣ PTCL ಕಾಯ್ದೆ ಅಡಿಯಲ್ಲಿ ಬಿಡಿಸಿಕೊಡಲು.
ಹಿಡುವಳಿ ಜಮೀನು ಅಂದ್ರೇನು?
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಹಿಡುವಳಿ ಜಮೀನು ಅಂದ್ರೇನು?
That Lord, the land vested with a private person, patta land.
Yes.
ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ತಿರಸ್ಕರಿಸಿ ಪ್ರಾಯಶಃ ಸರ್ಕಾರಿ ಪಡ ಆಗಿರುವ ಜಮೀನು ಸರ್ಕಾರಕ್ಕೆ ಸೇರಿದ ಮೇಲೆ ಅದು ಹಿಡುವಳಿ ಆಗದೆ ಅದು ಸರ್ಕಾರಕ್ಕೆ ಸೇರಿದ ಜಮೀನು ಸ್ವತ್ತು ಎಂಬುದನ್ನು ಸ್ಪಷ್ಟಪಡಿಸದೆ ಅದನ್ನು ಹಿಡುವಳಿ ಎಂದು ವ್ಯಕ್ತಪಡಿಸಿರುವುದು ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸಾಗುವಳಿ ಚೀಟಿಯ 7ನೇ ಷರತ್ತನ್ನು ಸಮರ್ಪಕವಾಗಿ ಪರಿಶೀಲನೆ ಮಾಡದೆ ತಪ್ಪಾಗಿ ಅರ್ಥೈಸಿಕೊಂಡು ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಿರುವ ಆದೇಶವು ಸಮಂಜಸವಾಗಿರುವುದಿಲ್ಲ. That is, Lord, the against Lord, the very Lord, the provision provided. Lord, patta land, Lord, the lack of payment of tax, it vests with it is nothing but a land forfeited by the government.
Yes.
And that land was Lord, if it is Lord granted, Lord, under the terms of Lord Darkas rule, land grant rule, Lord, it can be Lord held that it's a grant. But here, that was not a grant. It was put in public action. The purchaser is not the claims to be the original grantee in the present case.
Where is the auction?
Lord, action, the original records are secured and Lord, it is the order not to be preserved in the Lord, the registry.
All right, we'll secure that.
Please,
Read that.
Lord, the proceedings Lord initiated towards Lord putting the land in public action and Lord subsequent order, including the order of Pada, everything is secured. Lord, that is very clear. It is not a grant. If that records are seen, Lord, certainly, Lord, this honorable court.
Yes, read further. Paragraph 5.
ಪ್ರಸ್ತುತ ಪ್ರಕರಣದ ಬಗ್ಗೆ ಕೆಳ ನ್ಯಾಯಾಲಯದ ಕಡತ ಪರಿಶೀಲಿಸಿದಾಗಿ 3 ಮತ್ತು 6ನೇ ಪ್ರತಿವಾದಿಗಳು ಮಾತ್ರ ಪ್ರತಿಪಾದಿಸಿರುತ್ತಾರೆ. ಈ ನ್ಯಾಯಾಲಯದ ಪ್ರಸ್ತುತ ಮೇಲ್ಮನವಿಯಲ್ಲಿ ಸಹ 3 ಮತ್ತು 6ನೇ ಪ್ರತಿವಾದಿಗಳು ಮಾತ್ರ ಪ್ರತಿಪಾದಿಸುತ್ತೆ. ಉಳಿದ 2, 4, 5 ಮತ್ತು 7 ಪ್ರತಿವಾದಿಗಳಿಗೆ ನೋಟಿಸ್ ಜಾರಿ ಮಾಡಿದ್ದರೂ ಸಹ ವಾದಿಗಳ ಮೇಲ್ಮನವಿಗೆ ಯಾವುದೇ ತಕರಾರು ಆಕ್ಷೇಪಣೆಗಳನ್ನು ಸಲ್ಲಿಸುವಲ್ಲಿ ನಿರಾಸಕ್ತಿ ತೋರಿಸಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಪ್ರತಿವಾದಿಗಳೆಲ್ಲರೂ ಹೊಂದಿರುವ ಕ್ರಯ ವ್ಯವಹಾರಗಳಲ್ಲಿ ಪಿಟಿಸಿಎಲ್ ಕಾಯ್ದೆ 1978 ಕಾಲಂ 4(1) ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದನ್ನು ದರ್ಖಾಸ್ತು ಪುಷ್ಟೀಕರಿಸಿದ್ದು, ವಾರಸುದಾರಿಗೆ ಜಾತಿ ಮತ್ತು ಮಂಜೂರಾತಿ ಬಗ್ಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ಮತ್ತು ಮುಖ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಶಿವಮೊಗ್ಗ ಇವರ ಮೆಮೊವನ್ನು ಕೂಲಂಕುಷವಾಗಿ ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ಯಾವತ್ತೂ ಬರಬಾರೆ ಮಾಡಬಾರದು ಷರತ್ತು ಇದ್ದಾಗ್ಯೂ ಸಹ ಅಲ್ಲದೆ 1990 ನಂತರದ ಅವಧಿಯಲ್ಲಿ ಪಿಟಿಸಿಎಲ್ ಕಾಯ್ದೆ 1978 ನಿಯಮಾವಳಿಗಳ ಬಗ್ಗೆ ಪ್ರಚಲಿತ ವಿದ್ಯಾ ಸಹ ಸರ್ಕಾರದ ಪೂರ್ವಾನುಮತಿ ಪಡೆಯದೆ ಕ್ರಯಕ್ಕೆ ಪಡೆದು ಪಿಟಿಸಿಎಲ್ ಕಾಯ್ದೆ ಉಲ್ಲಂಘನೆ ಮಾಡಿರುವುದು ಸ್ಪಷ್ಟವಾಗಿರುತ್ತದೆ. Lord, he has not even read the papers, Lord, particularly the document pertaining to Lord the proceeding of Patta and Lord subsequent public action. Lord, even he has not gone into Lord the proceeding. Papers were he is the custodian of the document.
Yes.
Lord, arbitrarily, Lord, he Lord assumes things as that it's a grant. He has not even apprised the reasoning, Lord, of the Assistant Commissioner.
Yes, let him do it once again.
Lord, Lord, I produced, Lord.
He takes note para 4. Why does he answer para 4?
Government land. ಸರ್ಕಾರಿ ಬಂತು ಅಂತ ಇಟ್ ಇಸ್ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್. ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ SC/ST ಗ್ರಾಂಟ್ ಮಾಡೋದಿಲ್ಲ. ಇಟ್ಸ್ ಬಿಕಾಸ್ ಆಫ್ ದಿ ಕಮ್ಸ್ ಅಂಡರ್ ದ ಪಿಟಿಸಿಎಲ್ ಆಕ್ಟ್. 23 ಇದರಲ್ಲಿ ಅನೆಕ್ಷರ್ 6 ನಲ್ಲಿ ಹಿಡುವಳಿ ಇಲ್ಲದ ಸರ್ಕಾರಿ ಜಮೀನನ್ನು ಸಾಗುವಳಿಗಾಗಿ ವಿಲೇವಾರಿ ಮಾಡಿ ಅವುಗಳ ಅನುಭವದ ಹಕ್ಕನ್ನು ನಿಮ್ನ ತರಗತಿಯ ಜನರಿಗೆ ಕೊಡುವುದಾಗಿ ಈ ಸರ್ಟಿಫಿಕೇಟ್ ಮಾತ್ರ ಇಶ್ಯೂಡ್. 23 ಅನೆಕ್ಷರ್ 6 ಇಟ್ ಇಸ್ ಫ್ರೀ ಗ್ರಾಂಟ್. No, that was upside clause.
No, you, one second, you said that land was taken over with the government for non-payment of land revenue.
Land revenue. Lord, so it was perpetrated and put in public action.
What happened? Public action tell there.
Action proceedings so it's record secure agide.
Annexure R2 is the certificate.
No, it is not the certificate, Lord. The proceedings is there with regard to public action. Lord, Kimmat was paid.
Yes.
The action price was paid, and after paying up action price, Saguli cheat was issued. It amounts to a sale by the government. It is not a grant. And Lord, I submitted, Lord, one judgment of this honorable court. Lord, reported in year 2008 SC 1438.
ನೋಡಿ ಅದು ರೆಫರೆನ್ಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಇದೆಯಾ? ನೋಡಿ ಯಾವುದು ಜಡ್ಜ್ಮೆಂಟ್?
Lord, in the case of BK Muniraju versus State of Karnataka.
ಇಲ್ವಲ್ಲ ಯಾವ್ದಿಲ್ಲಿ? No such judgment. ಇದೆಯಾ? ಅವ್ರು ಹೇಳಿ ನೋಡ ಇರಿ ಅವ್ರಿ ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್ ಸಿದ್ಮಲ್ಲಪ್ಪನವರೇ ಇಲ್ವಲ್ಲ ಜಜ್ಮೆಂಟ್ ಅದು?
Or otherwise, my Lord, another judgment, my Lord, Dhanalakshmi versus State of Karnataka. I have given, my Lord, two copy.
ಯಾರು ಕೇಳ್ಕೊಟ್ರಪ್ಪ?
Last hearing date ಅಲ್ಲಿ submit ಮಾಡಿ.
ಹೇಳಿ. Yes, part.
Please, my Lord. Lord, para 9, Lord, Lord, in the judgment of Dhanalakshmi versus State of Karnataka.
No.
Para 9. Here
Yes.
in this case, land has been granted by way of public action on upset price, which came to be reduced. Subsequently, that cannot be considered to be considered to treat the land as a granted land to the person belongs to the scheduled caste or scheduled tribe for bringing the same within the meaning of section 3(1)(b) of PTCL Act. Such being the case, the authorities have no power to impose any condition of non-alienation of either 15 years or 10 years. Once the land has, does not fall under the provisions of PTCL Act, the question of restoring the land in question in favor of the legal representatives of the purchaser does not arise. Does not arise. By considering the document on record, after receipt of the report of the Tahsildar, the Assistant Commissioner rightly rejected the application filed by the legal representatives of the alleged grantee once in the year 2003, thereafter for the second time in the year 2008, and once again in the year 2014, without considering the same. The Deputy Commissioner allowed the appeal of the action purchaser only on the ground that the land which was granted to the grantee belongs to the land granted to people belongs to scheduled caste and scheduled tribe community. Even the legal representatives have not produced any document to show that grantee belongs to scheduled caste or scheduled tribe community as on the date of action purchase. Therefore, considering this aspect, the order under challenge is not sustainable.
They belong to the particular community even on the day of auction, if it is held to be.
No, even otherwise also, Lord, it can't be. Because he could not stand as that Lord of a grantee under the land grant rules. He is supposed to be recognized as a purchaser under public action. Meaning of grant, Lord, it will not, it could not be extended to action purchaser. That is the finding, Lord. Ultimately, Lord, the order of the Deputy Commissioner is Lord set aside in this particular.
Your case is that it was land seized, forfeited,
and
for,
Lord, what it was put in action
for non-payment of land revenue.
Land revenue. Lord, that provides.
Yes. And then was put in auction.
It was put in action.
When was the auction conducted?
Lord, the action was, Lord, it refers, Lord, in the order of the Assistant Commissioner, refers to 42, 43, 5 to 1942. 5 to 1942.
The auction itself was conducted in the year 1942.
Please, my Lord. Lord, I given, my Lord, synopsis. Lord, after 1942, Lord, the claim of Lord contesting respondent is that her father executed a will in her favor. Based on the will, she got property.
The auction purchaser is Maria.
Maria, Lord, who in turn, Lord, claims to be, Lord, executed a will in favor of his daughter.
Yes.
Daughter claims that she is a beneficiary under the will, under a testamentary right. She can't be, Lord, grantee again. The character of Lord grant also ceases. Nature of grant, Lord, if it is granted land, it ceases because of Lord transfer of title under a testamentary right. In the capacity of Lord acquiring title and position under the will, she conveys property. In this sale deeds also, she has stated that she got the property, title over the property under the will.
Is there a prohibition for bequeathing property by will?
No, I am not saying that. Lord, nature of acquisition of title. It is not the original grantee seeking Lord benefit under the provision.
He executes a will in favor of his legal representative or somebody, Does the land lose the character of a grant?
Lord, the independent right accrued to her, Lord, under the will. Under a testamental right, she will
Which means only if it is then testament rights are there, it don't remain as a granted land.
the characteristic of the land, she can't be a original grantee.
Of course, she can't be original grantee.
That's all the thing. Just I want to make clear.
Oh, so that does it take away from the purview of the act? Otherwise,
no. I am not saying that. I am not saying that.
Then,
Lord, as because Lord, it is a grant. It is not a grant, and it is put under a public action.
It's not a grant. You still have to make out a case that it's not a grant.
Lord, the records are secured. If records are seen, Lord, the record itself.
You have the copies of the record.
ಇಲ್ಲ ಅದು ಏನಾಯ್ತು ಸೇಫ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದೆ ಸೇಫ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದೆ ನನಗೂ ರೆಕಾರ್ಡ್ ಸಿಕ್ಲಿಲ್ಲ ಅದು ರೆಕಾರ್ಡ್ ಕಾಲ್ ಫಾರ್ ಆಯ್ತು
ಬೇಕಾದಾಗ ಸಿಗಲ್ಲ ಅಷ್ಟು ಸೇಫ್ ಆಗಿಬಿಡ್ತದೆ ಅದು
ಅಲ್ಲ ಅದು ಆರ್ಡರ್ ಇದೆ ಈ ಕೇಸಲ್ಲಿ ಆರ್ಡರ್ ಇದೆ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕೆಪ್ಟ್ ಇನ್
If you have seen that, please tell us. We will take note of your submission.
Lord, my submission is, Lord, the proceeding in file number CP number 638/1933-34, Lord, the Pada proceedings was taken place, and the land was forfeited for the default of payment of land revenue, and revenue record stand Lord entered as land Pada.
Yes.
Lord, the owner's property was Lord, name of owner Lord, was deleted, removed, and name of government and nature of Lord holding as that of Pada.
Yes.
Then Lord, the proceedings, Lord, action sale under a file number 96/1942-43. dated 5/2/1942, it was put under public action. Publics were participated. Ultimately, Lord, the Muniga, Lord, who stands, Lord, the highest bidder, and land was, Lord, action is confirmed, action sale is confirmed, and Saguli cheat was issued in his name. That is the records which reveals that. And Lord, in the Saguli cheat issue, it is not stated as that of a land granted under the grant rules. Saguli cheat is also clear. But Lord, it is a printed form where Lord, printed content say non-alienation clause prohibited forever. It was a printed format. For that reason, that printed form contents or a condition find therein could not be taken into consideration as because it was put in action and action purchaser, there could not be any prohibition for alienation.
Yes. Anything else?
Please, Malab.
Annexure.
ಇಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಅದು things they have produced Lord out of manipulation. For that reason only this honorable court Lord order to secure original record.
Idmanre document ಸಿಕ್ಕಿಲ್ಲ ನಮ್ಗೆ ಇನ್ನು which annexure R1 ಯಾವ್ದ್ರಲ್ಲಿ? When did you file? When is the auction procedure?
2014.
Yes. One ನಿಮಿಷ. Auction proceedings 1940. AC. ಎಲ್ಲಿ ದಟ್ ಆಕ್ಷನ್ ರೆಫರೆನ್ಸ್ ಎಲ್ಲಿದೆ ಯಾವ ಫೈಲ್ ಅಲ್ಲಿ ಇದೆ ಪಬ್ಲಿಕ್ ಆಕ್ಷನ್ ರೆಫರೆನ್ಸ್
there is a master and my lord, all other proceedings taken place for action, all is recorded, my lord. The revenue inspector who records the master.
who will assist?
My lord, page number 27, my lord. Of the assistant commissioner, it is mentioned as Haraj file number 688 of
Page number 27 of what?
27 of the assistant commissioner order annexed D, my lord. ಅದರಲ್ಲಿ my lord, here it is, my lord, PTCL ಕಾಯ್ದೆಯ ಅಡಿಯಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವಂತೆ ವಿಚಾರಣೆ ನಡೆಸಿ ದಿನಾಂಕ 23/2/2006 ಹಿಂಬರಹ ನೀಡಲಾಗಿದ್ದು, ಸದರಿ ಹಿಂಬರಹದಲ್ಲಿ ಭೂ ಕಂದಾಯ ಹರಾಜು ಫೈಲು ಸಂಖ್ಯೆ 688 of 2003 ಸರ್ಕಾರಿ ಪಡಾದ ನಂತರ ಅಪೀಲುದಾರರು ತಂದೆಗೆ 47-43 ಸಾಲಿನ ಬಂದಿದ್ದು, ಇದು PTCL ಕಾಯ್ದೆಯಲ್ಲಿ ಬರುವುದಿಲ್ಲ ಎಂದು ಉಪಾಧ್ಯಾಧಿಕಾರಿಗಳು ನೀಡಿರುವ ಹಿಂಬರಹ ವಿರುದ್ಧ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳವರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ PTCL CR 3/2006-7/2007 ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅರ್ಜಿದಾರರು ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಲಾಗಿರುತ್ತದೆ. ನಂತರ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಪ್ರಶ್ನೆ ಮಾಡಿದ್ದು, ಸದರಿ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಿನಾಂಕ 14/3/2008 ಮರು ವಿಚಾರಣೆಗೆ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಆದೇಶಿಸಲಾಗಿದೆ. ಅದರಂತೆ ವಿಚಾರಣೆ ನಡೆಸಿ ಹಿಡುವಳಿ ಜಮೀನು ಭೂ ಕಂದಾಯದ ಬಾಕಿ ಸರ್ಕಾರ ಪಡ ಆಗಿದ್ದು, ಈ ಜಮೀನು ಹರಾಜು ಮೂಲಕ ವಿಲೇವಾರಿ ಮಾಡಿರುವುದರಿಂದ PTCL ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದಿಲ್ಲ ಎಂದು ಆದೇಶಿಸಿದ್ದು, ಈ ಕುರಿತಂತೆ ಕರ್ನಾಟಕ ಲಾ ಜನರಲ್ 1996 334 ILR ಕೇಳಿ ಪ್ರಕರಣ 59 ಪ್ರಕರಣಗಳು ಅನ್ವಯಿಸುತ್ತಿದ್ದು, ಸದರಿ ತೀರ್ಪುಗಳ ಅನ್ವಯ ಪ್ರಶ್ನಿತ ಜಮೀನು ಹರಾಜು ಮೂಲಕ ವಿಲೇವಾರಿಯಾದ ಜಮೀನುವಾಗಿದ್ದು, PTCL ವ್ಯಾಪ್ತಿ ಅಡಿಯಲ್ಲಿ ಬರುವುದಿಲ್ಲವೆಂದು ಅರ್ಜಿದಾರರ ಅರ್ಜಿಯನ್ನು ವಜಾ ಮಾಡಲು ಕೋರಿಕೊಂಡಿರುತ್ತಾರೆ. ಅರ್ಜಿದಾರರು ದಿನಾಂಕ 24/6/2013 ಲಿಖಿತವಾದ ಮಂಡಿಸಿದ್ದು, ಅದರ ಮುಖ್ಯ ಅಂಶಗಳು ಏನೆಂದರೆ, ಮಲ್ಲಿಗೆರೆ ಗ್ರಾಮದ 45 P 3 ಎಕರೆ 7 ಗುಂಟೆ ಎಕರೆ ಸರ್ವೆ ನಂಬರ್ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮರು ವಿಚಾರಣೆ ಮಾಡಿ ನೀಡಲು ಆದೇಶಿಸಿದ್ದು, ಸದರಿ ಜಮೀನುಗಳ ಅರ್ಜಿದಾರರ ತಂದೆಯ ಮರಿಯ ದುರ್ಗ ಇವರಿಗೆ DD ಸಂಖ್ಯೆ 14-40-41 ಸಾಗುವಳಿ ಚೀಟಿ ಸಂಖ್ಯೆ 96-42-43 ಸಾಗುವಳಿಗೆ ನೀಡಿದಂತ ಸ್ವತ್ತಾಗಿದ್ದು, ಈ ಜಮೀನು ಮೂಲತಃ ಸರ್ವೆ ನಂಬರ್ 11/2 ಆಗಿದ್ದು, ನಂತರ ಕೋಡ್ ದುರಸ್ತಿಯಾಗಿ ಹೊಸ ನಂಬರ್ 45 ಎಂಬುದಾಗಿದ್ದು, ಈ ಜಮೀನು ಎಂದೆಂದಿಗೂ ಪರಾರಿ ಮಾಡಬಾರದು ಎಂದು ಷರತ್ತಿನ ಅವಧಿಯಲ್ಲಿ ಸರ್ಕಾರದಿಂದ ಮಂಜೂರಾದ ಜಮೀನಾಗಿರುತ್ತದೆ. ಈ ಜಮೀನನ್ನು ಅಪೀಲುದಾರರು ತಂದೆ ತಮ್ಮ ಜೀವಿತ ಅವಧಿಯಲ್ಲಿ ಅನುಭವಿಸಿಕೊಂಡು ಬಂದಿದ್ದು, ಅವರು ನಂತರ ಅರ್ಜಿದಾರರಿಗೆ ಮರಣ ಶಾಸನ ಪತ್ರವನ್ನು ಬರೆದಿದ್ದು, ಅದರಂತೆ ಖಾತಾ ಮತ್ತು ಪಹಣಿ ಬದಲಾವಣೆಯಾಗಿದ್ದು, ಮೊದಲು SR ನಂಬರ್ 1126 of 93-94 ದಿನಾಂಕ 29/9/19.
So he also admits it was a no, but read that page 3 ಅರ್ಜಿದ 24/6 ಲಿಖಿತವಾದ ಮಂಡಿಸಿದ್ದು, ಅದರ ಮುಖ್ಯಾಂಶ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅವ್ರದ್ದು. Where is the finding? All argument.
Yes, ma'am.
Lord, para 4, Lord, page 4.
Next ಸರ್ಕಾರಿ ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ಆದ್ಮೇಲೆ ಈಗ the government has allotted the land to the depressed classes on a big land. ಅದೇ annexure R1 ಪ್ರಕಾರ ಈ ಮೆಮೊದಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳ್ತಾರೆ ಇದು 3 grand ಅಂತ. R1 ಮೇಲೆ of my statement of objection. As recommended, sanction is accorded to the 3 grant of 5 acres of land each under requested class rules, subject to condition of non-admission at any time. This 3 grant as per the order. On that basis, annexed R2
ಯಾರಿಗಾಗಿದೆ ಇದು free grant? Where is the name of the person to whom it is granted? What is the extent of land?
Bhadravati subdivision, I put copy page number 8. Bhadravati subdivision officer's memo, so and so, dated 5/1/1942, recommending the free grant of land, such of described in the margin survey number 11 of Mandigere village, Karnataka, Changiri Taluk. Total is 12 acres 31 guddas, 7 guddas Kuttara. Remaining extended 12 acres 24 guddas. To the 2 landless and depressive class applicants with Mariappa, with Durgappa and Ramappa in Sanna Hanumanna, residents of the village. This land was allotted on 3 land. On that basis, Sagodi is also issued and
Yes, have you seen annexure R1, Mr. Council?
Please, Manoj.
ಅದ್ರಲ್ಲಿ ಕ್ಲೀನ್ ಆಗಿ ಹೇಳಿದಾರಲ್ಲ ಅದು.
ಇಲ್ಲ, it refers to not to the person Maria, not it refers to not the other person.
Which person? ಯಾರಿಗೆ? Whom does it refer to, sir?
Lord, this proceeding is the proceedings of not the deputy commissioner. Lord, that is contrary to the records, Lord, now secured by this honorable.
Nodi, then record. What do you want us to see?
Lord, my submission, Lord, once, Lord, the land perpetuated to the government for laches of Lord non-payment of tax.
Heli.
Lord, then Lord, putting Lord the land in public action, that cannot be recognized as a grant made under the grant clause. That is my submission.
Correct. My submission should be supported with the document, Mr. Council. We are requesting the document.
Lord, the assistant
There are
commissioner.
no documents. You are going on arguing for the 3 days on the same point. We are only requesting the complete.
Lord, your Lordship may kindly see, Lord, annexure R2, Sagoli cheat they have produced. There is no prohibition as such prohibiting Lord the alienation of the land. Not that the last line, Lord of internal page 2. ಜಮೀನನ್ನು ಡ್ಯಾಶ್ ಕಾಲ ಪರಭಾರೆ ಮಾಡತಕ್ಕದ್ದಲ್ಲ. ಅಲ್ಲಿ ಎಷ್ಟು ಇಯರ್ ಅನ್ನೋದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿದ್ದಾರೆ, ಅಲ್ಲಿ ಅಥಾರಿಟಿ ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವುದು? where is it written?
annexure R2 ದಲ್ಲಿ Sagodi ಸಿಗ್ತದೆ.
R2
Error number 8 ಅಲ್ಲಿ ಈ ಜಮೀನನ್ನು ಕ್ಯಾಶ್ ಹೊಡೆದಾಕಿದ್ದಾರೆ. ಡಿಲೀಟ್ ಅದರಲ್ಲಿ ಕಂಡೀಷನ್ ಯಾವಾಗಲೂ ಮಾಡಬಾರ್ದು.
No, Mr. Council, we are not able to follow your submission. Sorry, but merely reading para 8, can you say it's auction property?
No, regarding action, Lord, I have to appear before physically, Lord, before this honorable court, and with reference to Lord the record secured, I can convince Lord, because that record is clearly revealing. Because we were not permitted to take the certified copy of those records, because the day when the records were secured, it was kept under Lord.
Was executed after the act came to form.
ಇದು ಹೀಗೆ ಮಾಡಿದ್ರೆ ಪ್ರಯೋಜನ ಇಲ್ಲ ಸರ್. We are not here to meet your anxiety. He is making submission. We are trying to understand what submission is making. He is making submission without benefit of the documents. In the ಮಧ್ಯದಲ್ಲಿ ನೀವು ಬಂದ್ಬಿಟ್ಟು ಏನೋ ಹೇಳಿದ್ರೆ ಏನು? What is this? Maintain some decorum. SCGP, he's saying that there was forfeiture of this property in the year 1932 because of non-payment of revenue. So therefore, this land is considered as a Pada land. And once the land has become the government's land, it was put into auction, it was not granted. That's a simple argument. And he has no document to show that. He says this is there in those documents. Please point out from the documents. Yes. ಇದನ್ನ 5 ದಿನದಿಂದ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅವರು. Next year, R1 server number really there. Where is server number in R1? Huh? This is landing server number.
Original number 11, new number 45.
Landing server number 11 of Malaysia village. That's how
ಯಾವ್ದು ಓದ್ತಿದ್ದೀರಾ ಎಲ್ಲಿ ಓದ್ತಿದ್ದೀರಾ
first fourth letter. Margin 711 of Malaysia village. That's how measuring for letter 31 meter.
server number 11 is the ಮೊದಲಿಂದಾನು.
Earlier it was 11, now 45.
Grant ಅಲ್ಲಿ ಏನು ಕೊಟ್ಟಿದ್ದಾರೆ ನಂಬರ್?
Grant ಅಲ್ಲಿ 11/2. 11/1 now it is 11/2. Page number 11.
Yes, you said that's a different Mariappa. How do you say it's a different Mariappa?
Lord, the present case, Lord, refers to Maria.
You are relying upon annexure R2.
Maria, son of Durga.
You are referring to, you are relying upon annexure R2.
Lord, R2, Lord, refers to the name. I can read, Lord.
Yes, Maria bin Durga.
Maria bin Durga.
Now go to R1. Mariappa bin Durgappa.
Please.
Then how do you saying it is not applicable? That's a different Maria.
Lord, can I read, Lord, the entire document?
ಯಾವ document, sir?
R1, Lord.
ಓದಿ sir, ಓದಿ.
Bhadravati Subdivision Office memo number dated 5/1/42 recommending the free grant of land, each of described in the margin, survey number 11 of Malligere village, Kaspa, Channagiri Taluk. To the two landless and depressed class applicants, Maria bin Durgappa and Ramappa bin Sanna Banumanna, resident of Diggenahalli village. Lord, our proceedings is not, Lord, of this particular reference. Ours is the proceeding where, Lord, there was no such Darkat proceeding. My request, Lord, my case is, Lord, it is the land originally vested Pattadar and Lord Idolidar, and lack of non-payment of tax, Lord, it was forfeited to government.
Really?
For that reason, Lord, what the translation they had,
the original
Lord, it is not
record,
correct.
original records refers to election R1.
R1 continuation is contrary. In other proceedings, record says something else than this particular annexure R1.
We have records in front of us, sir. It's saying the same.
Please, Lord. Lord, the ಅಲ್ಲ ತಾವು ನನಗೆ ಒಂದು ಪರ್ಮಿಷನ್ ಕೊಟ್ರೆ ರೆಕಾರ್ಡ್ ನೋಡಿ ತಮಗೆ ಆ ಪೇಜಿನೇಷನ್ ಕ್ಲೀನ್ ಆಗಿ ರೆಕಾರ್ಡ್ ನ ಓದ್ಲಿಕ್ಕೆ ನನಗೆ ಅವಕಾಶ ಆಗ್ಬೋದು ಅಂತ. ಯಾಕಂದ್ರೆ ನನಗೆ ಇಲ್ಲಿವರೆಗೂ ಆ ರೆಕಾರ್ಡ್ ನೋಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಇಲ್ಲ. ಅದು ರೆಕಾರ್ಡ್ ಓನ್ಲಿ ಫಾರ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ದಟ್ ವಾಸ್ ಸೆಕ್ಯೂರ್ಡ್.
ಬರಬೇಕಿತ್ತಲ್ಲ ಸರ್ ಕೋರ್ಟಿಗೆ. ಹೌ ಮೆನಿ ಟೈಮ್ಸ್ ಶುಡ್ ಬಿ ಅಡ್ರೆಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಹೇಳಿ?
ಇಲ್ಲ ಅದು ರೆಕಾರ್ಡ್ ಇವತ್ತೇ ಸೆಕ್ಯೂರ್ ಆಗಿದೆ.
The matter you must be sure that consent to the case as well.
ಇಲ್ಲ ನನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಇಷ್ಟೇ, ಅದು ರೆಕಾರ್ಡ್ ಸೆಕ್ಯೂರ್ ಆದ್ಮೇಲೆ ಅದನ್ನ ಸೇಫ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇಟ್ಬಿಟ್ರು, ಅಲ್ಲಿಂದ ಈಚೆಗೆ ನಾನು ನೋಡ್ಲಿಕ್ಕೆ ಅವಕಾಶ ಇಲ್ಲ.
ಯಾವಾಗ ಬರ್ತೀರಿ ಹೇಳಿ?
ಮಂಡೇ ತಾವು ಫಿಸಿಕಲ್ ಅಪಿಯರೆನ್ಸ್ ಗೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ರು ನಾನು ಬರ್ತೀನಿ.
ಅವಕಾಶ ಏನು? ತಮ್ಮ ಅಧಿಕಾರ ಅದು.
ಇಲ್ಲ ಅದೇನಿಲ್ಲ. ಅಲ್ಲ ತಾವು ಅದ್ರ ಬಗ್ಗೆ
we asked you, ಅವತ್ತೇ ಕೇಳ್ದ ನಿಮಗೆ. You were there other day, you had come to the court.
ಇಲ್ಲ ಅದೇ ನನಗೆ ಸ್ವಲ್ಪ ಫಿಸಿಕಲ್
well therefore you cannot come, but we saw you in the court other day.
health actually not
we understand, but you were there other day in the court.
ಇಲ್ಲ ನಾನು ಬರ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ, ಇಲ್ಲಿವರೆಗೂ ಬರ್ಲಿಕ್ಕೆ ಆಗಿಲ್ಲ.
ಆದ್ರೆ ಯಾವಾಗ ಬರ್ತೀರಾ ತಾವು?
ಮಂಡೇ ಅಥವಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಯಾವಾಗಾದ್ರೂ
ಬೇಡ, ಮಂಡೇ ಬನ್ನಿ. ಮರ್ತೋಗುತ್ತೆ ಇದು, ಪಡ ಕೈಗೆ ಸಿಗಲ್ಲ.
ಇಲ್ಲ,
with great difficulty we have grappled that word pada.
That's right.
Yes. That counts for the petitioner who is appearing through virtual mode. Submits that he would come and address further arguments physically, referring the original records which are kept in safe custody of this court. List this matter on 21st. Seal this original records and keep back in safe custody and produce next set of hearings. See market put
ನನಗೆ ಮಂಡೇ ರೆಕಾರ್ಡ್ ನೋಡ್ಲಿಕ್ಕೆ ರೀಚ್ ಆಗೋಕ್ಕಿಂತ ಮುಂಚೆ ರೆಕಾರ್ಡ್ ನೋಡ್ಲಿಕ್ಕೆ
ಬೆಳಿಗ್ಗೆ ಹೇಳ್ಬಿಡಿ, ಕಳಿಸ್ಬಿಡ್ತೀವಿ. Yes,
please.
2:30 your matter is Monday. List this matter 2:30. 2:30. Yes, thanks.
Petitioner is no more, madam. Petitioner is no more.
This for the village. The village is not complete.
Response for the respondent files memo reporting death of the petitioner of he having died about 2 years ago. Counsel for the petitioner seeks 2 weeks accommodation to do the need. List this matter on. Memo copy ತಗೊಂಡಿದ್ದೀರಾ? Next time ಒಂದು ಕಾಪಿ ಸಿಕ್ಕಿಲ್ಲ ಅಂದ್ಬಿಟ್ರೆ ಕಷ್ಟ. Yes.
60. I know.
My lord, I appear for the petitioner, my lord. My lord, on the last occasion, your lordship had directed learned government advocate, my lord, to secure the records. If my submission is correct, my lord. If the records have come, my lord, your lordship may kindly have this on Monday.
Records have come, Mr. Narayan Bhatt.
Then your lordship may kindly have this next week, my lord. I will physically come and argue.
Learned HCGP submits that the records have been secured as directable court on 2/11/2022. Sri Narayan Bhatt and counsel the petitioner seeks weeks accommodation to address the argument. 25th.
Please, my lord. Please.
63. Prakash Tiyappa.
You're filing objections for main petition.
And also I filed application.
At the request of the council for the Shri Taver Tamesru. You're not Prakash Hebbar, no? And we asking the name. Tamma Hesru is there. Sri Kiran, that council appearing for Prakash is for the petitioner. Tamesru?
Yes, sir.
Si Ahmed, that counts for the respondent 4. SCGP 1 2 3. Shri S. Ahmed, that counts for the respondent 4 seats. 2 weeks accommodation.
Objection copy.
To file objection to the main petition and to the IA.
Filed in copy as well.
Yes. Copy receive ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ? Objection copies. Yes. He submits and served the copy of the objection statement to the petitioner council. He seeks time to file objection to IA. This matter.
6th December.
Interim order. ಇಲ್ಲಲ್ಲಪ್ಪ interim order extend ಆಗಿಲ್ವಲ್ಲ? ಯಾವಾಗಿದೆ ಇಂಟರ್ನೆಟ್ ಆರ್ಡರ್? ಇವುಗಳು ತಲೆನೇ ಹಾಕಿಲ್ಲ ಈ ಕಡೆಗೆ. Last matter is extended on April 2021. ಅದರ ನಂತರ ಆಗಿಲ್ಲ. ಅಕ್ಟೋಬರ್ ಬಂತು ಮ್ಯಾಟರ್ ಆಗಿಲ್ಲ. ಇವತ್ತು ಬಂದಿಲ್ಲ ಮ್ಯಾಟರ್ ಆಗಿಲ್ಲ. Interim order granted earlier, extended till next of hearing. Yes.